One, start.
Good afternoon, everyone. We welcome all of you to the final rounds of the 6th Symbiosis Law School Pune International Criminal Trial Advocacy Competition 2021. It's been indeed a pleasure for all of us to conduct this event, and I hope it's a joyful ride for all of you to be a part of this event, not just in the form of a participant, but also in the form of an observer or a spectator. I request all the witnesses, every single one present in the meeting, to not the witnesses, every single one present in the meeting to keep their cameras and mics off so that there is no disturbance for the participants. The teams that have qualified for the final rounds are team called SLS underscore 05, team called SLS underscore 07, team called SLS underscore 06. SLS underscore 07 is the prosecutor in this particular round. SLS underscore 05 is the defense in this particular round, and SLS underscore 06 is the victim in this particular round. The judges here are, we have a panel of 4 judges. However, one of the judges will be leaving shortly. She's here to grace us all in this august moment for the final rounds. I request all of you to please enjoy thoroughly and please let us know of the feedback. I congratulate all the teams who have participated, and especially the teams who made it to the finals. The last 2 days have been really hectic for all of us, and I really appreciate the patience that has been shown by the teams, by the participants, and by everyone else included. Now we declare the final rounds open. Thank you. Harita, if you can please ask them to start with the rounds.
Yes, Chamber Masters, please start noting the time, and the meeting is being recorded.
Is the council audible and visible? May it please the court, the prosecutor would like to start. May it please the court, the prosecutor would like to address the judges collectively as Your Honors. A very good afternoon, President, Your Honors, the legal representatives, and the defense counsels. In the case of the prosecutor versus Umberto Eco for the crime against humanity of murder under Article 7, Paragraph 1, Clause A of the Rome Statute, we represent the office of the prosecutor. I'm the speaker one, and I'll be making the opening statement and doing examination in chief of the witnesses, and I'm being assisted by my co-counsel, who will do the cross-examination of the witnesses and make the closing statement. Your Honors, the present case relates to the crimes against humanity of murder committed by Steiner administration on the civilians of Titan under the garb of its anti-drug war. The accused in the present case is Mr. Umberto Eco, one of the members of judicial infrastructure of Titan, who worked during the period of commission of crimes as chief judge of the Anti-Drug Authority Tribunal. Your Honors, he is believed to have been involved in the crime as an accessory to President Steiner, the main perpetrator. He has participated in the persecution of civilian population of Titan by illegal use of his office and influence as a part of Steiner campaign. He has intentionally influenced the prosecution of victims towards maximum penalty and denial of rights at his own disposal. Furthermore, Your Honors,
you right at the beginning. Very sorry, if I may.
Indeed,
you said the main person behind all this is Mr. Steiner, former President Steiner. Is he an accused? And if no, why no?
Indeed, Your Honor, he's not the accused in the present case because he has been given amnesty by the current government of Titan.
So you don't want to prosecute the person who had the scheme because he's been given amnesty, and you want us to prosecute, to quote unquote, from the compromise scapegoat?
Indeed, Your Honor. However, Your Honor, the accused in the
Sorry, you said indeed for the scapegoat.
Indeed not, Your Honor. Your Honor, in the present case, the accused was actually involved in the commission of the crimes against humanity of murder and as being a willing accessory to President Steiner. And in accordance with Article 25, Paragraph 3
Sorry, if I've understood you rightly, very sorry to interrupt you again. If I've understood you rightly, you're saying he's a willing accessory, quote unquote.
Indeed, Your Honor.
Right? So if you're using the words accessory, you imply there has to be something substantive because he's an accessory subsidiary. And you're
Indeed, Your
saying
Honor.
the main person is out of question, but you still want to prosecute the accessory. I'm a bit concerned about the way in which the prosecutor has approached the case.
Your Honor, in the present case, the main perpetrator has actually gone up, has been given amnesty, and he's out of the jurisdiction of this honorable court by fleeing to China. So, however, in the present case, we cannot let this crime against humanity be as it is. We have to prosecute it. We have to give justice to victims and lay down for the whole humanity that these crimes against humanity of murder shouldn't be committed in the near future.
I'm not very much convinced by your ideological argument. I don't like ideological arguments in courts, but in any event, since you've raised it, are you suggesting that because main accused has fled, so you just want somebody to be prosecuted and then you want us to uphold that? And it's not that we haven't, the ICC hasn't pursued people. We are still pursuing al-Bashir. You could have initiated investigations against him. You could have asked us to pursue him. You didn't ask any of that. It looks a very lopsided investigation.
Indeed, Your Honor. However, the accused, and it's not just the accused in the present case who is being prosecuted. There are other 11 individuals who are being prosecuted before this honorable court in different cases. And therefore, the moment this honorable court or the prosecutor, ICC prosecutor, is able to get hold of Mr. President Steiner, then he'll also be brought back to this honorable court to decide upon his case as well.
And what are the nature of offenses of those other 11 people whom you've also arraigned as accused in different proceedings?
Indeed, Your Honor. Your Honor, they are mainly charged as an willing accessory to President Steiner, just the way the accused in the present case.
But in a similar judicial context or otherwise? I see Judge Kadam also wants to say something, but you may respond to me and maybe take a question from him.
Not at this moment, maybe little later.
Indeed, Your Honor. Your Honor, the prosecutor would like to move forward. Your Honor, the office requested the court to refer to the facts as and when required on pages 14.
I'm very sorry. I asked you a question and you want to move forward. I asked you what are the nature of offenses in relation to other accused persons. Are they also judicial officers?
Your Honors, they are the administrators who were committing crimes in association with the President Steiner. They are from the various departments, including the judicial officers as well.
Now you may proceed.
All right. Your Honors, the office may request the court to refer to the facts as and when required on pages 14 to 18 of the written submission on behalf of prosecution. The prosecution shall rely on such facts to substantiate 3 arguments presented before Your Honors as follows. First, that the acts of the accused in the present case do constitute crimes against humanity of murder under Article 7, Paragraph 1, Clause A of the Rome Statute. Second, that the acts of the accused do not fall under any of the exceptions to criminal liability under the Rome Statute. And hence the third argument, that the accused should be held liable for the acts committed by him under Article 25, Paragraph 3 as an accessory to President Steiner. Your Honors, moving forward, the prosecution submits that the accused has committed the crimes against humanity of murder within Article 7, Paragraph 1, Clause A of the Rome Statute, as his acts fulfill all the essentials of the offense. Firstly, he fulfills the contextual elements. Second, the objective elements or the actus reus, and third, the subjective elements of the crime. Your Honors, it's contended by, Your Honors, in accordance with the provisions of Rome Statute and rulings of this honorable court in Kunarak and Popovic judgments, under the contextual elements, the essentials are: firstly, there must be an attack. Second, it must be systematic or widespread. Third, that the acts of the accused must form part of the attack. Fourth, the accused must be aware that his acts form part of the attack. Fifth, the attack must be directed against the civilians. And lastly, there must be a state or organization policy involved. It's duly submitted before Your Honors that there was an attack on the civilians of Titan, which is reflected by thousands of deaths loot, public humiliation, arson, summary executions, and so on. This attack
Sorry,
was
you referred to loot. Has the accused conducted any of the loots, arson, or any of such actions?
indeed not, Your Honor. However, in order to establish that there was an attack on the civilians of Titan, the prosecutor like to highlight the fact that there were, in addition to deaths, there were loot, there were public humiliation, there were arson, summary executions, and so on.
Mr. Prosecutor, what is the threshold for an attack?
Indeed, Your Honor. Your Honor, the threshold for the attack is that it must be, these must not be, the acts which constitute attack shouldn't be the aggregate of random acts. There must be a policy behind such act. It must follow some kind of a pattern, which in the present case is established.
It is to be an act. It's yet to be established. We haven't heard the evidence. Is it act or attack? Because there's a massive difference, gulf of meaning between.
Indeed, Your Honor, on part of the accused, there are acts, there's a conduct. However, as a general, there is an attack on the civilians of Titan.
Where is the attack? Is there a fighting? Is there a armed attack? Are there tanks rolling out? How do we say there's an attack?
Indeed not.
Is there a
Your
test
Honor,
in the statute or in rules of evidence?
Your Honor, attack even refers to conduct of the state or conduct of the perpetrator. And in the present case, the conduct of the perpetrator, which includes the state administration as a whole, they have conducted conducted encounters. They have summarily executed the civilians, and
has the accused committed any of these actions? Has the
indeed
accused
not, Your Honor. However, as a whole, indeed not, Your Honor. However, in order to establish that there was an attack, these acts point out to the commission on part of the accused.
Well, if let's say there's an individual who's a judge and he's just adjudicating, deciding cases. Well, he may be a bad judge. You might even say, I'm a bad judge. That's fine. But what's the harm with that? You're adjudicating, and where I can understand if there's a situation of an armed attack, civilians have been killed, you could have prosecuted the president, which you don't want to do. Where is the attack? I just don't see the attack. And you haven't given us the legal test for an attack. And how is that test to be satisfied in this case?
Your Honor, the accused in the present case has significantly contributed to the crime by not prosecuting officials who are actually committing the attacks. So this,
is there evidence to suggest that there were charges brought about against those people before him?
Your Honor, the judge in the present case, the accused in the present case was responsible for initiating prosecution.
He was a judge. He cannot initiate criminal proceedings against accused, isn't it? Like,
indeed,
I
Your
can't
Honor,
initiate criminal proceedings. It's for you as a prosecutor to do that.
Indeed, Your Honor. However, Your Honor, in the present case, the accused was under an authority and he was obliged by the laws of Titan that he initiate prosecutions against the officials who were committing human rights abuses. And the same cases.
Can you point out to a specific provision from the compromise or from the local law? Could you point out to a specific paragraph which says this, what you have said?
Indeed, Your Honor. Just a second.
Or you may request your co-speakers to pass it on in the meanwhile. But I want to see that he really failed, because we can't presume guilt, as I assume you know. That's the very fundamental of nullum crimen sine lege, the very fundamental of Article 22 of the statute. So we don't want to just simply assume things and conclude.
It's para 17, Your Honors, of the compromise.
Could you read it out, please?
Indeed. Your Honor, it says that these judicial officers, including the accused, were responsible for adjudicating on prosecutions launched against children and young adults caught using or possessing drugs. Secondly, they were also responsible for admitting or authorizing cases against the public officials by victims of human rights abuses.
But not initiating. Somebody has to initiate it, isn't it? Para 17 doesn't initiate it.
Indeed, Your Honor, there's another fact which clearly says that he has systematically denied permission to prosecute these officials.
Mm-hmm. Okay, you can move on.
Thank you, Your Honor. Your Honor, moving forward to the essentials itself, Your Honor, the attack was systematic as it was in furtherance of the common policy and pattern, here the anti-drug policy. And thirdly, Your Honor, the acts of the accused do form part of the main attack, as his actions cannot be isolated from the main attack because they were done in furtherance of the main policy only. Fourthly, Your Honor,
the policy, if you could help us, what was the policy?
Your Honor, the policy was to perpetrate. The policy was anti-drug policy initiated by the Standard Administration, and its objective was to remoralize Titan by eliminating the population or civilians who are involved in drug abuse.
So eliminating population involved in drug abuse. So their concern is about people who are indulging into drug abuse.
Indeed, Your Honor. However, their objective was to eliminate the population and not to rehabilitate.
So have you brought a charge on forced disappearance of persons? You don't seem to have.
Indeed not, Your Honor.
Then how can you rely on those arguments on which you haven't brought a charge?
Your Honors, these are the facts of the case. Therefore, the prosecutor is using them in establishing the charge, which has been portrayed before this honorable court.
I would request you to stick to the charge of crimes against humanity for murder. I'm a bit startled because you haven't referred to so many other charges.
Your Honor.
Yes, please.
Indeed, Your Honor. Your Honor, for the fulfillment of objective element, which is the murder in the present case, Your Honor, it's required that the accused either killed somebody or caused death of someone. Your Honor, the accused in the present case fulfills this requirement as well, because he caused death of many people through his acts and omissions. He issued 1,700 death warrants without trial and due process, and therefore they caused their death. Secondly, Your Honor, he willingly did not prosecute officials committing human rights abuses, which actually led to thousands of civilian deaths.
Well, I've already told you, I'm not convinced with that part of the argument. I don't know about my fellow colleagues. I'm not convinced because there's no question of he initiating. He only has to prosecute. Somebody has to initiate. If nobody initiated, it's not his fault. He can't go and initiate criminal proceedings. There's no procedure of suo motu proceedings unless you can point to one.
Indeed, Your Honor. However, the fact is that he systematically denied permission to prosecute these officials.
I have a small doubt. You have, right from the first statement, you have been telling the crimes against humanity. Now, if it is a crimes against humanity under the Geneva Convention as well as the subsequent conventions, there are 4 other 5 factors. Crimes against humanity, murder, extermination, determination, enslavement, and genocide. How do you attribute, in order to qualify under the conventions, the crimes which are perpetrated?
Your Honor, the pre-trial chamber has already restricted the scope of this proceeding to crimes against humanity of murder only. That's why the prosecutor argues about murder only, Your Honor.
However, you have quoted 1,700 people who are killed. You are relying
Indeed,
on
Your
that.
Honor.
Yes, then you are contradicting your own statement.
Your Honor, for the crime against humanity of murder, there are subjective or contextual elements which are common for all crimes against humanities, and there are subjective elements which is intent, and there is objective element which is the murder, presence of the murder.
Go ahead.
Indeed. Your Honor, at last, the requirement is that the accused must possess intent to commit the acts. It's duly submitted before Your Honor that the accused in the present case fulfilled this requirement as well, as he possessed the same ideology as that of the perpetrator. He drafted the policy which actually resulted in crimes against humanity. He suggested the executing strategy, and he willingly joined the perpetrator to commit these crimes.
Could you establish all 3 of them, because I have my doubts? You said he established the policy. Was he a part of forming the policy? Did he frame the policy?
Indeed, Your Honor, it's given in the compromise.
Yes, which paragraph? I'm pointing to paragraphs because I've noticed your reading and my reading of facts doesn't necessarily match every time.
Your Honor, paragraph 11, last line clearly mentions that Mr. Steiner, who in January 2017 appointed the accused to the drafting committee of ADA's war on drugs policy.
So he was on the war of drugs policy, isn't it? And it says relevant media reports. We also have to take that into account. What is the probative value of media reports? In any event, that's a separate issue. I won't haggle you on that. But I'm still. So, did he frame a policy on crimes against humanity of murder, or he framed a policy on war on drugs?
Your Honor, he framed the policy on crime, the anti-drug war. However, Your Honor, it's not necessary that there must be a policy specifically to commit crimes against humanity. There can be a non-criminal policy, which the execution of which could result in crimes against humanity. And the same has been held by this honorable court in Kunarag trial judgment, Your Honor.
So it's the fault of those executed. It's not his fault then, isn't it? He just framed the policy. Honestly, he thinks there's so much drug. We need to tackle drug problem. It destroys generations. No country in the world likes drugs. In Singapore, you would be executed just for possession of them.
Indeed,
so
Your Honor.
It's a matter of choice. What's the problem with that?
However, Your Honor, the drafting of the anti-drug policy was actually aimed at eliminating the community.
What is the evidence to that effect?
Your Honor, it imposed for petty crimes, for just mere possession of the drug, it imposed death penalties, which is
well, possession of drug is not a petty crime. I gave you the example of Singapore. You may be a foreigner found with a drug, no defenses, you're executed. It's just normal in several jurisdictions.
Indeed, Your Honor. However, Article 6, Paragraph 2 of the ICCPR, which the country Titan has ratified, clearly mentions that the death penalties can only be imposed for more serious crimes. And secondly, it states
the definition of serious crime happens according to national jurisdiction, and a country wants to say possession of drugs is a serious crime. What's the problem with that?
Your Honor, the UN Commission, Human Rights Commission, has clearly stated that the possession, any offense in relation to possession or usage of drugs cannot be considered most serious crime.
Are those binding? Are those observations binding?
Your Honor, the present Titan, the country of Titan has ratified the
Are
UN.
the observations of the Human Rights Committee binding?
Indeed not, Your Honor. However, that the interpretation can be taken by
it's an interpretation by a few experts, like Judge Kadam may be a bit angry with this, but ICRC makes certain interpretations. Not necessarily we all agree with that. So how do we rely on that?
Your Honor, this is not the only argument which tries to get the intent of the accused. There are other acts as well as omissions on the part of the accused from which the intent can be drawn out.
Could you please highlight them straight away so we save time?
Your Honor, he suggested the executing strategy, and he's willingly joined the perpetrator to commit the crime.
Okay, Your Honor, go ahead. Yes, sorry.
Counsel, I have a question, if I may interrupt you at this moment. As far as I understand from the facts of the case, the policy was to identify those who are indulging in use of drugs. Isn't that correct?
Indeed, Your Honor.
And then take legal action against them, although it's a very harsh legal action, in some cases resulting into death sentence, but it was directed only at certain individuals who were indulging in usage of or possession of drugs. Am I right?
Indeed, Your Honor.
So the objects of murder were individuals, isn't it? Specific individuals. Specific individuals, because I have a little problem with this, because the jurisprudence of this court as well as some other tribunals, it has consistently observed that crimes against humanity should be of collective nature, in the sense there is mass killing involved, and it's not like identifying a specific individual, killing that individual would amount to crime against humanity. It might amount to another crime. I'm not saying it may not be another crime, but to amount this type of killing to a crime against humanity, there should be, the crime should be of a collective nature. Like a person giving order, go and kill all the residents of this locality or eliminate all my political opponents. But here we find you identify people who are engaged in a certain activity, which according to the state is harmful to the society. It may not be harmful in other countries that have legalized usage of certain drugs, but I would like to draw your attention to these observations in Kaishema and Ruzindana of ICTR, decided in September 98, paragraph 598, then Kordich of ICTY, then again February 2001, 26 February, a decision of ICTY, paragraph 236. And there are a number of other cases where the international criminal tribunals have consistently upheld the view that to amount these types of killings to a crime against humanity, these offenses are known as mass atrocity crimes, Council, and therefore we would like to see whether this element is present in this given situation. Otherwise, we might be holding a person responsible for carrying out orders in accordance with the law laid down by the higher authorities. Kindly explain.
Indeed. Your Honor, the point here to be noted here is that it's a fact that 30,000 deaths were caused on account of this anti-drug policy. And Your Honor, for the widespread criteria that you mentioned, Your Honor, it's this honorable court and ICTR, ICTY in Prosecutor versus Ruto and Prosecutor versus Tree have clearly stated and held that that they have recognized just 200 target victims as fulfilling the widespread criteria for crimes against humanity. Your Honors, there were 30,000 deaths in the present case, and even if we consider...
Counsel, let me clarify. If there is a policy announced by a president or a person who is acting in similar capacity, addressed to his subordinates, go and kill all my political opponents. And if that person kills only one person, that will amount to a crime against humanity. Even if there is only one death, and the jurisprudence of international criminal tribunals, it doesn't insist that there should be huge number, but it should be part of a policy. It should be addressed to collectivity of individuals, not against a specific individual. So I'm not impressed by the numbers that you are quoting, 30,000 versus 200. I mean, even as I said, even killing one person would amount to a crime against humanity.
Your Honors, in the present case, this there was a clear state policy in the sense there were not just the laws and the policies, the execution of which resulted in crimes against humanity. However, there were state forces, the police, the administration, bureaucracy, the judges who were involved in commission of these acts, and therefore it completely fulfills the systematic criteria as well as the state policy criteria that you have mentioned.
I think you should go ahead and address some other points. None of us seem to be convinced by any of the arguments. So, but better go ahead.
Just go ahead. Yeah, we will maybe come back with some other questions.
Your Honor, the prosecutor has already consumed time, so just an extension of 30 seconds to wrap up.
Yes, please.
Other points.
Your Honor, the second argument is that the acts of the accused do not fall under any exceptions to criminal liability under the statute. Your Honor, the burden to prove that the acts of the accused fall under the exceptions is on the defense. However, the prosecution can well establish during the course of the trial that none of these defenses actually apply in the present case, as the essentials thereunder are not fulfilled. Your Honor,
If I may interject you to save time, what I think we could do is after we have heard the evidence and after we have heard at your closing, you can come back to that point and we can consider it at that stage. And if the other fellow judges don't have an objection, we'll come back to that to save time in your closing. I think that'll be better.
all right. So should the council conclude then?
Yes, please.
All right. So that's all.
You can just leave. We know your prayers, so you can conclude and then you can pass it on to your colleague.
All right. Your Honor, the third argument briefly. Your Honor, the third argument is that the accused should be held liable for the acts committed by him as an accessory to President's dinner under Article 25. That's all from the prosecutor's opening statement. Thank you, Your Honor.
The council addressed the bench as your lordships.
Yes, please.
A very good afternoon to your lordships and to my respected colleagues on the side of the prosecution and the defense. I am Speaker 1, appearing on behalf of the victims in the case of the prosecutor versus Umberto Eco, concerning the commission of the crime against humanity of murder as per Article 7, Paragraph 1, Subclause A of the Rome Statute. The council will be providing the opening statement and conducting the examinations in chief, and my co-counsel will be conducting the cross-examination and delivering the closing statement. Your lordships, the case before us today is one that is rife with tragedy.
I'm very sorry to interject. I might be too much of a stickler for procedure, but I don't have a problem with being called Your Honor, but we are an international tribunal, so you deserve to be called Your Excellencies. And then you called us Your Lordships as well. So you may decide, but you should always give us some amount of ego comfort to international judges. Thank you.
Yes, Your Excellency. May I please continue using Your Excellencies? All right. Your Excellencies, the case before us today is one that is rife with tragedy and gore. The victims in this case are deeply aggrieved by the gruesome treatment meted out to a particular class of citizens in the state of Titan, due to the events that followed from the implementation of the Steiner government's war on drugs policy. The aggressive manner in which the policy was implemented caused great distress to the victim community. The victims of such governmental action could then only turn to the judiciary in the state for respite. However, here as well, they faced additional persecution. The judicial infrastructure, as commandeered by the accused in this case, seemed to be against extending basic decencies to the victims in this case. And so the tragedy continued.
Sorry, just a quick question. Have you been authorized by the victims? You're an NGO, aren't you? We know you are a very respected and a political body, but are you authorized by the victims to appear?
Yes, Your Lordship. The same has been confirmed by the decision of the pre-trial chamber as well. Thank you, Your Excellency. As I was stating, the victims in this case...
I'm very sorry. Again, I was reading paragraph 32, if that's what you're referring to from the compromise. When you said you've been confirmed, it says a CRM now seeks to participate in the trial. Is that what you're saying, or you're referring to the decision of the pre-trial chamber? If you look at paragraph 32, say it says CRM is now seeking, which means it's not yet authorized.
Your Lordship, if you would just, sorry, Your Excellency, if you could please refer to the next paragraph on the same page. It states that during the course of the proceedings so far, CRM made multiple submissions, and the conclusion is essentially that the chamber allowed us to represent the victims in this case.
Yes, thank you.
Thank you, Your Excellency. The judicial infrastructure in the state of Titan therefore continued to cause even greater emotional distress to the victims in this case by lack of proper trial, excessive punishments for petty crimes, and complete disregard for due process. And what this reflected was a general sense of apathy in administration. And we are here to argue that the accused can directly be linked to these problems faced by the victims. Your Lordship, the victim's legal Excuse me, Your Excellency, the victim's legal representatives stand before this court today to support the actions initiated by the ICC prosecutor. We would also like to acknowledge the extraordinary power of the court to award reparations as per Article 75 of the Rome Statute to the victims in this case. The presence of the victims in an international trial of this magnitude affords a fine opportunity to this court to contribute to the growing jurisprudence of victims' reparations before the International Criminal Court.
Sorry, we are here to contribute to jurisprudence or to decide cases?
To decide cases, of course, Your Excellency.
So let's avoid the ideological rhetoric. Let's come to the points.
Yes, Your Excellency. Through our submissions and through the evidence we will present and the witness testimonials we will put before this court, we will seek to establish the following. First, supporting the claims of the prosecution that there was indeed the commission of the crime against humanity of murder as per Article 7(1)(a) of the Rome Statute. And
At the
secondly,
same time, what additional points you may want to make apart from the prosecutor, and also to fill the gaps where the prosecutor was massively lacking?
Your Excellency, as the victims in this case, we will be able to put forth witness testimonials of the victims themselves to understand just how grave the problem was and just how severe the consequences of the aggressive implementation of this policy were. Also, we will make a case for the provision of reparations that this court may be so kind to grant us, if it deems right.
So you're also asking us to adjudicate on reparations?
Yes, Your Excellency.
So what would be the standard we have to apply for reparations?
Your Excellency, if we refer to Article 75 of the Rome Statute, it states that the court can establish principles relating to reparations with respect to the victims and give due consideration to the exceptional circumstances, determine the scope and extent of damage, loss, or injury caused to the victims in this case. Through our witness testimonials and the evidence we submit, we will be able to give you an idea of exactly what kind of damage was caused. Further, Rule 97 of the Rules of Procedure and Evidence of the International Criminal Court makes clear that awards for reparations can be made on an individual basis, on a collective basis, or both. Therefore, we would leave it to the good judgment of this court to understand what the victims in this case deserve.
Yeah. Just one more point. I was struggling with this fact. Somewhere there was a reference which says that none of the statements are made on oath, but you're going to produce some witnesses, right, who would take oath and then depose in front of us.
Yes, Your Lordship.
Okay. Thank you.
Thank you.
Just another technical question. Are the documents which are on record, have they been testified?
Your Excellency, we will mark them as and when they are brought up in cross-examination.
Thank you.
Thank you.
Counsel, I have a question. I fail to understand how you are contributing to this trial in addition to what the Office of Prosecutor has done, because having multiple counsels, talking about the same issues and same facts, is it not putting the defense at an advantage? Because the defense is only one, but here you are like an additional prosecutor. Because the idea behind allowing victim participation was to enable the victims who have personally suffered a loss to take part in the proceedings. And that was made clear in Kony and others by this court in 2009. And there this court has very clearly observed that the harm should be suffered personally. CRM as an organization, as an entity, has it suffered any harm because of the policy of the government or whatever has been done in the name of that policy is one question. And secondly, there is also some jurisprudence to establish that legal persons may also qualify to participate as victims, but if they have suffered a loss, like for example, there is an attack on a school. So the school itself as an entity can become a victim, or a hospital for that matter, which has been attacked where there is a loss. The hospital itself can be an entity as a victim. But here you are just an NGO working for a good cause. I understand, I admit. But then what is your necessity of joining the proceedings? Because the prosecutor's office is very much there to take care of establishing all the charges, claim reparation on behalf of the victims. So what additional things you are, in a way, I feel, victimizing the defense? Thank you.
Your Excellency, thank you for your question. In our understanding, the reason why the civil rights movement is the appropriate body to represent the victims in this case is because, as we will demonstrate through the witness testimonials and the evidence that we present, the victims have suffered such grave harm that they are unable to organize and put forth their cause
with the required force and the required resources to argue before this court. Therefore, as a non-governmental body with requisite resources, we have come forward to try and help them out and present their cause before this honorable court.
Do you want to suggest that the office of prosecutor is not competent enough to espouse the claims of all the victims?
No, Your Lord, no, Your Excellency, that is not what I'm hoping to suggest. I'm instead hoping to impress upon the fact that the prosecutor's intention is more towards charging the accused in this case. Our intention is to bring forward the cause of the victims and the harm that they have suffered, so as to provide the court with a better idea of exactly how grave the actions of the accused have been.
That's a very good point. And how many victims have you brought before the court? The actual victims? None.
Your Excellency, we have brought forward as witnesses 2 victims in today's trial.
Tell us who are the victims and what they suffered.
Your Excellency, the first victim witness is a former police officer from the police force in Juan by the name of Mr. John Ferreira.
So whose witness is he?
Sorry?
Whose witness is he?
He is our witness, Your Excellency.
Okay.
And the second victim's witness, his information and details have been redacted due to the fact that he fears for his life and security and has undergone great trauma due to the actions of the standard administration and the accused.
And just as a matter of procedure, you may want to rethink your position. You've presented them as witnesses, and you would be comfortable to go along with them irrespective of what comes out of the cross-examination, because I see their written depositions are not essentially very helpful to your case, but you're going to stand by what they say.
Your Excellency, we will work with what we have.
Okay, very good. We'll see what comes out of the testimony.
Thank you. Thank you, Your Excellency.
Your Excellency, shall I proceed?
Yes, please.
Yeah. A very good afternoon to the President, Your Excellencies, the Office of Prosecutors, the legal representatives of victim. May it please this Excellencies, may it pleases this Excellencies, may it pleases this bench collectively as Your Excellencies. As Speaker 1, appearing on behalf of defense in the present case of prosecutor versus Umberto Eco. Your Excellencies, I'll be dealing with the opening statement and conducting the examination in chief, and my co-speaker will be dealing with the cross-examination and the closing statement. Your Excellencies, may I proceed with the opening statement?
Before you proceed, I have a bit of a technical, which might sound as an academic question, but it has a great deal of influence in this case. Is we have 2 conflicting positions, and I'm struggling which one to take. In Lubanga, it was said the dolus directus only has to be of the first degree. That is, you only have to have the intention to commit a crimes against humanity. But in Bemba, the court said you need to have a dolus eventualis. That is, you have to have an intention also to have the consequence and achieve that consequence. So in Bemba, they say you don't need the first degree, but in Lubango, they said you also need the second degree. How do we reconcile? What position should we take on this? Because it's going to decide your guilt ultimately. I mean, your client's guilt, if I may say that.
Indeed, Your Excellencies. As per the best knowledge of the counsel on behalf of defendant, we need to give priority to the judgment which is the latest one, because what happens, the time, it changes day by day. We have the cases going on each and every year, right? Where therefore the jurisprudence of each and every single legislation it changes throughout the time. Therefore,
so you are suggesting that people become wiser with time, and people who have given decisions in the past have to be ignored.
In this, Your Excellency, this is not my suggestion. It is the established fact that people are becoming wiser day by day. It is established fact.
Really, I doubt so, because I come from India and don't have any comparative wisdom as compared to Adi Shankaracharya. He just lived for 36 years and made the foundation of the entire religion. I'm much older than him and still struggling even to fathom the technology. I doubt if I'm wiser than my ancestors. I'm definitely not.
Your Excellency, for that purpose, counsel has only one single thing to say, that wise, the definition of wise is very subjective. It differs from person to person. So it might be different for you. It might be different for me.
I think let's, rather than getting into this very vague and abstract
Indeed, Your Excellency.
it would be helpful if you tell us as to why you prefer one decision over the other. And I don't think timing is just a convenient point. Some people are lucky to buy before, to take birth before, and some people are very lucky to take birth later.
Your Excellency, here we need to understand about the retrospective effect of any law. We generally don't give retrospective effect to any criminal legislation. Whenever any law which is related to criminal law, it passes, it has no retrospective implementation of the same. Your Excellency, therefore, we believe that if a judgment is being passed in the ICC, so we need to give priority to the judgment which is the latest one, because even in the Supreme Court, what happens whenever any judgment is given reference, we generally
if you may pause, the judge has a question.
I have a small
Indeed,
question.
Your Excellency, I sense a question.
Whether it is even in the ICC statute that the judgment of the ICC is binding?
Your Excellency, here we need to understand the law which is applicable there in International Criminal Court. It is something which has to be understood through the cases.
Each case is decided upon the facts and circumstances
Indeed,
of that concerned case, dependent upon the arguments which are made before the court of law.
Indeed,
so even the judgment of the International Court of Justice is not binding on the parties, except the parties under Article 56 of the statute. Ipso facto, it is binding only for the parties to the dispute, not for others. It may be having persuasive effect. So at least could you say, by way of your argument, when the decisions of the ICC have persuasive effect on the international community or the parties to the dispute now herein?
Your Excellency, it indeed has effect. The ICC, it indeed has effect on the international and the country which are parties to the Rome Statute. We believe.
What is that effect, if at all there is any?
Indeed, Your Excellency. Like in the present matter itself, we'll be showing how exactly by bringing in a prosecution against Umberto Eco, the international community, it has come together to save a particular individual. Because what happens when a particular individual is being, whenever any crime happens, and a person has nowhere to go. Let's say the state is corrupt and there's no case which can be brought through the state.
You are referring to individuals. So sorry to be rude and interjecting in between your sentences, but you said there's a reference to individuals. Is international criminal law aimed at protecting individuals? Is domestic law not enough? Can we take up all individual murders, take them into consideration?
Your Excellency, that is the whole, I believe that here we need to understand that ICC is something which punishes an individual crime. It does not punish any crime which is being committed by government. Therefore, what exactly is happening?
Are you suggesting that the whole regime of international criminal law is created just to prosecute individuals for private crimes?
Your Excellencies, indeed, we believe so, but
that contradicts my understanding and the understanding of everybody else who studies international criminal law, because we always thought it was created to punish people who use their government office. It may be people sitting in the government for using public instrumentalities to commit serious crimes, and they ought to be punished. It's not just a normal offender who commits a murder on the street who's to be prosecuted.
Your Excellency, I would like to give my clarification over the statement that I made. Here, what statement I gave, that I meant that whenever there is any crime, we can only punish the individual criminals. We cannot punish the people who are involved in the crime, like at the ground level. We can punish the root cause of that crime, the person who was the major reason behind happening of that crime, the one who influenced the crime, the one who has effective control over that crime.
Yes, that's why precisely we are prosecuting your client, isn't it? Because he's the one who's been killing people. You saw we got the numbers, misusing the judicial process. That's why we are prosecuting him.
Your Excellencies, he can be prosecuted, but here we need to understand none of the element is substantiated to bring in this case before international court. Neither elements of Article 7 is substantiated, nor Article element of Article 25 is substantiated. And if we refer to defenses, which is mentioned under Article 31, we can substantiate, we can justify the action of Mr. Umberto Eco under para 1 subpara D of the Article 31, which talks about duress. Your Excellency will be dealing with this particular issue with our testimonies. We'll be showing you how exactly there was this duress on Mr. Umberto Eco. And
you have jumped on to duress. I'm assuming you don't want to establish that this is not a crime against humanity. You're agreeing there is a crime against humanity, and now you want to raise defenses.
Your Excellency, exactly. We are saying that there is a crime happening, but we are not saying this is a crime against humanity. It might be a crime. This might be something else.
I was trying to help you, actually. Judges also try to help sometimes.
Indeed, Excellency.
The council. I'm trying to understand. Do you have two arguments? The first argument to say, well, the requirements of offense are not complied with, number one, and even if they're complied with, we have a defense. Is that what you're saying? Or you are saying, yes, the elements are complied with, and we want to go straight to defense? What is it you want?
Your Excellencies, we are indeed saying that the crime has happened, but your Excellency, we do not want to enlist this particular crime under the head of murder, which is listed under Article 7.
Okay, where do you want to put it?
Your Excellency, basically the element which is required under murder, it is not substantiated. Murder talks about the mens rea.
That's okay. You said look, you have agreed there's a crime committed. You're saying, but it's not murder, it's something else. You tell us which is that crime against humanity, and we'll ask the prosecutor to open investigation and then indict you for that.
Your Excellency, we believe that it should be dealt with the case of Mr. Steiner. It should not be dealt with the case of Mr. Umberto Eco. Your prosecution is going on with regards to act which is being done by Mr. Umberto Eco. And here, by the end of this trial, we'll be substantiating that none of the act which was done by Mr. Umberto Eco was any crime. None of those crime was happened.
You just agreed he has committed the crime, and now you're saying he did not. And I think the prosecution has already told us he has committed the crimes himself. And they also explained why they're not prosecuting the fountainhead of these crimes, the president.
Your Excellency, will be showing that crime has happened. The crime against humanity has happened. We are actually submitting to this fact that crime against humanity has happened. But what is the crime that we do not want to support? But it can be crime against humanity of murder. It can be something else. But here we need to focus on crime against humanity. Moreover, Your Excellency, will be showing that Mr. Steiner is the one who is doing this particular crime, and only Mr. Umberto Eco is being used as an instrument. He's been used as a tool to execute that particular policy by duress and by superior order. Therefore, we are taking the defense of Article 31 and Article 33. And this is how we are going to justify our case, Your Excellency. I hope it pleases the answer pleases the bench.
You're just telling us what you're planning to do, but you haven't told us how it is. I think let's
Indeed,
tell us how it is.
Yeah,
done.
we will move on
Thank
to
you.
the submissions. Your Excellencies, first, it is pertinent to note in the paragraph number 4 of the undisputed facts, order were passed under which any kind of contention and denial was not allowed during Mr. Jude Steiner's regime. Those who stood against them were charged with false accusation and charges. Moreover, sanctions were imposed against the judges who opposed him or as an his administrative views. Your Excellencies, these threats to the life of Mr. Eco were also evident by email communication which happened between Mr. Nemanja Vidic, the chief of ADA, and Mr. Eco, which is attached as the annexure in the.
They have some relationship, don't they? The person who sent the email and received the email.
Nemanja, the Excellency, Nemanja Vidic is the head of ADA. He is the
they
main
have a
chief.
personal relationship as well, the both of them.
No, Excellency, they had no personal relationship.
Sure. Okay.
Indeed, Your Excellency, it was very professional.
But no, did they have relationship outside the professional relationship?
No, Excellency, as per the moot compromise, they never interacted in a personal manner.
Okay, go on.
The email. Indeed, Your Excellency. Your Excellencies, accused had no say in any of the order passed by under the chapeau of war on drug policy. He was just drafting what he was asked for. He was just disposing the duty of the post that he was for which he was appointed. He was just passing the judgment pursuant to the legislation which was passed. He abstained from.
But the legislation was drafted by him.
Your Excellency, but here it is pertinent to note that he was just in the drafting committee. Drafting committee is not the one who is giving suggestion. He's the one who is just typing down those policies. Drafting committee's work is to type down those things, not to give advice, not to render advice.
Well, I'm very shocked and disturbed by hearing that, because I've myself chaired the drafting committee of the International Law Commission. And I can tell you drafting committee is where the law is made. You may say whatever at any other place, and you're just saying drafting committee is the most useless. We're not clerks, for God's sake.
Your Excellency, that was just how I wanted to explain. That is not exactly the duty of a drafting committee.
That's exactly what the duty of drafting committee is, Mr. Counsel. I'm very shocked to hear all this.
Your Excellency, I'll seek ignorance for that particular definition I gave for the drafting committee, but I was just rendering what exactly a drafting committee major work is to do. Yeah, they can also advise the particular person with regards to that policy. A drafting committee's member can also render the suggestions for that policy, but it's not the major task of that.
I'm sorry to take you back to, because I'm still struggling with some facts. So
Indeed,
Judge Beko has a wife also, isn't it?
Indeed, Your Excellency.
What is
Martha
the wife's name?
Martha Ramde.
And what is her role?
Your Excellency, she was the head of Ministry of Law and Justice. She was the chief secretary of that particular ministry.
And she complied with, and they both worked in complete concert with each other to commit crimes against humanity.
Indeed, Your Excellency.
Yes, they did.
Your Excellency, could you repeat the question? I
said both husband and wife worked in conceit, worked together to commit crimes against humanity.
No, Excellency. No, no, indeed.
Okay.
Yeah. Ignorance for the last statement.
And she, where did she work? She worked in the president's office, isn't it?
No, Excellency. Actually, the ministry was under the control of president, but she was under the Ministry of Law and Justice, which is completely different to ADA, Anti-Drug Authority.
That did not regulate administration of justice at all.
Ministry of Law and Justice.
Mm-hmm.
No, Excellency. They work for the administration of the same.
Okay. You should have been able to point out the facts if you're aware of them, but it's okay. I found
Indeed. No, Excellency, I can point out the facts. So could you repeat the question in the brief, if you could?
It's okay. You can move ahead. The time is up.
I have
Indeed,
a question,
Excellency.
Counsel. You refer to duress, and you claim that the accused was under duress. I would like to draw your attention to Article 31, paragraph 1, clause D of the Rome Statute, where duress may be accepted as a valid defense, duress resulting from a threat of imminent death. Was there any such imminent death as far as the accused is concerned, while the accused was handing down sentences, whether somebody was standing with a loaded gun pointed at his head and saying, sign this order, otherwise I would kill you? Can you explain the meaning of threat of imminent death in this instant case?
The council was going to actually answer that particular thing in the further submission. Anyway, there are three major elements which we can see under paragraph D. So first one is rightly pointed out, first one is the imminent threat. Your Honors, Your Excellency, we can see in the present case, there is an imminent threat to the life of those people who are, here we need to understand what exactly we are going to content in our closing statement. That imminent threat, where we are trying to make you understand by term imminent threat, that by the time Mr. Umberto Eco, Your Honors, Your Excellency, I believe for that purpose, I'll have to tell you the whole story which was going on. First of all, here we need to understand why exactly Mr. Umberto Eco took the position of ADA's head. He took that position because he wanted to avoid the greater harm which could have caused if he had declined the offer of that position. Therefore, and if he had declined, Mr. Steno could have appointed someone else.
So what's the problem? He should have gone and appointed someone else. Why was
I mean, the president was not going to kill him. merely because he's not accepting. Because
But
he
Your
would have said,
Excellency,
okay, not you, I will appoint somebody else. That's it.
But Your Excellency, the threat which was given by Mr. Stainer to the ADS judges, that if you won't be giving judgment as soon as possible, then your life, like you will be, your life will be at the prejudice. You might get a mob lynched by some civilians who are working for Mr. Stainer's administration, who are working for Mr. Stainer's policy. So there are so many things which was going on.
Can you just point out in compromise where it is said that the president threatened them with their life if they
Your
did not
Excellency,
follow the orders? Is it just a conjecture, or you are imagining that the president would have done that, threatened them with their life? There is nowhere we have come across any such threat. He would have just appointed somebody else. If not you, I will see who follows my orders.
so Your Excellency, it's not about appointment. It's about avoiding the greater harm. If there was someone else in that particular position, then I believe as of now, the capital punishment was only about 1700. But if someone else was in the position, the capital punishment to around 10,000 person could have been given, because the policy war on drug is of such a nature that it gives a very extreme power to the judges, and it makes such an extreme policy. Even if a person is keeping drug with him, the person can be brought behind the bar.
Just to remind you that that your client is the author of this policy, and he was picked up by the president, and he's the one who gave the powers to the president. So let's
Your
not
Excellency, Stainer
But
was
I think
never
what needs to be done is we could pause on this issue, because this is a very important issue, and after we hear the evidence, we come back to it, because I see there are these documents, and we would like to hear the witness and then come back, and I'm sure Judge Kadam might have more trying questions for you then.
Indeed, Your Excellency, we'll be proving that particular fact with the testimony of our witnesses and through cross-examination. I believe we'll be able to establish this particular fact beyond reasonable doubt.
Don't be so confident, but if you have concluded, let's move on. I think that's better.
Indeed, Your Excellency, we can move on. With this, Councillor has the opening statement.
Okay, thank you. I think if other judges have questions, I think they may have to any of them, or we can, now we move to the evidence phase, isn't it, I suppose?
Your Excellency, just one clarification. Shall I state those other articles and those other contentions as well, through which I will be taking the defense? There is Article 33 as well. We'll be proving that.
You can come to that in your closing, I think. That would be a better
my co-counsel will be dealing with the closing statement.
Yes, and you can, if you think your co-counsel could not raise some issues, you can always step in. If
Indeed, Your Excellency, that would be very helpful.
May the prosecutor proceed with a chief examination of prosecution witness 1?
Yes.
Obliged. Witness, do we have you here?
Yes.
Witness, first I would like you to take an oath. Witness, kindly repeat with me the words. I solemnly declare.
I solemnly declare.
That what I shall state.
That what I shall state.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
All right. Witness,
I'm very sorry, I should have raised this question even before you administered the oath, because this is a procedural one. Is this witness, Mr. Prosecutor, a witness of fact or an expert witness of opinion?
Your Honor, it's a witness of, it's an expert witness relying on the journalistic experience.
Thank you.
Right. Witness, could you please introduce yourself to the court?
My name is Eugene Young. I am 40 years old, and I am a journalist.
All right. Could you please tell the court how are you related to the present case?
Sure. I have written various research papers and books on the social political issues of Titan. Currently, I'm working on a manuscript on the Steiner regime. I seek to highlight the motivations and context in which all the individuals responsible for perpetrating the war on drugs policy against the population willingly acted so. I will be doing so by relying on my in-depth study and years of journalistic observations on the geopolitical developments in Titan.
All right, witness, could you please tell this court who were the primary victims of the Steiner strategy?
The primary victims of the Steiner strategy were the marginalized community in Titan, which would be the Protestants and those belonging to the poor background. Essentially, the strategy of this regime was to create further the rift between these communities.
All right, point to be noted, Your Honor, the policy was directed against the civilians in itself. All right, moving further, you have mentioned that political strategy of Steiner, right? Could you please tell how this strategy was executed?
So with the underlying current with which Mr. Steiner's regime rose to power stems from the fact that the lack of willpower amongst the youth to vote. And Mr. Steiner's strategy was that he used the ignorance of the elderly population to come to power. And he knew that by raising this drug problem as an agenda, it would appease the elderly population.
All right. On what scale was this strategy executed?
As soon as Mr. Steiner, as I mentioned before, Mr. Steiner had a huge, he thought that society's downfall was solely attributed to this drug problem. And he said that he promised, in fact, swift and conclusion action with respect to the same. And as soon as he came into power, he lost all track of due process and all regard for the same. And when he took over, he got rid of all procedural safeguards against his administration. And he also imposed the harshest penalties in relation to the trading of drugs and in relation to substance abuse. He also, his administration also formed a dedicated task force called the Anti-Drug Authority, and they were authorized to use aggravated police force to arrest the distribution of drugs. And he also enforced a local watchdog unit called the AD enforced a local watchdog unit called Friends of the Neighborhood that assisted the police.
All right, witness, could you please tell, was the execution of this strategy made possible with the connivance of the state machinery, in specific, for that matter, the judiciary?
Indeed, it was the judiciary that was, as I mentioned about the Anti-Drug Authority. Following that, pursuant to that, an Anti-Drug Authority tribunal was set up. And now 17 judges, including, and in addition to the Chief Judge, Mr. Umberto Eco, were authorized and made part of this campaign by Mr. Steiner himself. And these were the people who were giving out sentences in relation to charges of drug consumption and trade.
All right, point to be noted, Your Honor, state machinery was involved in this, in the present case. Moving further, could you please state the role that the accused Mr. Umberto Eco in specifically in the execution of this strategy?
Sure. Mr. Umberto Eco, he was ruthless while conducting his trials. He conducted speedy trials and jumped to conclusions without following a proper trial procedure. He also is known to have given the maximum number of death penalties at his disposal. And to be precise, we're talking about 1,700 death penalties under his judgeship. Post that, he is also known to have not listened to the legal claims and defenses of the other parties and has directly given out sentences. In addition to that, he has given long-term and lifetime sentences to young minors and children, in fact. And lastly, he has dismissed any form of prosecution against cases in relation to police brutality, etc., effectively dismissing any checks on the power of the government.
All right,
witness, I have a question for you. I need some clarification. You said the accused did not follow any procedure in handing over sentences during those trials, if I am right. Is that correct?
Indeed, Your Excellency.
And you have first-hand knowledge of that because did you participate in all the trials that were conducted by the accused person?
No, Your Excellency.
So your knowledge is depending on something you heard from some other sources, isn't it?
No, Your Excellency. I have conducted various interviews with members of the
administration. Yeah, exactly. I mean, after listening to the interviewees, you drew your conclusions.
Yes, sir.
My question is, do you have first-hand knowledge of attending the trials that were conducted by the accused, and you are basing your statements purely and exclusively on the basis of what you observed in the courtroom?
Your Excellency, unfortunately, I was not present in the courtroom. So my experiences are by means of these interviews and other research.
You may go ahead, and prosecutor, you may go ahead, but I'm not going to rely on this witness anyway. Thank you. Go ahead.
All right, Your Honor. Witness, you mentioned that the accused actually aided and assisted the Mr. Steiner in commission of some grave offenses. Could you please state what was the objective behind such assistance?
Sorry, could you reframe the question?
Yeah. So could you please state what was the objective behind the assistance by Mr. Steiner? Mr. Ambatoeko, sorry.
Mr. Eco also believed in the ethos, and he harbored the same political ambitions as Mr. Steiner. And in fact, he whatever was put forth in terms of the war on drugs policy, he believed in all of the same. In fact, it was on the basis of his memorandum on the unitary executive theory, which stated that he believed.
I'm very sorry to interject. I did not want to interrupt because I wanted to listen to what the defense has to ask in cross and then step in. But I see that the defense seems to be quite calm and quiet with whatever is being said by the witness. But I wish they were a little more alert.
Your Honor,
yes. Are you not
Your Honor, if you may permit to speak. Your Honor, I will be dealing with all those questions in my cross-examination. I'm just jotting it down, like whatever she's like presenting in treatment.
Yes, but if there is a certain question which deserves an objection,
yes, Your Honor,
I think you should raise the objection before it is too late. But I was going to do it on your behalf. Because once it goes on the record, it's on the record.
From now on, I'll keep that in mind. Like, actually, I was thinking that we cannot raise. Yes, Your Honor. From now on,
I had told the organizers that you can. So if you have to raise an objection on this point, do raise it now. Do you have any objection?
From the same political ambition, right? Like he mentioned. Am I audible?
I couldn't hear what you were trying to say.
I think my network.
Yeah, you can go on.
Okay. So, witness, like you mentioned about the same political.
I'm not asking you to do a cross-examination. Please understand the difference.
Your Excellency,
you cannot
raise the objection. Objection is that the witness is the counsel is assuming the facts which is not mentioned in the memorial in the.
I don't think I'm not very convinced with such kind of an objection. Your objection is overruled. It's a wrong objection. But the objection I had was, Mr. Prosecutor, you started off by saying that your witness is an expert witness, and the witness is giving all kinds of factual conclusions as if the person has first-hand information. You have to make a choice, and I don't think we would take anything on record where the witness is making statements of facts rather than statements of opinion.
Your Excellency, if I may.
That's for the counsel,
oh.
And we'll come to you. Yes,
Indeed.
as well. Certainly you may at a later stage.
Your Honor, the witness is actually relying on the interviews that she has conducted and the years of journalistic experience that she had regarding the political situation of Titan. She has also written a manuscript on Steiner regime. So therefore, the witness.
Thank you. That's fine. Yes, witness, what do you want to say?
No, just that, Your Excellency, I'm writing my manuscript. So all this part of all this data that I have is part of my collection for my manuscript.
The prosecutor said you're writing on the political background.
I'm writing it on Steiner's regime. Indeed.
Are you also writing on legal background?
It's inclusive of everything that happened, and it's with.
Okay. Do you have any legal knowledge yourself?
No, Your Excellency. I do not have any legal knowledge.
Have you witnessed any of the trials which Judge Kadam was asking? You haven't?
No, Your Excellency.
Thank you. Sorry, I shouldn't have asked these questions. It's actually for the defense and would have come later, but apologies for that. But we'll restrain ourselves till witnesses finish the cross-examination. But if there's something egregious like this, where you start off as an expert witness and go into facts, then we might have to object.
Your Honor, should the counsel move forward?
Yes, please.
All right. Witness, could you please tell us about your observations from your interviews that you conducted over the past 3 years?
Sure. Based on my interviews, it had become abundantly clear from all the people that I spoke to and relied on that everything that Mr. Steiner propagated and the precedents that he set is something that Mr. Eco abided by or he believed himself, and that he was not just accessory to whatever happened. He was actually a willing participant. And in fact, I would like to supplement this by stating that all the professional and financial benefits that he receives speak to this nature. And additionally, nothing else can justify his high rise to power, position, and prestige.
All right. Point to be noted, Your Honor. He was a willing participant in the commission of the crimes. Moving forward,
we are noting all points. No need to reiterate it every time.
All right. Your
Unless you have any other substantive points, because we don't want to go on with this forever. Right?
All right, Your Honor. Witness, from interviews, you mentioned in your testimonial that from interviews, it has become abundantly clear for people like Umberto that Steiner had set a precedent worth following. How did Steiner set a precedent worth following for the accused?
Your Honor.
I'm very sorry to interject. Are we trying President Steiner here?
Indeed not, Your Honor.
Yeah, so what's the point of what was his strategy? I don't think that's a relevant question.
Your Honor,
you have to stick to time as well.
It's not about the strategy, rather the role of accused in the present case.
You can ask for the role of accused. You need not ask the policy of Steiner for that.
Indeed, Your Honor. Witness, do you think that the appointment of accused as the judge of ADA tribunal was in furtherance of the criminal design?
Indeed.
Honest, we object to this question, this leading in nature. This is a leading question. The counsel is trying to lead witness to a particular answer.
So it's an open question, no? Was it yes or no? There's nothing leading about it.
Your Honor, basically, counsel was trying to give a suggestion to the witness to answer.
I agree with the point. Yes, you should not be giving those suggestions unless other judges.
I'll rephrase it. Witness, could you please tell how was the appointment of accused made?
The appointment of the accused. Firstly, Mr. Umberto himself, I think, contacted the Steiner regime when he submitted the memorandum I was talking about earlier. And after that, he was appointed on the drafting committee of the War on Drugs policy. Pursuant to that, once the ADA tribunal was created, he went from a university professor to the Attorney General and finally to the Chief Judge of the ADA tribunal by Mr. Steiner himself, all within the years of the Steiner regime. And he was appointed by Mr. Steiner himself. So this shows a close association between the two. And like I mentioned earlier, nothing else can justify his rise of the ranks.
Witness, I'll have to stop you on account of paucity of time.
Sure.
Your Honor, just the last question. Witness, could you please tell how could you adduce the intention of the accused that he acted as a willing accessory to Steiner?
Sure, like I mentioned earlier, it was made abundantly clear from all the interviews that I conducted that Mr. Eco believed in the ethos and the political ambitions harbored by Mr. Steiner. He believed in this policy and he was part of the drafting. So he in fact believed that there was good coming out of this policy, and he supported Mr. Steiner in every capacity, and he was not just an accessory. He believed in the policy.
All right. Points to be noted, Your Honor. That's all from the prosecutor. Thank you, witness. Thank you, Your Honor.
Thank you.
The defense may cross-examine, I think.
Your Honors, the victim is allowed to cross-examine the prosecutor witness.
Go on. Yes. No problem.
Much obliged, Your Excellency. Witness, Mr. Eugene, can you hear me?
Yes, I can.
Okay. Mr. Eugene, you're a journalist, is that correct?
Yes.
Mr. Eugene, would it be correct to say that using election campaigns, Mr. Steiner garnered the votes of the elderly by turning them against the younger population?
Yes, he did use that.
Indeed. Mr. Eugene, would it be correct to say that Mr. Steiner did this by feeding an agenda of that demographic participating, that the youth participated in the usage of drugs. That was his propaganda. Is that correct?
Yes, people voted for him because he convinced the voting population that the poor Protestant was out there to destroy the civilized family traditions of the innocent, hardworking Catholic.
Indeed. But as you stated during your chief, when the prosecutor was examining your chief, that the war on drugs was just a facade, which was a veil for the actual intentions of targeting the poorer sections of the society. Is that correct?
I wouldn't say the war on drugs was just a facade. Maybe I can't speak for their personal intentions. It was, in all honesty, it might be to actually solve the problem. However, the way it was implemented was targeted at the marginalized communities. Yes, definitely.
I have a question for you, witness. I need a little bit of clarification. You said the policy was directed against poor Protestants. You referred to the Protestants as a religious group, I understand. So I would like to know, because you have done extensive research on the trials conducted by the accused, was there any person who was a Catholic and he was convicted for possession or use of drugs by the accused?
Possibly, Your Excellency, but here I would like to give a clarification. The demographics or the population as it stands in Titan was that the Catholics were more on the rich and affluent end, and the Protestants, they were called as the ghetto community. They were more on the lower income earning side. So this policy, it in no doubt it would have. There are instances that where it could have affected the Catholics, but it primarily in larger numbers affected the Protestants.
Do you want to suggest, witness, that only poor people use drugs and the rich do not use the drugs?
That is not my suggestion, but that is even if they do, maybe they weren't tried for their crimes, because definitely the number of people tried, it was the marginalized communities, it was far worse for them.
So coming back to my first question, if it was directed against Protestants, and you said yes, it was directed against Protestants. So naturally, this raises certain questions I would like to put to prosecution and others. Why not the accused was charged with offense of genocide rather than crimes against humanity? But that is not for you. But from you, what I wanted is that the policy was directed exclusively against Protestants.
Your Excellency, in relation to that, it was like this was, I don't know if Mr. Stein, I can't speak for Mr. Steiner's intentions again, but Mr. Steiner used this to his advantage, as in he used it as a political strategy for campaigning. He knew that if he went with this strategy and created a rift, he would get the majority support of the Catholics present in Titan, as they're the majority, and which is why he went with this approach, so that he got the majority votes. And in the process, this created a divide in the society of Titan. So it was more of a political campaign and a strategy effectively to come into power.
No, I agree with your policy. I mean, with your research and findings, but in a way you are suggesting that the accused has not committed crimes against humanity. He has committed another crime for which the accused has not been charged. So naturally, we will have to acquit the accused for this technical deficiency on behalf of the office of the prosecutor, I must say. Thank you, and go ahead. I don't want to pursue this point further, but we may come back to this later.
Your Excellency, the counsel for the victim would like to continue with the cross-examination after answering the query that was raised by Your Excellency, if Your Excellency permits.
If I may interject, I don't think this is the right time. You can make legal arguments when we are at your closing. You're taking evidence, not the time to make legal arguments.
Indeed, indeed, Your Excellency. I wanted to clarify regarding the additional charges. We were strictly specified that we could not bring in additional charges of genocide or other charges for that matter.
It's a mixed.
I mean, I don't want you to bring other charges. What I'm simply saying is, if the crime committed by the accused person is something else, we are going to acquit the accused from this crime against humanity, and there is no question of any reparation for the victims that you are representing. Thank you.
Much obliged, Your Excellency. I would like to continue with the cross-examination of the witness. Mr. Eugene, would it be correct to say that the actions of Mr. Steiner resulted in an increased rift between the poor and the rich?
Yes.
Can you please tell us about how the poor were the worst affected by the anti-drug policy of Mr. Steiner, the war on drugs policy?
Yes, there were several instances of cases where these communities were subjected to brutalities in the form of sexual violence, loot, arson, etc. That is, from my research, they were made the targets of these attacks, and a lot of them underwent hate crimes as well.
So this was a direct result of the ADA policy, is that correct?
Yes.
Do you remember anything about the way in which the interviewed individuals told you about how their trials were conducted?
How their trials were conducted? Indeed, the trials were conducted without really giving the other side an opportunity.
Counsel, the prosecution has already asked that question, and we have that noted. Let's not waste time on repetition.
Indeed. Much obliged, Your Excellency. Mr. Eugene, can you please tell us regarding Mr. Steiner's actions of Mr. Steiner's benefits that he reaped as a result of furthering the agenda, of Mr. Umberto Eco's benefits that he reaped as a result of furthering Mr. Steiner's agenda?
Madam Counsel, these questions have been asked. We have recorded the answers. Do you have anything new to ask? Anything different than what prosecution has asked?
What I want to repeat is we have two prosecutors in this case and only one defense counsel. Sorry to come back to this point again.
And interestingly, what I'm finding shocking, and I was going to raise a procedural objection, that you're treating this examination as a cross-examination. So the victims, under the pretext of cross-examination, get to ask leading questions, and the prosecution is anyways asking is not so big what the prosecution cannot do. So I'm a bit concerned about the way this trial is functioning. You know, I might have to, because I doubt if it goes in the direction of fairness and the human rights of fair trial of the accused. But in any event, please, if you have any additional points, make them and conclude.
Your Honors, the Council would like to ask one final question regarding the harms that were suffered by the victims due to the policy. Do you remember, the one question is, do you think the victims got justice through the judiciary in the present case?
No.
No further cross
questions. Enough answer, I think. I just wish to know procedurally, has the prosecution and victims' lawyers have had a joint conference, or have they seen the witness at the same time? Is that what's?
No, Your Excellency, we are meeting Mr. Eugene for the first time in court today. We did not have a joint conference. The two witnesses that the victim is presenting, Mr. John and the redacted witness, are the only two witnesses with whom we have had interactions before. If that satisfies your question, Your Excellency.
If Your Excellencies may permit the Council to move on with the cross-examination of the prosecutor witness one.
Yes, please.
Much obliged, Your Honors. Witness, can you state your nationality for the record?
Sure. I'm a citizen of the United States of America.
Okay, so you're not the citizen of Titan, right?
No.
Okay, so in order to know the situation and the scenario existing in Titan, you must have visited Titan. Can you give me specific years, like from when to when you have been visiting Titan for the research?
Sure, I visited Titan for the purposes of my interviews, which were...
No, I don't want to know the purpose. I want to know the specific year, from when to when you visited Titan.
I would say maybe 2017 to 2019, between that time, I would say.
But we want to hear the purpose as well. We want to hear the purpose.
Your Honors, the purpose for this cross question is that we want to know, like he is...
You are right, don't worry. As judges, we are entitled to know the purpose, right? We can pose questions to understand the facts.
Yes, Your Honors.
Tell about the purpose.
Yes.
purpose? Ms. Young?
The purpose of the visit? Your Excellency, like I mentioned, I was working on my manuscript. So for that purpose, for all the interviews that I had to conduct, I had to visit Titan.
Okay. In your chief examination, you have mentioned about the interviews. So can you please tell the court who were the people whom you interviewed?
Well, a good journalist never reveals their sources, and I am bound by norms of journalistic conduct. But I will say that they were members of the administration, and they were people associated with Mr. Eco, and yeah, that's about it.
Members of the administration of Mr. Stenner, right?
And associated with Mr. Eco.
Okay. Can you just tell me, in bits, like what they stated that make you conclude that Mr. Umberto Eco was following the precedent of Mr. Stenner? In bits, if you can state what they mentioned.
Sure. They basically brought me up to date on the all the policies and everything. They explained to me. Someone brought up the unitary executive legal theory propounded or suggested by Mr. Eco, that he suggested that there should be a system where there is one executive who has unbridled powers and there are scarce checks, and that executive should be Mr. Steiner. Now, only a close aide of Mr. Steiner would suggest such a policy, and this is what brought me to believe that he wasn't really an accessory, but he really truly believed that Mr. Steiner should have all the power in the world.
Okay, journalist. I mean, you are a journalist, so you must have researched, right? Like when exactly that unitary executive theory was given by Mr. Umberto. Can you state the date?
Yes.
Because you must have researched.
14 December 2016. 14 December 2016.
Okay, it was on December. And when was Mr. Stenner came into power? Can you state that also? When Mr. Stenner?
July 2016.
July 2016.
Yeah, I think so.
What is the relevance of this question, Madam Lawyer? What do you want to say with this?
Your Honors, what I'm trying to establish is that on the basis of the unitary executive theory, the witness is concluding that Mr. Umberto Eco was having the same intention as Mr. Stenner.
If I may clarify to that point, you asked me about my interview, and this is what was brought to my notice during an interview, which is on the basis of which
so
I
ultimately from that interview you're concluding this, right?
Ms.
Whatever
statement and Madam Lawyer, it's a court, it's not a bilateral conversation. Please don't speak unless you've been asked to. I asked you a very specific question, Madam Lawyer. What's the relevance of the timeline that you asked? What's the point you want to make?
Your Honor, the timeline is very short, and it is, I mean, it cannot be justified on behalf of Mr. Stenner to know the intention of Mr. Stenner's intention from July
feeling that
to December.
The speed with which it was done gives me the impression that there was something fishy about it. So it rather goes against your own accused, you know. It weakens your own case.
No, Your Honor. No, Your Honor.
Your own case. That's perfectly fine.
Your Honor, that was the personal belief of Mr. Stenner. I mean, Mr. Umberto Eco. He wasn't aware of the intention that he is going to use the policy in such a way that there is going to be mass execution. So
you can address these points in legal arguments. Let's stick to the facts. Don't draw conclusions. I'm very uncomfortable getting into legal issues at this stage.
Much obliged, Your Honors. Okay, witness, you have stated in your chief examination about the ADA. So I would like to know that what you know about the ADA, as you must have researched on it.
Well, it's already been said, you know, we don't, what more do you want?
Your Honor, what the witness mentioned was what was the outcome from the ADA. She hasn't mentioned about the executive part to whom it rested. So the council is trying to focus on that.
The ADA gave a lot of undue power to, it allowed aggravated police force for one, but beyond that, the ADA gave a lot of power
to be specific, can you state with whom the executive power rested?
to whom the executive power
Mr.
rested.
Mr. Steiner.
Okay, Mr. Steiner, right? Okay, witness, as you're claiming of your research, so can you state that what, were you accompanied by your teammates, or were you the only person looking for, looking into this matter?
I'm an independent journalist, and I've been working closely with Titan for I would say my entire journalistic career. So I've been working on it independently.
Okay, so can you specifically state, your research on
actually
on
it's
which you're taking these?
You will find it in my manuscript very soon, and for the purposes of this for today I have disclosed fairly enough, so I don't know if I can disclose any further, because I've disclosed almost a good chunk of my research, and I am writing a manuscript on the entire process. So
No, but if you're claiming any conclusive statement about the accused, you must state about your research, like what research you did that,
what research I did, as I've already mentioned, counsel for the defense, that under the Mr. Umberto Eco, there were around, under him personally, 1,700 death penalties were issued. He did not allow any legal claims or defense to his opponents. Thirdly, he did not allow any, he gave long-term sentences to children and minors, almost in some cases life sentences. He did not allow any prosecutions against police brutality. Should I expand on this,
you're
or is this
stating
enough?
these facts, so how you derive these facts? How you derive these facts?
It's going all over the place now. She has told us she's done research. She's told us how many times she visited, why she visited. If you have any substantive question to cross-examine, please ask that. If you don't have any substantive point, we'll move on, because it's just wasting time.
Okay, Your Honors. Witness, if you could mention, if you could state that, is it true that the officers who were not following the orders of Mr. Steiner, they were being executed and they were being charged with harsh penalties? Is it true?
Yes.
Okay. You, in your chief examination, you mentioned about the trial procedure. So can you give us an authentic source how you relate those? Trial procedure.
Sorry, I'm not clear with the question.
Okay, I'm just rephrasing my statement. In your chief examination, you mentioned about unfair procedures that were conducted by Mr. Umberto Eco. So yes, how you came across that evidence?
Interviews and my own research, and how I conduct my research is quite frankly a journalistic course you'll have to undertake.
So on the basis of that interview, how can you claim that? Like, there has to be an authentic source to it.
Like I mentioned, counsel for the defense, they were through interviews, members of the administration whose specific names I cannot disclose. I am also bound by certain oaths here today. I have mentioned to the best of my ability that they were members of the administration closely associated in the ECO. Additionally, all my research was done, as like I mentioned. But
the amount of information you have given in terms of your source is enough at the moment. Mr. Defense Counsel, do you have any other questions?
Okay, witness, just for our submissions, Your Honor, if we would like to ask just two questions. Do you accept that the society was undergoing, it was influenced by drugs?
I feel that's a very opinionated question. I can't really.
Of opinion, you can give the answer.
Yes, I guess there was a drug problem, in my personal opinion.
Okay. There was a drug problem, and do you think an action was required in order to curb that drug problem?
Sure, and again, in my personal opinion, action was required. Death penalty, I don't think so. In a note of policy, rehabilitation and reform is what would be recommended, because drug addiction is a problem. It is not a crime.
So in the end, you are saying that Mr. Umberto Eco, by giving an opinion to draft such policy, was justified on his behalf, right?
No, justifying harsh sentences and death penalties is in no way.
No, not of the harsh penalties, but in order to curb that drug problem, he was justified in giving opinion to Mr. Steiner regarding that policy, war on drugs, right?
No, because his opinion was problematic.
Okay, let's not get into this individual fight. Is there anything else you want to say, but you want to ask, Madam Defense Lawyer?
Yes, Your Honor. No, Your Honors, I rest my question.
Thank you. I just had one question for the lawyer for the prosecution, Mr. Prosecutor. Your witness just said, and while your witness is still here, your witness said that she has a source of information which is confidential and which she cannot disclose, which I find a little fishy, because you could have asked for in-camera proceedings, you can ask for confidential proceedings, but you have to give us the source, otherwise how do we trust that?
Indeed, Your Honor. However, the manuscript is still it's incomplete. So, and in accordance, as the witness has pointed out, in accordance with the journalistic norms, she's not, We are
not bound by journalistic norms. We are bound by a statute, and we have to find the truth. We may have to disregard some sections if because the source is not provided. And I think it's the prosecutor's fault and the gap in prosecution's case.
Your Honors, if I may, from the side of the prosecution. Your Honors, the prosecution is willing to provide the manuscript to the court in a sealed cover.
So we can delay the trial and then release the accused in the meanwhile.
Your Honors, after the proceedings for the perusal of the court.
Thank you. It's all speculative. Let's move ahead.
If I may take the leave of the court.
Thank you, Ms. Young, for sparing your time. Thank you.
Thank you, Your Excellencies.
Your Honor, may the prosecutor proceed with the chief examination of prosecution witness 2. All right, witness, do we have you here?
Yes.
Just for timekeepers, please make sure that this is finished in the next 3 minutes, because we'll be here forever. We don't have... the budgets of the UN are not so much.
All right, should the council begin?
No need to ask permissions, just
right.
start, go and get straight to the point. And let's get
could you please introduce yourself to the court?
Right, I'm William Mason. I was a judicial clerk under Judge Eco.
All right, witness, could you please tell how are you related to the present case?
I was a judicial clerk under Judge Eco, so I have first-hand account of how he gave judgments and how his office functioned.
All right, witness, moving further. Witness, you served the accused, right? Could you please explain to the court the approach of Mr. Umberto Eco with regard to following of due process in a trial and human rights?
Right, so he had no regard for fair trial. He always gave the verdict as guilty, and these judgments were written even prior to the hearing of these concerned trials. Further, he really took advantage of the written submissions of the defense in finalizing these judgments. So due process was completely thrown out of the window.
All right, point to be noted, Your Honor. Witness, moving further, to the best of your knowledge, was this approach his own, or was he under some kind of a pressure?
This was his own approach, because he wanted to put in practice his unitary executive theory, and he found Steiner as his ally for the same. Also, he believed that Titan was morally degrading, and therefore use of force was necessary to revive morally in the society.
All right, witness, you mentioned that Mr. Eco was in contact with the executive officials. Is that correct?
Yes.
All right. Could you please tell how? Yeah.
Right. So he was in contact because he used to have closed-door meetings with them.
All right. Witness, were these meetings in consonance with the judicial proprietary in title?
No, this was actually against it, because prior to the Steiner administration, the executive had no say, or no such meetings were supposed to be conducted.
All right. Witness, could you please tell this court how did the accused, Umberto Eco, assist Mr. Steiner?
Well, the accused gave legitimacy to Steiner's propaganda. The system of accountability was rendered completely ineffective, as he did not prosecute the police. Also, public perception of policies of Steiner was boosted. since the public thought that those who were convicted actually did those crimes, and that's why they are being sentenced. But in reality, it was just because he was a hand in glove with the administration and was not giving a fair trial to the accused in those concerned cases.
Point to be noted, Your Honor, the accused give legitimacy to the crimes of Steiner. Moving forward to the last question, witness, could you please tell this court, in totality, how did the conduct of the accused give legitimacy to Steiner?
How did it? I'm sorry.
Give legitimacy to Steiner's propaganda.
Right. How did it contribute to Steiner's propaganda? So both favored a restrictive approach to human rights and did not have any regard to due process. So Mr. Steiner found a trustworthy ally in Judge Eco when it came to prosecuting youngsters guilty to give legitimacy to his propaganda. On the other hand, Mr. Eco found an ally who helped him achieve who helped him put into practice his unitary executive legal theory.
All right, witness, points to be noted, Your Honors. That's all from the prosecutor. Thank you. Thank you, witness. Thank you, Your Honors.
Your Excellency, the counsel for the victims would like to continue. Much obliged. Mr. William, you stated that Mr. Umberto Eco was a close confidant of Mr. Steiner. Is that correct? Yes. Can you please elaborate on this relationship? Right. So, like I mentioned, they were allies in furthering their propaganda, and also the relationship. Officials of Mr. Steiner's administration had closed-door meetings with Judge Eco, which was against the judicial propriety of Titan. Your written.
Sorry to interrupt. Timekeepers, please make sure this doesn't go beyond 1.5 minutes. Thank you.
Your Excellency, I will restrict it to that. Mr. William, can you please remember your testimony where you stated that the accused pronounced multiple youngsters guilty and sentenced them? Is that your statement? Yes. So would it be correct to say that in furtherance of this, majority of people or youngsters did not get a fair trial, were young in age? Yes. Would it be correct to say that many of the accused who did not get a fair trial were not given a trial with a due process, or it was not a fair trial? Right. Can you please tell us with respect to, can you please describe the statement that you made, elaborate on that regarding the restrictive approach to human rights that was taken by Mr. Umberto Eco in the present case? I said this because he gave no regard to fair trial. Like I mentioned, the verdict was always guilty. We were told to prepare the judgments even prior to the hearing of the concerned trial. And he did not take into consideration the written submissions of the defense. He did not give them importance. And that's why I said that he had a very restrictive approach to human. What was the impact of this restrictive approach and the pre-written judgments that Mr. Umberto was writing for the victims of the drug use? A lot of them were unfairly judged, and some of them might not have been guilty, but we'll never know because a fair trial wasn't afforded to them. No further cross questions, Your Honor.
If Your Excellencies, examination of witness. So, witness, can you please state your designation?
I was a judicial clerk under Judge Eco.
Okay, so can you state from when to when have you served the ADA as a judicial officer? I mean, judicial clerk.
The time period?
Yeah,
right.
yeah.
The time period was 11th April 2019 to 2nd November 2019.
Okay, and are you aware, like, when Mr. Umberto Eco acted as a judicial judge of ADA, if you're aware of it?
I was aware of it, but I cannot recall right now the exact date.
Can you just state, like, Mr. Umberto was acting as a judge, like, before you were admitted as a judicial clerk?
He was a judge in the ADA while I worked.
Yeah. So, so you are not aware of any scenarios that existed in ADA before 11th April 2019, right? Because you are not, you haven't joined ADA till then.
Right.
Okay. Okay, so in your testimony, you have mentioned that Mr. Steller found a man he could trust when it come to pronouncing multiple youngsters guilty. So on what basis you have made this statement?
I said this because he wasn't giving a fair trial to these to the accused in the concerned cases. He did not, due process wasn't given any regard, and we were asked to prepare these judgments even before the trial began, and the verdict was guilty always.
Okay. So do you agree, like you have already mentioned in your testimony, that you have seen senior brass of the ADA visiting and having closed door meetings with Mr. Ambarto Eco?
Yes.
So you are completely unaware like what happened inside those closed rooms?
Yes, and the very fact I'm trying to make by saying this was not supposed to happen. It's against the tradition of Titan to be having such meetings.
Okay, so you cannot make any statement whether Mr. Ambarto Eco was being threatened under the closed doors, or whether he was actually deciding or actually conducting meetings in order to execute the war on drugs policy mercilessly. You cannot make any such statements.
These were confidential meetings.
Witness, my question is that I understand it was confidential meetings,
right?
But,
so I was not allowed inside them.
Yeah, so you cannot make any statement what happened in those closed meetings.
No.
Okay. Your Excellencies, I would rest my cross-examination here.
I have a question for you, witness.
Yes.
How long have you practiced law? You are a lawyer, I presume.
Yes.
How long did you practice law?
Around a few years. And I practiced under Judge Eco for a period of 7 months.
7 months.
Under Judge Eco, yes.
Yeah, so you had an opportunity to observe closely the accused while he was the judicial officer only for 7 months.
Yes.
And you base all your conclusions on your observations on those 7 months proceedings.
Right. So in these 7 months, I realized all the illegal activities that were happening in his office, and that is why I voluntarily left after 7 months.
No, I understand, because you have been speaking so authoritatively about the standards of fair trial, justice, human rights, and so on. I am very much impressed by your knowledge and how you could come to those conclusions during those 7 months. Thank you very much. I just wanted clarification on this. Thanks. Bye. I don't have any more questions, and I don't expect any clarification from you as well. Thank you.
Counsel for the victims would like to begin the examination in chief for the victim witnesses.
You two have 1.5 minutes.
Yes, Your Excellency. May we please have the first victim witness, Mr. John Ferreira?
Yeah, I'm here.
Witness, you will now be asked to take a solemn undertaking. Could you please repeat after me?
Sure.
I solemnly declare.
I solemnly declare.
That I will speak the truth.
I will speak the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your name and credentials for the record.
My name is John Ferreira. I'm a former senior member of the police force in Titan. I have served for the force for around 35 years.
What caused the end of your service?
I was terminated from my post when I started an investigation into the custodial death of a 16-year-old boy. I was charged for insubordination and indiscipline, and I was terminated.
All right. And how do you feel about the insubordination charge brought against you?
I believe it was very unfair that was brought upon me, and further injustice was that even while the case against me was pending, there was no thorough investigation which was done. And in between the investigation is when I was terminated from my force, even though after I've served 35 years loyally. So I believe I was done grave injustice in that manner.
All right. How do you think the accused might be linked to all of this?
I believe that the formation of the anti-drug authority and him being the chief drafter of it might have is what led down to the atrocities that have succumbed to in the society, especially in the with respect to drug abuse and the Friends of Neighborhood Watchdog Legions, etc. I believe the chief drafter is one of the major sources for everything that has followed upon in the society of Titan.
All right. Your Excellencies, may I please conclude with one last question? Witness, would you say that you have faced great harm by the hands of the state machinery, and what would you like the state to do about it?
I feel like I definitely did face, because this is the only thing I've been doing for the past 35 years, and I have a couple of teenage kids that I have to put through college, and I was the sole wage earner in the family, and I was terminated unjustly, and I believe I want to be compensated or seen justice for the unfair treatment that I've received at the hands of the state machinery.
Thank you, witness. We sympathize with your problems. Thank you, Your Excellency.
Your Honors, now the counsel for the prosecution would like to proceed with the cross-examination of the victim, which will be on the lines of the examination in chief, but it goes by that name. Witness, you mentioned in your communication to the Office of the Prosecutor that there were some instructions to the police force by the senior administration. Could you please elaborate on that?
So the major instructions that flew down to my ranks was, first of all, was to encounter or terminate any vagabond or anyone found with respect to drug abuse. And if we could not terminate or encounter any of these abusers of substances, we were asked to levy them with the highest charge possible. And multiple times the cases which were charged were on indubious and unsubstantiated evidences, but we were told by the public prosecutors in office that the cases, once it goes to the tribunal, it would not be tried on the basis of these evidences and so on. Yeah.
Your Honor, these statements may be taken on record. Moving ahead, witness, while you were in the police and the police force did these acts which you just mentioned, did you fear any repercussions from the judiciary in Titan?
Yes, the fact that me and my colleagues were terrified because anyone who stood against the Steiner administration or anyone part of the administration were executed.
If I may just clarify, the judiciary as in the ADA, because that was competent to try these cases. Did you fear any repercussions from the ADA?
Yeah, definitely. Because if we did stand against any of these, we were afraid of because anyone who stood against the administration or the ADA, there were repercussions, as in we would not know how things would rain down on us, and there was always environment or circumstance of fear amongst all of us workers once he came into power. So that is one of the major reasons why even though things were not going down in the smoothest of ways, I did not call out.
Witness, if I may, witness, you have mentioned in your communication that you were told that judges in Zuan were in support of the president's, were in support of the vision of the president senior. So yes. Did you fear that since you were conducting investigations or dubious investigation and ill-founded evidence, did you fear that you would be held accountable to the same? Or there was no fear?
The fear was in the opposite manner exactly. If I was not, because the judges believed in eradication of drug abuse and no matter what. So if we stood in the way of that eradication, we would face the consequences for it. That was the fear amongst all of us.
All right. So would it be correct to say that the judiciary bolstered the will of the police because it gave it a free hand because they were also in consonance with the vision of President Steiner?
I wouldn't say the bolster the will of the police, but moreover the administration and flowing down the commands or the executive to the police force.
All right, witness. Your Honor, that would be the end of examination from the side of prosecution. Thank you so much.
Your Excellencies, counsel seek permission to move on with the cross-examination of the witness. Much obliged, Your Honors. Witness, can you please state your age before this honorable court?
53 years.
Okay, so what are your credentials?
I've been working in the police force for the past 35 years. And I think that speaks for itself.
Okay, so what is your experience till now? I mean, the years of experience. Years of experience.
35 years.
Okay, okay. Okay, can you, in your testimony, you have mentioned that your own unit was responsible for the criminal trial against 400 victims. So can you please state why you were doing it?
So
I mean, what was the...
we were given strict administrations was passed down to me from my superiors to ensure to round up all abusers of drug substances. And like I mentioned before, if not termination or encounters of them, to levy them with the highest charges. And these charges were not always substantiated on hardcore evidence. It was sometimes indubious as well as unsubstantiated. But we were always told by the public prosecutors, once it reaches the chambers of the trial, a tribunal, it would not be on the basis of these evidence that they would be tried. And further, the atmosphere of fear which was instilled in all of us public officers, if we did stand against these ill doings, what would come down to us is one of the major reasons why we went ahead with doing this.
Okay, so right now you mentioned that you were doing it because of fear, because there was the environment of fear that was created by Mr. Stener.
I've never directly communicated with him, but his administration and people who worked for him.
Okay. In your statement, you have mentioned that Mr. Stener used to, used to rule mercilessly, right?
Yeah.
Mercilessly. Am I audible?
Yeah.
Okay,
yes.
Okay.
Sorry. Yeah, I didn't mention that.
Okay, so you have mentioned it, and you have also mentioned that he didn't tolerated any dissent from the administration in his administration. Am I not audible?
Yeah. Yes, you did. I think there's a lag. I'm sorry about that.
Okay. So just repeating my statement. In your testimony, you have mentioned that Mr. Stener was not tolerating any dissent in his administration, right?
Correct.
Okay. And you have also mentioned that you were instructed to terminate all vagabonds responsible for substance abuse.
Yes.
Okay. So can you please tell this before the court that who instructed you to do criminal trial against 400 people? Just in your unit, 400 people were tried on ill-founded evidence. So why you were doing it? Was it fear on your head? I mean, you were afraid?
He has already said that, Madam Counsel, and several times in his examination and cross as well. He is the point of fear has been brought out very well. Let's not belabor that point.
Okay. So I would rest my cross-examination questions, Your Honors.
Yes.
I just have a quick after Justice Rashmi.
After you, Judge Kadam.
Okay,
please.
no, a very quick question to the witness.
Yes, sir. Yes, Your Honor.
I would like to know your academic qualification.
I am not fairly educated because I was brought up in a very poor socioeconomic background. I joined the force when I was around 16 to 17 years, and that has been my whole life, sir.
So a person who join our police force can be, at the age of 16, you can join a police force, is it?
Sir, yeah, this was around the years of 1970s, late 70s and 80s. And at that time, the regimens of enrollment were not as strict as it is today. And
it's okay. Yeah. No, now I follow.
Sure. I believe that satisfies Your Excellency.
Yeah, I just want to understand. In fact, my impression was Judge Kadam was going to ask you that very question, but maybe I'll do that. What was the intensity of the fear, you would say? Was it like you might actually be killed if you don't do something, or it's up to you?
So I wouldn't say it's definitely up to me, but there is no specific instances, but there was a fear that there was instances of people who stood up to the administration, and then there were disappearance that happened, or there were vagueness about the whereabouts of such people. So it was an inclination towards understanding that if you did stand up to the administration, there is something bad that is going to befall on us. And like I mentioned before, people in the force were not economically well off, and they were sole wage earners. So that, coupled with the fact that there were people who were already missing, bundled up to the fear instilled in us, sir.
Thank you. If I may ask, you have been removed by the government. Is did that also create some amount of anger and resentment towards the administration and everybody associated with it?
So I support the whole, I believe this structure prevalent in the country is something I believe in and I support, but I believe the people who have been elected to it is destroying the ethos and essence of it. And I stand against the people who are abusing the authority of the structure in place, sir, if I may.
Okay, thank you.
Counsel would like to proceed with the examination in chief of the second victim's witness.
Yes, please.
Witness, can we please hear from you?
Yeah, am I audible?
Yes. Witness, you will now be asked to take an oath. Could you please repeat after me?
Sure.
I solemnly declare
I solemnly declare
that I will speak the truth,
that I will speak the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Witness, we notice your information has been redacted. How would you like to be addressed?
Please call me witness.
All right. Witness, when did you first interact with the officials at the ADA tribunal?
Counsel, on July 20th, 2019, I was charged along with two other people for the commission of the crime, for aiding and abetting the commission of trade in substances, banned substances. And after that, the next year on July 20th, I was called before the accused in his court.
And what was your experience like at the trial?
Counsel, it's a very horrendous experience, which I would want to recollect right now for the benefit of this court. And my trial only lasted for 4 days before the accused, and it was largely a very huge injustice which was done to me, because I was not, even after innumerable pleas for a lawyer, I was not given access to a lawyer, and even the chance for examining the opposite witness was also given only for 9 minutes, and after that they just simply sentenced me to 17 years of imprisonment, merely for finding me somewhere near a building where the police found the drugs.
Witness, do you feel like justice has been served to you through the trial process?
Not at all.
Witness, could you please tell us if similar treatment was meted out to others in your knowledge?
Yes, my own brother. He was killed in the police custody. His trial lasted for 10 days, but he was kept in the custody, and he had injury marks. And because of those marks, as a result of the injuries, he passed away. And and even other people from my community that's belonging to my age group, belonging to the Protestant faith, have encountered similar incidences.
To add on to your point about your community, could you please tell us a little about your background?
I come from a very socio-economically backward background, and my community is notoriously famous for its drug syndicate, and it's not disliked for being poor. And after this, Mr. Jude Steiner came into power in 2016, we started noticing that so many police officers simply keep patrolling our area, and simply they just didn't need any reason whatsoever. They would simply arrest anybody and everybody on their whims and fancies. And this is exactly what the concern about my background is.
Witness, could you please tell us about whether you were given access to legal aid through your trial process?
No, I was not given access to any lawyer. And even when I approached lawyers by myself, they also shooed me away, simply by warning me that no matter what the outcome would be, you would end up in jail.
All right. Witness, it appears that you have gone through a lot of trauma and emotional turmoil. Could you please tell us what you expect from the state in response?
I just need some sort of reparation for the injustice which has been caused to myself and my community.
All right. Thank you so much for your time, witness. No further questions, Your Excellencies.
Your Honors, now the prosecution would like to begin with the cross-examination. So, witness, first of all, we are very sorry for the loss of your brother. We wholeheartedly empathize with you. Could you please tell the court, in your trial, what was the evidence against you?
Sir, your voice broke during the last.
I'll ask again. In your trial, what was the evidence against you?
That I was found near the place where the police discovered the drugs, and this was just based on one person's testimony and nothing else.
And that was the only evidence. Is that correct?
Yes.
All right, witness. Witness, are you aware how long do trials generally last in Titan?
Sir, I'm just 19 years old, and I'm not very much aware of these legal aspects. But yeah, but still, I know that it goes on for 8 to 10 months, sir, not 4 days whatsoever.
Point to be noted, Your Honor. Witness, please tell the court, what did the Supreme Court of Titan record when they overturned your verdict?
Yes, this is a point to be noted here, sir. That is, the Supreme Court reversed this conviction of 17 years, which was posed on me, but on the basis that the accused, Umberto Eco, was a biased person and gave the judgment in a biased manner. Hence, that judgment could not be credible at any cost.
Point to be noted, Your Honor. Witness, in the case of your brother, he was denied bail on medical grounds. Even after he had injury marks on his body. Is that correct?
Yes, sir.
All right, witness. So would it be correct to say that your brother died due to the omission of the accused?
Yes, sir. Yes, sir. The injustice caused to me, my family, and my brother, and the other people belonging to my community, sir.
Points to be noted, Your Honor. That's all from the side of prosecution. The witness may be excused. Thank you.
Your Excellencies may permit the counsel to move on with the cross-examination of the witness. Much obliged, Your Honors. Witness, you are a redacted witness, right?
Yes, ma'am.
Okay, so could you please state what were you charged with, your charges?
I was charged with aiding and abetting the commission of trade in banned substances.
Okay, on what basis you were charged? I mean, okay. Just reframing my question. In your statement, you have mentioned that Supreme Court overturned your judgment, right?
Yes, ma'am. Yes,
on what basis they overturned it?
Ma'am, I'm not very much aware of the reason and all of that, ma'am. I don't understand that, even if someone explains it to me. But I just know that I'm no more supposed to serve as a convict for this offense for 17 years in prison.
But on the basis of that statement, you are making a very bold statement against the accused.
Like,
so
I'm not, ma'am, I do not know the legal provisions, but I know that it was because the judge who passed the judgment, Umberto Eco, was biased, and the opinions of his cannot be taken as a credible opinion. This is the most basic thing I know, ma'am. And he has done this to so many people, and that comes as a ray of hope, this judgment.
So you're in a position not to point even a single statement made by the Supreme Court.
I'm going to interrupt you there, Mr. Counsel. The witness is not a law expert who's expected to analyze the law, and she's already said
okay.
that.
That's obliged, Your Honor.
Time on that.
Okay, in your testimony, you have mentioned about the 3 lawyers. Okay, so what is the credibility of those lawyers who are making this statement against the accused?
Ma'am, as I told earlier, I come from this very poor economic background type of a class. So I just know these people are lawyers. I came to know they work as lawyers. I approached them, ma'am. That's the maximum I can tell you.
Okay, so in your testimony, you have mentioned that you were refrained from meeting any lawyers.
In which testimony, ma'am? Like the pre-trial, that testimony?
The testimony that has been given by the prosecutor to us. I mean, the victim.
Oh, yeah. Yeah, like the Umberto Eco, like when I pleaded to him to give me access to lawyer, he refused that.
Okay, so you haven't met any lawyers, then how can these lawyers come into picture claiming such a bold statement about the accused?
Ma'am, as per fair trial, I was supposed to be allotted a lawyer. Okay. This basic knowledge I have, I didn't get it. So I myself tried to reach a few, and they also gave me the similar reply. They cannot help me.
Okay, witness. Witness, you have mentioned that after 2016, the police patrolling in your vicinity was significantly increased.
Yes.
Okay. So who were behind this? I mean, whom you...
Mr. Jude Steiner and his administration, which includes the accused who also contributed to the policies of Mr. Jude Steiner.
Is this your personal knowledge, madam?
Sir, like it had come to light very quite famously how the accused was aiding the Mr. Jude Steiner. So it's just the knowledge which I have, Your Sir, Honor.
General knowledge. It's not
yes, general knowledge.
It's not
sir.
a proven fact. Okay. You have witnessed cold-blooded war, right?
Not war, ma'am. Cold-blooded murder of my countrymen in front of my eyes.
Okay, so police officials were behind it.
Like I've seen several instances, and police officials, or yeah, you can say that, like people of Mr. Jude Steiner, and the other things, whatever they were doing as a part of their war on drugs or whatever.
Okay, counsel rests its cross-examination questions, Your Honor.
Is this it, counsel?
Yes, thank you, witness.
Yeah, thank you so much for the time of the court. Thank you, sir.
Your Honor's counsel will start with the chief examination of defense witness 1, Martha Remge. Mrs. Martha, just take the oath. Starting with the oath, please plead that I solemnly declare.
I solemnly declare.
I solemnly declare.
I solemnly declare.
That I will speak the truth.
That I will speak the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Okay, Mrs. Martha. Mrs. Martha, can you please state your nationality and age for the record of this court?
I'm a citizen of Titan and I'm 45 years of age.
Okay, witness. Can you state your credentials before this court?
In a professional capacity, I've served as a chief secretary to the Ministry of Justice, Law and Order since 2014.
Can you please tell this court how are you related to this particular case? How are you relevant for this particular case?
I stand here as in my professional capacity since I was the chief advisor to the Ministry of Law, Justice and Order. It was actually in our work portfolio, so that we have to actually collect the data from the proceedings that happened in the due course of the ADA tribunals, like that in Zuan, for which my husband was heading, and then we had to present a report of those cases as to when they did not meet the threshold for the higher degree of conviction, as the Steiner administration had authoritarianly fixed. And then we had to report them to the judicial ombudsman of the said organization.
I got this point, witness. Now, witness, can you please state before this court that what was the experience under the presidency of Mr. Steiner? What did you experience?
Yes, I think as pointed out by the various witnesses that came before me, it is actually very pertinent to note that everyone has described a very persistent and traversal fear of the environment of fear that has existed. And we were no excuse, even being at such high position, there was no excuse for us. The authoritarian regime that Steiner had actually a very adverse effect on us, and we were constantly under vigil, under threats. I personally received a lot of direct and veiled threats, which were against my life, liberty, livelihood, and family. And my husband as well has received those threats. And this regime, this was very disturbing to have been functioning under this authoritarian regime. And if we didn't actually abide by what the president or we were directed by his ombudsman, we had received various threats, and we have seen other judicial officers who have been lynched by the followers who believe that he's some god, and there are instances of people being lynched for the same. And yes, there was a very bad state of affairs where we feared for our life.
So, being a chief secretary of Ministry of Law and Justice, I have a very relevant question for you. Could you please state to this court what kind of environment which was created by Mr. Steiner under his presidency in the Titan?
Yeah, sure. So the judges appointed by him, I'm strictly speaking in terms of the ADA tribunal, because his policy was very much to lash out in a very aggressive sense towards the people who were even assumed to have used drugs in some sense. The judges were appointed and kept under constant scrutiny. As I mentioned, there were constant threats. There were actually targets given to these judges to meet a certain threshold of number of cases, so that in which a very high degree of conviction is made. So as I mentioned, our ministry's job, which was very intrinsically linked with the tribunal, was actually to take a note of all the proceedings that happened on a regular interval, say quarterly basis, and to see if there were certain cases where there was not enough higher degree of conviction that was made. We actually had to send those judgments back for reconsideration, just so that this authoritarian regime could fulfill its whims.
Thank you, witness. Now, witness, can you please state that what was the status of judges under the presidency of Mr. Steiner? How they were treated?
Yes, as I mentioned, so they in a twofold manner. Firstly, they were obviously very much threatened by the authority. There was a constant fear by the authorities. And secondly, the environment in the country as well was very aggressive and extremist to a very large extent. And we saw lynchings of public officials, which also included judges. We saw a lot of judges who were actually persecuted by this very regime just because they did not adhere or failed to adhere to the very strict, unfair policies of this regime.
So could you please state to the court what the judges were doing after getting those threat of abide or perish?
Once they received those threats, the normal trend was to unwillingly follow what the regime was saying, and thereby giving out wrong, morally and ethically wrong sentences.
So can we say that, according to your previous statement, that whatever Mr. Eco was doing was just the act of self-defense?
Yes, because all of us, he also feared for ours and his own life.
Okay, witness. So you have stated in your testimony that Mr. Umberto Eco has always aimed at preserving the sanctity of life. Could you please justify that statement that you gave in the written testimony to the pre-trial chamber?
Yes, sure. So Eco has always been a man very integral, despite his conservative views. He has always respected life in general. So initially, when he shared the view of curbing the drug problem in the country, and he was appointed before knowing how bad this regime is. He was for curbing this problem, and when after he realized how bad the situation is and how bad this authoritarian regime
Witness,
is.
sorry to interrupt, that much will work out. I have next question to ask, and there are only 2 minutes left. So question is, was that act, there was this act of appointment. Mr. Eco was appointed to Ministry of Law and Justice. So I have this question, was that act of appointment of Mr. Eco by the later government, was that politically motivated act?
Yes, absolutely. I think this is very important that this court notes that all of this that is today happening, in my professional opinion and personal opinion as well, is a construct of a drama that has been created, because what is happening here is one government who is trying to clean its image, correct? The same government the vice president is now the president, who served for the same government of which all of us today are complaining about here. And once they offered an amnesty deal to the said person and made sure that he flees to China, now that they're getting negative response from the public, now they're trying to put up a show wherein they want to clean their image and show how justice is being delivered. And they're using Mr. Eco as a scapegoat. Just to show that, okay, there's some justice that is being delivered. There are many other stakeholders in this case, while there is only one accused, which is very problematic. While everyone in here has mentioned about the situation and environment of fear that everyone was facing, I think it's very easy to prove and come to the conclusion that I and Eco were no excuse to the same. And all of this was happening because of the government that Mr. Steiner was a part of. And very ironically, it's the same government who is actually pushing these charges today. And very surprisingly, I think it must come to the note of this court that all the evidence was collected after the new government came into picture. So I do not see any credibility of all the statistics that have been brought before this court, because no independent committee was also formed. Even I, being the chief secretary of the Ministry of Law, Justice and Order, there was no even a single comment made about creating an independent committee for the investigation of all this. And I strongly reject all of this that is happening. Thank you.
Mrs. Martha, thank you for your testimony. Thank you for giving your testimony before this court. Your Honors, I rest my chief examination of Defense Witness 1 with this question.
Your Honors, now the prosecution would like to begin with the cross-examination of the witness. All right, witness, you are the wife of the accused. Is that correct?
Yes.
Therefore, is there a possibility that you will be biased in favor of the accused?
I'm under oath and I promise there won't be.
All right. Why should the court rely on your testimony?
Because I am the Chief Secretary of the Ministry of Law, Justice and Order. I do understand how the domestic laws of Titan work. I have worked very closely with Mr. Steiner, and I understand how the system works.
Right, witness. Witness, were you under pressure as the Chief or Secretary of the Ministry by the Steiner administration?
Yes, absolutely. All of us, all bureaucrats of at any level.
And did you do some acts in contravention to law?
Can you please rephrase that question?
Yes. Did you do some acts in contravention to law while you were the Chief Secretary of the ADA? Of the ministry?
Okay, by definition, the law, I'm assuming you're talking about the domestic law of Titan here. And as I mentioned, this was very craftily and shrewdly developed by the lawmakers. So technically, we never did anything against the law.
Because if I may ask you, were you under pressure to do certain acts by the administration? Yes or no?
Yes, we were under constant pressure in order to
responded by in the affirmative. Let's move on. Let's not repeat the questions.
Yes, yes. All right, witness. Since you have said yes, what is to say you're not pressurized to testify here today?
Because Steiner is no more. He's resting in China.
I'm talking about your husband.
Yeah, again, he's free of Steiner. He's a free man.
All right, Your Honors. One thing to note here, that relationships with the accused are one of the standard factors to factor in partiality determinations that was held in the...
Are you objecting on admissibility or are you objecting on the probative value?
Your Honor, probative value.
Yeah, so then why are you raising that objection now?
Right, Your Honor, I'll just move ahead. Witness, you're here to testify in a professional capacity, is that correct?
Yes.
So how long have you worked with the accused?
Since my appointment 2014.
How is that? Please explain to the court.
Do you want me to explain my work relationship with the accused?
No, since you were at the ministry and he was at the ADA, then how have you worked with him since 2014?
No, I've been working with the ADA in general. So since I'm Chief Secretary of State, whenever his appointment made, I'm sorry if my aging has made any loss to my memory. I think he was appointed in 2016. So since then.
All right. Since you claim that you worked with the accused even during his tenure at the ADA, how is the working of the ADA so intrinsically linked with the ministry?
Yeah, so ADA, just to clarify, ADA is a tribunal. It is something that gives out judgments. It's something that gives out justice in a sense. And I head a ministry that by its name is the Ministry of Law, Order and Justice. If you still want me to elaborate, I would love to.
Right, witness, right. Were you as Chief Secretary to that ministry privy to the day-to-day affairs of the ADA tribunal?
Yes, that was one of the ministry's tasks. Even though
did not the ministry have other things to do, and you as Chief Secretary to do the same, have other things to do?
Are you questioning
see the
what I did
workings of the ADA tribunal?
I do not get. So yes, this was our task as the ministry that was given to us by the Steiner administration, that we have to make sure that the judgments that came out of the ADA tribunals were set.
My question here, witnesses, was it the only task?
No, we had a lot of tasks. If you want, we can discuss those as well.
So were you privy to the day-to-day affairs of the ADA tribunal, more particularly to the work of the accused? Yes or no?
Yes, that is what I'm saying. If you're paying attention, we were constantly required to prepare reports and assure
witness, can you just stick to the questions, because you give a lecture when a single question is asked to you.
Sir, yes, my answer has been yes.
The lawyer is asking you yes or no, so just stick to that.
Yes, sir. Yes, my answer yes. I was aware.
Point to be noted, Your Honors. The witness as Chief Secretary to the ministry, which had other things to do, were saying was privy to the day-to-day affairs of the ADA tribunal and more particularly to the affairs of the accused. Moving ahead, witness. You've talked about instances of threats and the environment of fear. To your knowledge, was a threat objectively given to the accused? Yes or no?
Yes.
How was it given?
As I mentioned, we had received many direct and veiled threats. One of the example as on record are the emails by one Mr. Vidich.
So you acknowledge the existence of the emails, is that correct?
Yes.
Point to be noted, Your Honors. The same is marked as the same is in Annexure 1 of the compromise, and may be marked as Exhibit 1 for the court. Moving ahead, witness. Please tell the court what was the threat in particular.
In that regard, are you asking just for the email?
Yes, the objective threat with regard to the objective threat.
Yes. It was if it stated if we do not adhere to what the regime is saying, then they would silence us as they have silenced many others in the past.
If I
so
may,
it
if
did.
I'm coming here, we are really struggling with the time, and we are very short on time. We are already late, and I do understand that these issues have been already stated in the chief. Unless you want to.
Yes, Your Honor, I'll just conclude. Please tell the court, was there a threat to life and not vague statements like you will be silenced? Yes or no?
In our opinion, we believe silencing does mean life, and in holistic view, as with other threats that we have received, we believe that this represents a threat to life.
Okay, what was the threat with regard to why were you threatened? And that would be my last question.
Are you asking me in a personal capacity?
No, why was Mr. Rico threatened? Mr. Rico, yes.
He was threatened as a warning if he did not adhere to the instructions that were given to him.
Could you please specifically state in the email what was the warning?
I'm sorry, that conversation happened a long time ago. I do not remember the specifics of the email.
All right, witness. Your Honor, that's it. That's it from the side of the prosecution. The witness may be excused. Thank you.
Thank you.
Your Honors, the counsel for the victim would like to go ahead with the cross-examination. Witness, please restrict your answers to yes or no as possible. Due to the paucity of time, I will keep this cross-examination short, very short. Witness, do you think your husband, Judge Eco, believed in conducting speedy trials of the victims? Yes or no?
For believed, no.
Do you think your husband conducted speedy trials of the victims within 4 or 5 days? Yes or no?
Yes, he was forced to.
Are you aware that the accused, even after being forced,
Hello.
yes or no question?
Madam Counsel, very sorry.
Apologies.
You simply can't have a tick mark like a COVID entry form for a witness, because we also need to know what's the background. So I think the witness should be allowed to give an elaborate answer. We also need to understand the background, unless it is unnecessary.
Indeed, Your Excellency, the only reason the counsel said that was because the witness has stated in the examination in chief, as well as the cross by the prosecution in the same case regarding the reasons for the force.
Then don't ask the same questions if the answer are already given. Why are you wasting your time and our time?
Your Honors, I was trying to draw a chain of arguments. I will move to the next question.
No, if you're looking for train of inquiry, you're not supposed to look for a train of inquiry. Cross-examination is not a fishing expedition. If you have a specific question, ask it. Don't intend to create a train of inquiry. No domestic laws allow it.
Indeed, Your Excellency. The counsel would like to move on to the next question. Witness, are you aware that the accused, even after cutting short the time of the trial, issued 1,700 death warrants?
Yes, that is something that has been brought by the government. I do not personally believe the credibility of the same, because this was given by the same government. But yes, this is something that has been brought by the government.
You stated during your testimony that the charges and actions of the accused were done as a result of giving biased judgment due to force. Is that correct?
Can you please repeat the question?
The accused gave biased judgment as a result of self-defense. Is that correct?
Yes. Yes.
During your chief, you stated that you were aware of the day-to-day activities of the tribunal. How do you not know whether 1,000 death warrants were passed or not?
Ma'am, the only thing that I'm saying, the statistics that have been given as an evidence are given by the government, and I do not believe that this government, who was actually involved with Steiner in the same capacity, is a credible source to give out information, especially when the elections are coming up. And this, I believe, is a whole setup to clean their image.
Indeed. Witness, do you consider your husband as a biased judge?
Not at all.
Your husband, you stated during your examination that your husband was appointed and his appointment was politically motivated. Is that correct?
Yes.
Can your husband still be understood as unbiased?
Politically motivated for the current government. I mean, I'm sorry if I got the question wrong. The political motivation is for this trial. I'm so sorry. I would like to correct myself, but his appointment was not. I'm sorry, I misheard. I'm so sorry.
Witness, do you know about the judgment of the accused regarding the 19-year-old victim, which went to the Supreme Court and was overturned as a result of bias?
Yes, I am aware.
Did it occur to you that were such judgments normal in the course of day-to-day activities of Mr. Umberto Eco?
Council, as I mentioned, the domestic legislations that were drafted by the lawmakers of that regime and the behavior of the regime actually made it compulsory for those judgments to exist. And I'm so happy that the judgment that you're talking about actually took place after that Steiner had resigned. And I'm very happy that an appellate body exists so that those wrong decisions can now be scrutinized.
Did it ever occur to you during your tenure as a judge to appeal to the Supreme Court and explore alternative remedies regarding the threat that you were supposedly facing for your life?
Since ADA is an independent authority and I was in a constant state of fear, I tried my best to resist with the authorities. I tried my best to actually speak to someone above me, but it was again the authorities. So it was the oppressors it was only the oppressors who I could report to. So I could not find an actual way to rectify this, and I was constantly under vigilance.
Your Excellency, I see that my time is indeed. I no further cross questions.
I just have one question.
Yes, Your Excellency.
Mrs. Martha, I'm just curious to know, your husband was instrumental in drafting or interpreting the Constitution in a manner which gave a lot of authorities to the president. And then we suddenly hear all this, that he's so innocent and he was under fear, threat. When do you think his actions were voluntary, and when did his actions became actions committed under threat?
Yes, thank you, for Excellency, for that question. I believe the timeline in this regard plays a very important role. Since my husband is a conservative ideologist, he shared his passion for removing the violence of drugs that was so much embedded in our country. He still is against drugs. And when he heard about the Steiner regime wants to do something against drugs, he did submit a paper, he did work on a policy. However, he was actually very happy when his appointment was made. It was after his appointment that he discovered how the system of this authoritarian government actually works. And probably I think he even though, as you mentioned, did propose the policy of unitary executive authority, as is practiced by probably the most developed democracies like the US itself. He never hoped that it would turn into an authoritarian regime.
Thank you.
Your Excellency, we'll start with the Chief Examination of Defense Witness 2, Mr. Umberto Eco. Mr. Umberto Eco, just take the oath before this honorable bench. I solemnly declare. I,
Umberto Eco, solemnly declare
that I will speak the truth,
that I shall speak the truth,
the whole truth,
and
nothing but the truth. Okay, Mr. Umberto Eco. Now we'll move on to the chief examination of yours. So could you please state to the court what is your nationality and your age?
I am a citizen of Titan and I'm 51 years old.
Okay, witness. Can you state your credentials for the record of this court?
Yes, I have been a professor of criminal justice in the Central University of Zuan from 2007 to 2013. Post that from 2013 to 2015, and again from 2016 to 18, I worked at the Office of the Attorney General under him. Thereafter, I was appointed as the Chief Judge of the ADA Tribunal from 10th January 2019. And after my resignation in 2020, I have been appointed as a senior consultant to the Ministry of Law, Justice and Order under the government of Titan.
Okay, witness. Being the accused tried before the pre-trial chamber, what defenses you took to justify your acts under the regime of Steiner?
My defenses were twofold. Firstly, the actions that I conducted, my omissions, my actions were pursuant to a constant threat. I was under duress. I had no other choice but to stay within the confines of law and comply with my constitutional and legal duties that I had by virtue of the position. And second was that I never had an intention, a mens rea, or the willingness to personally, intentionally commit those certain acts. And I had to commit those under self-defense because, as stated by the chief secretary of the Ministry of Law Justice before me, we received constant threats, indirectly as well as directly, for our life and limb. And in order to protect ourselves and our interests, I was bound to act in a certain manner.
Okay, witness. What was the kind of relationship you shared with Mr. Steiner? Could you elaborate more on it, like how and what shows? I mean, how it was shown and discussed in the media? How it was shown your relationship with Mr. Steiner? How media showed it?
So I was appointed in as the chief judge. Post that, I was only rendering academic service in terms of providing legal assistance, in terms of suggestions and recommendations to Mr. Steiner. I had no personal relationship with him whatsoever, and the media portrayed it in a way as if I was a close advisor to him. However, in my opinion, there is a personal and professional opinion. There is no authenticity that should be regarded or ascribed to such media reports without their verification. And throughout the regime, by virtue of the position that I was holding, I was simply performing my constitutional and legal duties by working under Mr. Steiner, who was the president of the state.
Okay, witness. Now we'll be moving on to the next question. Have you ever given any opinion to Mr. Steiner with regards to these policies?
Yes, I have. It was on one occasion when I was appointed by him as a member of the drafting committee of the war on drugs policy. By virtue of being one of the many members in the committee, I had given an opinion. However, at that time as well, I was unaware to the fact that that policy would be later abused and misused by his administration in order to commit certain heinous acts.
Okay, witness. Have you now? Next question is: have you argued in favor of unitary executive theory for the Titan?
Yes, so I did argue in favor of a unitary executive theory. To that end, I'd like to submit that I had made a memorandum while I was working with the Office of the Attorney General and had submitted the memorandum to the ministry. Now, post that, the memorandum was discussed very actively by the legal community. And at that time as well, when I had done that, it was December 2016. And Mr. Steiner had come into power in mid 2016. So, in a brief, short period, I was blatantly unaware of what was going, his true intentions, motives, or objectives behind why, how, and the manner and mechanism through which he would implement this theory and take over absolute control over the regime.
Witness, can you please state to the court why did you accept the offer of becoming the judge at ADO Tribunal of Zuan province if you were aware of such happenings in the Titan?
When I took up the position, I was aware that I wanted to avoid any sort of greater harm, because if it would not have been me, it would have been someone else in my position. And as additionally, if I would not have accepted, it could have caused harm to my life as well, as was done with other public officials.
Okay, witness.
Mr. Counsel, your time is up. Can you just summarize?
Indeed, Your Highness, I have just two last questions. Just briefly mention it. In your testimony, you have mentioned that judges were not given discretion. It was, their discretion was highly curtailed by the environment. So could you just briefly elaborate that? What do you mean by that? What you was trying to testify in your testimony?
Yes, sure. So if you can refer to the evidence of 21st September 2019, the email sent by Mr. Nemanja, he specifically stated that they have silenced the dissenters before and they will continue to do so. In addition to that all the public officials that raised their opinion were false accusations were raised against them of corruption, dereliction of duty, obstruction of justice. They were sentenced to harsh sentences, and there was a pattern specifically against all the prosecutors and judges for all the illegitimate sanctions that were imposed against them.
Witness that which work out. Just the last question. Could you please state before this court that why did you act in the direction of Mr. Steiner? Just briefly.
As I stated, it was solely out of fear. I was performing my legal obligation to obey the orders of my superior.
Okay, witness. Your Honor, I rest my submission for Chief Examination of Defense Witness 2.
Your Honors, now the prosecution would like to begin with the cross-examination. Save the time of the court witness. Kindly keep your answers brief and to the point, please. Witness, could you please tell the court what was your role at the ADA?
I was the chief judge of the ADA tribunal and not the ADA.
Right, got it. Were you also responsible for admitting and authorizing cases against the public officials by victims of abuse?
The ADA tribunal did have the authority to admit cases if any charge was raised to that effect.
Against public officials, right?
If any charge was raised, yes.
Right. Please tell the court, why did you join the ADA?
I think it's asked and answered. I answered that in my chief, that the reason why...
Could you please tell the court, was it out of your own...
It has been already said in the chief, no need to spend time.
Right.
Yeah.
So was it out of your own violation? Yes or no?
Or no, because if I knew if I would not have done that, I would have perished.
Witness, then why in your email, which the existence of which has been confirmed by your wife, have you expressed gratitude for the appointment as Chief Judge of ADA?
As you can see, all the public officials and even the ministers that showed their dissent towards their to any sort of...
My question here, witness, is why did you express gratitude if it was not out of your own violation? You were pressurized to do so.
If I have been given an appointment, as I said earlier, it was for the greater good, for the greater happiness
So you were
of the
happy
people.
that it was for the greater good and for the greater good. You were happy about that? Yes or no?
No, I made sure that due process and fair trial is followed during my regime during my stint as the chief judge of the ADA tribunal, and therefore since I was acting doing my legal duty and I was given the appointment,
Thank you, witness. That would be it. Thank you. I'm glad you brought up the point of due process, and you said that you were guided by the letter of law. Do you consider due process to be a part of the law?
In my personal opinion, and due process is again subjective in nature. What kind of due process are you referring
Due process,
to?
the procedural law, that the rights to the accused, things like that. Do you consider that to be a part of the law? Yes or no?
Law or rule of law, that is the domestic law.
The basic trial, the basic rights, like the rights to the accused, rights to fair trial. Do you consider that to be?
Sorry to interject you on that. We know what the law is in the field of international law. I don't think it's going to help to ask a witness of fact on what it means.
All right, I'll move ahead to the main part of my question. Why did you fail to follow, since you said you always try to follow due process, why did you fail to follow due process and rights to accuse, basic rights to accuse, as per the testimony of victim witness number 2?
I do not think I failed to follow that. If you want to ask me, did I fail to follow, then no.
All right, I'll move ahead. Were you aware that you are a key asset in Steiner's criminal design?
In his criminal design, are you asking me if there was a criminal design in picture?
Yes, that too. And were you aware that you are a key asset in his design?
I don't think I'm competent to comment on his criminal design and the existence of the same.
Do you think you were a key asset to his design at large? You think you were a key asset in his vision of perpetrating war on drugs policy?
No.
All right. So you could be easily replaced. Is that correct?
If Mr. Steiner wanted to, sure.
Point to be noted, Your Honors. Witness, you have served at the ADA in multiple capacities. So do you consider yourself to be a legal expert?
I have not served in multiple capacities in the ADA.
In the ADA as well as the Attorney General's office in Central University. Do you consider yourself to be a legal expert?
I have a fair amount of knowledge to my.
That would be it. Are you aware about the conventions ratified by Titan?
No.
All right. Point to be noted, Your Honors. Did you have any intention to support Mr. President in his policies?
The current president or Mr. Steiner?
President Steiner.
President Steiner in his policies.
Did you have any intention to support him? Then why have you asserted your willingness and commitment to implement his vision and policies in your email?
Because as I said earlier, if I would have, for example, if you look at my next email, the moment I showed my apprehension to obey to his regime,
I got it,
witness. Yes, so I had no other choice.
So doing a thing under pressure is one thing, but to assert your willingness and commitment is the other. Why did you assert your willingness and commitment? That is my question.
I think willingness and the
Should I read out your email to you? Should I read out your email to you, if I may? This is my last question, Your Honors. In your email, you have mentioned that, if I may, just a moment, that we should strive to implement the vision of Mr. Steiner, as you have mentioned. Is that correct?
What else? I did not have a choice. If I've been received a mail from the chief,
but all right, that would be from the side of the prosecution. The witness is not answering them. He's just
answering. It's just that she's giving answers which are uncomfortable to you, but the witness is answering.
All right, Your Honor, due to the paucity of time, I would like to conclude. Thank you.
Witness, do you think a fair trial can be conducted following the principles of natural justice in only 4 days? Yes or no?
Are you asking for my personal opinion or professional opinion?
Professionally, as a judge.
As a judge, if all the 3 principles of natural justice are followed, then sure.
Do you remember you denied bail to a victim who was accused by your very court?
I take up hundreds of cases on an everyday, weekly basis. I am not sure which case you're referring to.
This case refers to a bail application that was filed as a result of multiple injuries.
Okay.
Yes, injuries which resulted in the death of the victim a few days later. Do you remember denying a bail?
If I'm not wrong, the death was caused by the police forces when he was in the police station under the police custody. So,
indeed, but you denied the bail when an application for bail was filed. Is that correct?
The bail application, I am sure, would have been rejected after hearing both the parties and reaching the conclusion that bail at that time was not in the interest of justice.
Witness, please restrict your answers to yes or no. Do you think a fair trial involves not allowing the accused to have legal representation?
A fair trial, both the parties need to be given an opportunity to be heard. As per me.
Do you think a fair trial involves not allowing the accused in that case to have a legal representation? Yes or no?
If the accused has been given an opportunity to be heard, and then I believe it is acceding to all the principles of a fair trial.
Is it correct that summary trials are not conducted for serious crimes?
It depends from regime to regime. The domestic laws differ all across the globe.
Please restrict yourself to type.
I'm sorry, there's a breakage in your voice.
I'm sorry, can you hear me?
Yes, I can.
My question is, do you think, is it correct that summary trials are not conducted for serious offenses?
It depends, as I said, from all domestic law to domestic law. It varies from regime to regime. There's no uniform law with respect to summary trials.
With respect to Titan, can you confine yourself to the state of Titan?
In Titan, we have the trial regime, the trial mechanism is given in the black letter of law. You can just refer to the law itself. It's a public record. Why are you asking me?
Because you are here for conducting summary trials of serious offences, witness, which is why I'm asking you. Can you please recollect and tell us whether you gave a speech on March 13th at the inauguration of Courtroom 5?
Yes, I did.
We request Exhibit 2 to be marked, Your Honours. Is it true that you have given multiple legal opinions on multiple policy decisions undertaken by Steiner?
The opinions were such that I had no other choice but to support the war on drugs policy publicly, because if I would not have done that, even I would have been lynched and sentenced to a harsh sentence. And if you are
But you
referring
have
to
given opinions, is that correct? Yes or no?
uh, yes, those were my professional opinions for which I had no other choice but to give those opinions.
Indeed, indeed. That is noted. Are you aware of the Friends of the Neighborhood policy that was created as a direct result of the policies that were given by you?
The Friends of Policy was, yes, it was created, but not a direct result of the policy because it was
You aware
given by me. I agree with the first
Are you
half of your
aware of the
question. I agree. Yes, I'm aware of and I agree with the first half of your question, which is the existence of Friends of Neighborhood, but I do not agree with the latter half of your question.
that shall suffice? Are you aware of the deaths that were taking place as a direct result of the Friends of the Neighborhood policy implementation?
uh, from all the popular media that came across and from newspapers, I was aware of the police brutality and that was being undertaken.
Is it true that the threats that you stated about in your examination in chief were never imminent to harm your physique or your family?
No, it's not true. They were imminent.
For example, when you were in your courtroom, was there any threat as a person holding a revolver to your head to give a judgment of execution?
If Okay, so imminency may not per se be defined as holding a revolver over someone's head. However, if I would not have followed the regime in terms of, since you have asked a general question, I would like to elaborate that since if I would not have followed the regime in terms of not, if I would have been lenient or if I wouldn't have fulfilled that certain threshold of minimum number of convictions, or if I would have opposed the policy publicly, then the only recourse or the fate that me and my family would have seen is, of course, death, because we were given veiled and direct threats, even in the closed door meetings that were held in the courtroom with the
Let's time
executive.
it up, Madam Counsel. You can ask one last question and there'll be 10 seconds to respond.
Indeed, Your Excellency, that was going to be my request. My last question is, witness, did you ever find yourself in a situation where you had to either save your life or that of the sentenced person in that case as a judge?
My life or of the sentenced person? I'm sorry, I don't think it's a
Or
very
accused in that case before?
I believe a parallel or cannot be drawn between if I'm standing in a courtroom as the chief judge and the accused who's been sentenced for his crimes of drug consumption or use of psychotropic substances cannot be compared to my life at that point of time. And I believe it's not relevant
No further
to the
cross
case
questions,
at
Your
hand.
Honor.
That's fine. I just have one question. What do you have to say on the decision of the Supreme Court, which said that you are a biased person?
To this, Your Excellency, I have one submission. If you may refer to the email dated 21st September 2019 that I had sent to Mr. Nimanja, who's the chief of the ADA, I have explicitly shown my discontentment towards their request for being biased, and I have mentioned that I do not wish to be biased. But again, unfortunately, the same result I faced, and I was told that that they would oppress and silence their dissenters. So that is what I would like to say.
Thank you.
Honors, now the prosecution would like to begin with the closing statement, if I may.
Yes, please.
Honorable judges of the trial chamber. At the very outset, the prosecution would like to state that no one better than your honors understands the sanctity of the chair in which your honors sit and administer justice. The accused in the case before this case today is responsible for vitiating that sanctity by defeating all established notions of justice. Your honors, the instance of prosecuting judges is in fact res integra before the ICC. However, judges have been convicted and held criminally liable for acts aiding in the commission of crimes against humanity ever since the time of the Nuremberg trials. The prosecution, in due course of its submission, prove beyond reasonable doubt that the accused is liable for crimes against humanity or murder under Article 7 of the Rome Statute. Your Honors, when the state turns against its citizens, they look up to the judiciary as a beacon of hope, which will protect them from the whims and fancies of men with power. However, Your Honors, it pains me to inform this court today that these victims have ironically been slaughtered by the sword of justice. Therefore, the prosecution implores this court to set a precedent for all times to come that these acts of impunity by judges are not repeated in the near future. Since the contentions have already been laid out by the prosecution in its opening statements, the prosecution would straightaway delve into the substantial portion of the same. Your Honors, firstly, the contextual as well as the material elements of crimes against humanity or murder have been fulfilled. Your Honors, at the very outset, I would like the court to note that the requirement for Article 7 is that there has to be a larger attack, which in the instant case were perpetrated by the Steiner administration, and only the acts of the accused should be a part of the same. Your Honors, the attacks in the instant case, by the larger attacks by the Steiner administration, were widespread and systematic. Your Honor, since this is a disjunctive requirement as per the Savick case, the prosecution would only prove the widespread criterion. Your Honor, the same case was widespread as it was carried out on a large scale, frequently, and the same was corroborated by prosecutor witness 1. The estimated number of casualties, Your Honors, were 30,000, and the same is a fact on record. And Your Honors, this court has taken cognizance in cases in which as low as 200 civilians were affected. The name of the cases are the Prosecutor versus Katangna and the Prosecutor versus Chui, which find a mention on footnote 19, page 3 of the complaint. Your Honors, the second requirement is that the acts of the accused form a part of the attack. Your Honor, it's important to note that the accused should carry out should not be asked to carry out the attack. It just has to be a part of the same. And this it was set in stone in the case of Prosecutor versus Corday, which finds a mention on footnote 20 of the writ submissions. Your Honors, the prosecution would like to contend that it was the concerted action of the accused in conjunction with the administration which resulted in the perpetration of crime against humanity or murder. The same has been corroborated by victim witness number 1, who testified that the police did not fear any accountability because prosecutors told them that judges are in support of Mr. Steiner. Moving ahead, Your Honors, the attacks were directed against the civilian population. That is also a contextual requirement. Your Honors, I would like the court to note that the term civilian population has been given a very broad connotation by this honorable court, as it includes within its ambit all people who are not members of the armed forces. This was held in the case of Prosecutor versus Gombo. Your Honors, moreover, as far as the directed against requirement is concerned, civilians should be the primary object, not the incidental victim. Your Honor, the prosecution admits, even though the policy on paper was to eradicate drugs, however, the testimony of prosecutor witness 1 and victim witness number 1 make it emphatically clear that the same was just to eliminate civilians, particularly belonging to the disenfranchised minority Protestant Christians, which was touted to be the epicenter of drug-related crimes by the administration, and the same finds a mention in the compromise on para 14. Your Honors, moving ahead, that there existed a state and organizational policy. Your Honors, for ordinary crimes to rise to the level of crimes against humanity, state policy is an essential. And a state policy may not be inherently criminal, but the means to achieve the same may involve commissions of crimes against humanity. The prosecution for this relies on the Kovoka case, wherein The non-criminal plan of creation of a Serbian state was achieved through persecution of Muslims and Croats, which was recognized by the appeals chamber. Your Honors, in the case at hand, the war on drugs policy was on the face of it a non-criminal policy, which was executed through commission of a series of crimes, and the same has been corroborated by victim witness one as well as prosecutor witness one. Your Honors, coming to the most contentious issue as to whether the actus reus element has been satisfied or not in the case at hand. Your Honor, the actus reus element requires that the accused killed or caused death of one or more than one person, Your Honor. In the Bemba case, it was held that death may either result from an act or an omission of the accused. The accused in the instant case, Your Honors, has caused death by both acts and omission. Firstly, Your Honors, he has caused death of individuals by issuing the highest number of death penalties, which was summarily executed, and the same can be ascertained by referring to para 4 of the compromise. The prosecution submits that the accused should be held criminally liable for the same, as the legality of these award of these death penalties should be ascertained on the touchstone of the hierarchy of applicable law to this court under Article 21 of the statute, which gives a precedence to conventions and principles of international law over national laws. Your Honors, it is very pertinent to note here that Article 6, Clause 2 of the ICCPR stipulates that death penalties shall only be awarded in the most serious crimes. And ICCPR and Titan is a signatory to ICCPR, as well as the UNHRC has proclaimed that drug-related offenses and drug trafficking cannot be construed as the most serious crimes. Moving ahead, Your Honors, therefore, the prosecution contends that these death penalties are illegal and should be considered as acts of murder. Furthermore, the accused also caused death by omissions, which can be ascertained, which can be corroborated from the testimony of victim witness number one, wherein, Your Honors, because he gave a free hand to forces to perpetrate crimes against humanity or murder, as well as the case of victim witness number two, in the case of his brother, wherein his death in custody was directly linked to the omission on part of the accused, which was in furtherance to the state policy of Mr. Steiner, and that should be considered as an act of murder. Your Honors, I would just like to wrap it up in a matter of 2 minutes. According to my clock, there are 3 more minutes remaining. I just like to wrap it up. Your Honors, the intent requirement is also fulfilled because, firstly, the SC on record note that he was biased. What could be a testament better than that for ascertaining intent, Your Honors? And Your Honors, the fact that he willingly took charge as the Chief Judge of ADA can be construed from showing his gratitude after his appointment, which was rated by defense witness number 2, and his continued presence as Chief Judge of the ADA. Moving further, Your Honors, the requirement of knowledge has also been fulfilled because, Your Honors, the requirement because he was in touch with the officials of the ADA, which was corroborated by prosecutor witness 2 as well as in his emails. Moving ahead, Your Honors, how the defense of duress is not applicable. This would be perhaps a contentious issue in this case at hand. Your Honors, first of all, the prosecution would like to state that in the case of Eredemovic appeal, the majority did not recognize duress as a complete defense to crimes against humanity, which involved the killing of innocent human beings. Moreover, Your Honors, as per the requirement of Article 31, there was no imminent threat. And Your Honors, even if the prosecution accepts that there was a threat, he was threatened only to the extent that he should dismiss at least 50% of the applications against illegal detentions, which is the threat mentioned in the email. There is no other objective threats, Your Honors. And Your Honors, but the accused in the case at hand, he went to the extent of issuing the highest number of death warrants, as well as denying victims basic rights. And therefore, he willfully went way beyond the threat. Your Honors, moving ahead,
Counsel, I have a question for you.
Please, Your Honors.
You just referred to a decision of ICTY where duress was not admitted as a valid defense in crime against humanity. Can you just give me some more details of that decision?
Your Honors, it was mentioned in para 19 of that particular decision.
There was a decision to the same effect in 1997. I would like to draw your attention.
Please, Your Honors.
Eredemovic trial, sentencing appeal, 7th October 1997, where ICTY held that defense of duress is not admissible for crimes against humanity. However, William Shabas, the commentator, talking about that decision, what he has said, and I would like to quote, the consequence of the provision in the Rome Statute is to set aside the precedent established by the Yugoslav tribunal and to reinstate the defense of duress. So what do you want to say about this one?
Thank you, Your Honors, for that input. With regard to that, Your Honors, I agree to the fact that the defense of duress has been installed in the Rome Statute by virtue of Article 31. However, Your Honors, there have certain standards which have been set for the same. And one standard is that there must be a threat. And as I would also like to cite a commentary here, the commentary of Mr. Ambos on his treatise to international law, wherein he held that an abstract danger or simply an, Your Honors, you're on mute, if I may point out. Your Honors, Your Honor, you're on mute.
I just want to clarify that I'm not concerned with the requirements, whether it has been fulfilled in the instant case or not. I am only concerned with the fact or the position of law, whether defense of duress is admissible for crimes against humanity in this court. I'm not referring to ICTY, in this court or not, in view of the provisions of the Rome Statute. As to whether the accused can validly claim the defense of duress or not is a
Your
very
Honors,
separate
going
issue.
by the strict text of Article 31, yes, but taking into consideration the jurisprudence regarding the same, no. Thank you, Your Honors. Your Honors, moving ahead, that first of all, Your Honors, as I stated, an abstract danger or simply an elevated probability that a dangerous situation might occur would not suffice. And there was no objective threat in the case at hand. And now, if the defense of duress falls, the culpability lies on the accused. And Your Honors, if you want me to address the question as to why Article 31, the prescription of law is not applicable, if I may, Your Honors. Your Honors, if I may address the question of why prescription of law under 33, Article 33 is not applicable.
But in the next 30 seconds.
Yes, Your Honors. So, Your Honors, if you read the bare text of Article 33, that says that there is an exemption when there is an order from government. And therefore, I would like to rely on Article 31 of the VCLT, which mandates an interpretation of the term within its ordinary meanings. And a judge cannot be legally obligated to obey the orders of the government. Moving ahead, Your Honors, to the last point, that the accused incurs liability under Article 25, 3C of the statute as a willing accessory. Your Honors, there was a substantial contribution in the case at hand, and in the case of celibacy and nullity, it was held that all acts of assistance lend or acts which lend support or encouragement fall within the purview of aidment and abetment. And lastly, this one last case which I would like to cite, in the case of Brandon appeal, Auric appeal, as well as the Taishima appeal, it was noted that any act of non-interference coupled with the position of authority held by the accused amounts to a tacit approval and encouragement to commit the crime. And lastly, his position as the Chief Judge of the ADA and his non-interference resulted in a substantial encouragement to the forces committing crimes against humanity by rendering the system of accountability ineffective. With these submissions, Your Honors, the prosecution would like to rest. And now, with Your Honor's permission, the prosecution would like to proceed with the prayer.
Yes, please.
Yes, Your Honors. Wherefore, in light of issues raised, arguments and merits, evidence is supplied and authorities relied on. It is humbly prayed that the accused, Mr. Umberto Eco, committed the acts of crimes against humanity or murder under Article 7(1)(a) of the Rome Statute. Mr. Umberto Eco is individually criminally responsible for the acts committed by him as a willing accessory under Article 25(3)(c) of the Rome Statute. These are the submissions, Your Honors. If Your Honors have any inquiries, the Council would be happy to answer them. Thank you, Your Honors. It was an honor arguing before this honorable court.
Your Honors, with your permission, the counsel for the victim would like to proceed with the closing arguments on behalf of the victim.
Yes, please.
Much obliged. Much obliged, Your Excellencies. Your Excellencies, a criminal trial is a voyage in the search of truth. We stand before this honorable court for a serious offense committed by the accused, which is within jurisdiction of this court. The victims today will try to prove that there is a doubt in relying on the opinions of the defense because they only talk about intentions of third parties and they talk about unreliable and shaky defenses. There is no substantive evidence to disprove the evidence of the victims in the present case, Your Excellencies. The victims have suffered tremendously through the actions of the accused.
Interject, madam. Does the defense have to prove that they're not guilty, or the prosecution has to prove?
It's the burden on the prosecution, Your Excellency.
How can you shift the burden on
I apologize if I...
It's very fundamental. It's a fundamental principle of the criminal system.
I apologize if I communicated it that way, Your Excellency. Your Excellency, I tried to prove that there are I tried to say that there are inconsistencies in the defense testimonies, which we will prove through the course of the victim, through the closing statements. However, the actions of the accused in the present case are not fair, and that is the reality. The accused awarding death penalties did not care if the victim was an innocent person or not. There is no reason, no justification or mercy in the actions of the accused, even when the person was suffering several health emergencies, as it was highlighted by the victim witness number 2. Despite doing everything in their capacities, the victims were not able to stop him because the accused in the present case has the backing of the state, Your Excellencies. Your Excellencies, the victims in the present case would like to rely on the judgment of the prosecutor versus Jermaine Katanga, the citation being ICC 01/0401 and 07. We would like to rely regarding the reparations that were awarded in that case, Your Excellency. They understood the harm that was faced by the victims. In the present case, Your Excellencies, the victims are under constant fear. They saw the relatives dying. They lost
for crimes against humanity for murder?
No, Excellencies, I'm trying to talk regarding the case of reparations in that case, Your Excellencies.
But do you have a case to cite on crimes against humanity for murder?
Indeed, Your Excellencies. The Council would like to come to that, Your Excellencies. And with respect,
there's no point giving this whole general background of general lecture on reparations. You may assume we know a little bit of law.
Indeed, Your Excellencies. Your Excellencies, in that case, the Council would like to draw your attention to Article 75, Rule 97, and Rule 85A of the present case, Your Excellencies. And we would like to talk about how victims satisfy the tests in the present case that have been laid down by a slew of judgments in the present case, Your Excellencies. The victims of the Steiner regime, which was oppressive, violent, and...
Tell us the law. You said, and there is a slew of decisions. Tell me a slew of decisions on crimes against humanity for murder.
Indeed, Your Excellencies. Your Excellencies, the first one that we would like to cite is with respect to Lubanga's decision on indirect victims, the citation being ICC 01, paragraph number 47, Your Excellencies. Your Excellencies, there they held that for a victim to claim reparations, a causal link must be established between the crimes for which the person was convicted and the victim's harm, Your Excellencies. In the present case, the victims through the testimonies have tried to prove that in the present case, the actions of the accused resulted in direct harm to the victims. That is the reason why they claim reparations in the present case, Your Excellencies. The next decision.
The point of causal link. Can you show us the causal link that the actions actually resulted into harm? And of
Indeed, Your Excellencies. Indeed, Your Excellencies. For this, the Council for the victims would like to rely on the testimony of victim number 2, Your Excellency, that is the redacted witness, and we would like to show the causal link through the connection that was made between the accused decisions and the overturning of the same by the Supreme Court of the state of Titan, Your Excellencies. Your Excellencies, if you notice, the Supreme Court would not make a remark regarding the bias of the accused in light or in humor, Your Excellencies. Moreover, another addition to that is with respect to the death of the brother of the victim that was caused as a direct result of the link that was made between the accused and the present case. The accused's conduct resulted in
link? I'm still looking for the link. I don't know. Can you tell me where is the link? You gave me 2 events, but you haven't connected them.
Your Excellencies, the link in the present case is the conduct of the accused, Your Excellency, with regard to not giving the due process for the victims in the present case and not giving them opportunity to be heard in the present case, Your Excellencies. Awarding a sentence of
What
17.
we heard in the cross-examination which you conducted of the accused told us that there was no lawyer representation. That is correct, but he gave due consideration to the case of the accused, even if there was no lawyer representing him. That's what he said in cross-examination.
Indeed, Your Excellency. Your Excellency, we would like to point out in this regard the fact that the accused has said there was no royal representation. There was another aspect, Your Excellencies, that was with respect to being heard. That is an addition, Your Excellency, in addition to the lack of legal representation.
Do you
with
have
respect to being
evidence
heard,
to say? Do you have evidence to say he wasn't heard in that trial?
Your Excellency, the witness testimony is the evidence that we rely upon in the present case that was cross-examined by the defense counsel as well.
The witness did not say he wasn't heard at any stage. I didn't hear, unless you heard it. I didn't hear that.
Your Excellency, I would like to shed some light on that with your permission. With respect to the victim's statement regarding the 9 minutes that were given to him for cross-examination, the victim distinctly mentioned that in those 9 minutes, he was not allowed to ask any questions in the present case, Your Excellencies. Furthermore,
I don't remember that. When you asked questions about law, the victim said, I don't know law. I'm a common person. I don't understand these issues.
Indeed,
And by the way, you are accusing the judge for not giving right representation, but it was lawyers who were not willing to represent him. I think you should have gone ahead and found the lawyers and also initiated proceedings against them rather than against a judge. Do you expect a judge to go out and find lawyers? I don't think that's
no, Your Excellencies. Of course not. In the present case, what the victim counsel is trying to point out is with respect to the lack of cross-examination time that was given, Your Excellencies, regardless of the legal representation. Even if we put that point aside for a minute while we consider the trial that took place,
what is
one
a
of the primary aspects.
Duration for cross-examination? If a cross-examination is done for 5 days, it's a good cross-examination?
Your Excellency, in the present case, the counsel would like to rely upon the testimony of the witness for that matter. The witness stated that approximately 8 to 10 months were given for each cross-exam or for each trial alternate in the state of Titan, and they had adequate time to prepare for their reliefs. They had adequate time to ask for their defenses, and they had adequate time to search for the lawyers in that.
I'm a little bit confused because you are saying that this judge is biased. And he's biased in all cases. He doesn't follow due process. Then you tell me in every case he takes 8 or 10 months. In one case, he didn't take 10 months. So are you seeing the point? You're contradicting. So as a matter of norm, he finishes a trial in 8 to 10 months. But in this case of one victim, he finished it early. So what do we rely upon?
With all due respect, Your Excellencies, the counsel would like to disagree on the point that the 8 to 10 months in this regard was the normal time that was taken by a trial. This was not the time that was taken by the trial that the accused was conducting, Your Excellencies. Through the testimonies, we see that even the brother of the victim in the present case was given a trial only of mere 10 days, Your Excellency. So that is the pattern that we're trying to show.
For example, in the United Kingdom, which is considered to be the most advanced jurisdiction on all these issues, a trial gets over in 1 day. Does it mean they don't follow due process? Just that they don't allow a lot of nonsensical cross-examination. And they're very efficient.
Indeed, Your Excellency.
And they produce the best judges in international criminal law. And if you look at the lawyers, most of them are British barristers. And they do things in a very compact manner.
Your Excellencies, with respect to that, the counsel would like to point out the specific instances of the accused in the present case, where the accused denied the right of fair trial. With Your Excellencies, is not with respect to the cross-examinations alone. For that, the counsel would like to rely upon the testimony of other witnesses as well. The witness, the first aspect that the counsel would like to talk about is the testimony of Mr. William, that the the judgments were written beforehand. Even if we keep that aside for next second, Your Excellencies, there was no evidence in the present case. The evidence that was present in this case was only the fact that...
I have 10 seconds to finish. We are way beyond time.
Indeed, Your Excellency. Your Excellencies, I would like to conclude that point and then move to the prayer within the next 15 seconds, Your Excellencies. Your Excellencies,
Counsel, I have a question for you.
Indeed, indeed.
What I understand from what you have been saying and what others have brought to our attention is that the accused in this case sentenced a number of people, 1,600 or 700, whatever, to death. And he was acting as a judge. He was acting in accordance with a law which was made in the state of Titan. And he was just enforcing the law which was given to him by the legislature. Because why I'm talking about this, the reason is that murder to amount as a crime against humanity is one of the basic requirements is unlawfully causing death. And this has been reiterated in Akayesu by ICTR in 98, then Elesic in ICTY in 99, and also Kupreskic in the year 2000. So consistently, the tribunals and the international criminal jurisprudence has established that the death, if it is caused unlawfully, then it may amount to crime against humanity. But in these cases, what we understand is the accused, and in the instant case, the accused was acting in accordance with law, and therefore we are reluctant to believe that this was unlawfully causing death. What do you have to say about this?
A twofold response to that, Your Excellencies. The first is with respect to the law in the present case, Your Excellencies. If you notice, the aspect of the law that was drafted with respect to the ADA policy, the accused himself has admitted that he was one of the chief persons who was indulged in the drafting of the same. Secondly, Your Excellencies, the victim that was testified from the side of the defense, Ms. Martha, also agreed that drafting of the policy in the present case would mean that the accused did work on the attributable and the implementable aspects of the policies. Secondly, Your Excellencies, even if we do regard that as a matter of fact that was presented in the present case as a law that was implemented in the state of Titan, ordering the death of 1,700 civilians is not a mere aggregate of random actions of the judiciary, Your Excellency. This shows that there is a conduct and there is a propaganda that was followed, Your Excellencies. Furthermore, in all these actions, Your Excellencies, if due process was followed and if the trial was conducted with regards to all the legal principles in the Criminal Code of Titan, it would have been a fair trial. However, due process was not followed and the charge sheets and the judgments were immediately prepared as soon as the charge sheets was filed, Your Excellencies. There was no due process in this regard, which is why to claim that in the current situation, the accused has given legitimate judgments when the accused and his wife both have admitted that they were both biased judges and they gave judgments which are overturned by the Supreme Court on account of bias. We would humbly like to submit, Your Excellencies, that this was not due process and this was not the proper implementation of the law of the state of Titan, Your Excellencies. Your Excellency, if you're satisfied with the answer, the Council would like to move on to the prayer and conclude in the next 10 seconds.
I think we have got your prayer, and I think we should end there because we are way beyond the time. And I'm sure, like Judge Kadam, I'm also not convinced because that's not what the witnesses said. I think let's go forward, and that should be enough. We know your prayers. We'll take it from the record. Defense, your... Yes.
Your Excellencies, Council seek permission to move on with the closing statement on behalf of the defense. Much obliged, Your Honors. Your Honor, we are going to prove before this honorable court that how prosecutor has failed to prove beyond reasonable doubt that all the elements of crime against humanity of murder under Article 7, Para 1, Sub Para A is being fulfilled. Your Honors, first we will be going with how the prosecutor witness cannot be admissible before this court. Your Honor, moving with the prosecutor witness 1, Eugene Young. Being a journalist, Your Honor, his research was confined from year 2017 to 2019, Your Honors. Whereas the whole scenario, it existed from 2016 till 2020, Your Honors. Your Honor,
I'm so sorry. You started by saying it is not admissible. Is it not admissible, or it doesn't carry sufficient probative value? What do you want to say?
So it is not at all a sufficient evidence from the
So
witness
you
in order
agree
to
on the
prove.
admissibility part of it. You agree it is an admissible evidence, but you don't agree on the probative value of the evidence.
Yes, Your Honor.
Okay. So don't use the word the evidence is not admissible then.
Yes, Your Honor. Much obliged, Your Honor. Your Honor, the witness in his testimony has clearly mentioned about the trial proceedings, about the interviews, but Your Honor, the witness has failed to give any authentic source on which the judges can rely upon. Your Honor, the counsel would try to bring before this court that Mr. Ambarto Eco resigned from the ADA on 5th September 2020. Your Honor, whereas the research was just confined till 2019. So, Your Honor, the journalist is completely unaware of the scenario that happened after 2019, Your Honors. Therefore, the testimony of prosecution witness should not be took into account, Your Honors.
I didn't understand. What is the point you're saying? After 2019, the witness has no knowledge? Because it's
yes, Your Honor, because in the cross exam, yes, Your Honor.
Because she's conducted interviews of people who have experienced throughout the regime, no?
Your Honor, it was simply from 2017 to 2019, and the people whom the journalist interviewed were completely from the Stener administration, as it was like accepted by the witness itself.
Your Honors, if you may allow, I have just one point to mention, that the witness was not having first-hand knowledge about that particular happening. It was not
a witness of fact. It's an expert witness. So let's not waste our time on wrong legal arguments. Go on. I think come to a next point if you have anything to say.
Yes, Your Honors. So, Your Honors, coming to the prosecutor witness 1, prosecutor witness 2, that is William Mason. Your Honor, the point that should be noted here is that William Mason was assigned to ADA as a judicial clerk from the period of 11th April till 2nd November 2019, whereas Ambarto Eco was assigned as the judge of ADA from 10th January till 5th September 2020. So, Your Honor, William Mason is completely unaware of the scenario that happened in the ADA. He's completely unaware of what might have happened. He might have been, Ambarto Eco might have been threatened, but Your Honor, as the prosecutor witness is having incomplete knowledge, he cannot be made he cannot be relied on, Your Honors. Your Honor, moving to the victim witness 1, John Ferreira. Your Honors, the victim witness has mentioned that whatever he was doing, it was because of fear, it was because of the threat that he was experiencing every day, Your Honors. So, Your Honor, if we can conclude that whatever Mr. Ambarto Eco did, it was just because of threat, it was just because of fear of his life, and whatever he has done, it is just an act of self-defense as any human being could have done. Your Honor, coming to victim witness 2. Your Honor, the point to be noted here is that when the victim witness 2 was asked in his or her cross-examination, to pinpoint the points on which the Supreme Court overturned the judgment, she completely failed to explain it. But whereas, Your Honors, in the testimony of the redacted witness, it is completely mentioned by the redacted witness that a fair trial should take place according to the redacted witness, Your Honor, that the fair trial lasts from like 8 months to 1 year. So, Your Honor, it completely contradictory on his behalf. He's completely contradicting himself, stating that having no knowledge, whereas this statement of his having having
got that
like
point.
what
Sorry
should
to
be the
interrupt.
period of fair trial?
Yeah, we have got that point. You have any other points?
Yes, Your Honor.
We have understood that point. Any other points to make?
Yes, Your Honor.
Yeah.
Much obliged, Your Honors. So, Your Honor, it clearly shows that why the prosecutor witness should not be taken into account. And hence, prosecutors have failed to prove beyond reasonable doubt that why the defense should not take the defense of self-defense under Article 31, Para 1, Subpara D, and Article 33 as well, Your Honors. Your Honor, moving further, much obliged, Your Honors. Your Honors, counsel would like
counsel,
to...
just a moment. You refer
Yes.
to Article 33 on defense of superior orders. Is that right? Because Article 33 of the Rome Statute talks about the defense of superior orders,
Yes,
not of
yes, Your
duress. So you are also relying alternatively on the defense of superior orders.
Yes, Your Honors.
Have you followed my question?
If you could repeat your question, Your Honor, once again.
You refer to Article 33 of the Rome Statute, which deals with the defense of superior order. 33 paragraph 1.
No, sir, 33 para 2 we are dealing with. 33 para 2.
Okay, you're not referring to the defense of superior orders.
No, no, no. 33 para
okay.
2, Your Honor.
It's okay.
Much obliged, Your Honors. So, Your Honors, the counsel would try to prove that who is the actual culprit. Your Honors, the accused should not be charged against crime against humanity of murder, whereas Mr. Steiner should be charged under Article 28, para 2, under the definition of civilian superior, Your Honors. Because, Your Honor, he was having absolute control over all the subordinates. And
I'm
therefore,
very sorry to interrupt you, madam, but he's not standing trial here. So let's not speak about things which are not relevant.
Okay, much obliged, Your Honor. So counsel would rest its closing statement right here, Your Honor. Much obliged, Your Honor.
Any other questions, maybe? Yeah. It seems there are no other questions, and now we'll be in the hands of the
just one last, because I'm not fully satisfied with the explanation given. The counsel just said that she's not relying on Article 30. She's relying only on Article 33, para 2, but she's not relying on the defense of superior orders. Is that clear, counsel?
Yes, Your Honor.
Just need some clarification on Article 33. You refer to second paragraph of Article 33, and you said you are relying on that. And you said you are not relying on the defense of superior orders.
Counsel would like to rephrase my statement, the counsel from the defense would like to take the self-defense under Article 31, para 1 and subpara 3.
Okay, because you misled me to believe that you are
Yes,
talking
Your
about
Honor. It was
the
just
defense of superior orders. Article 33 deals exclusively with the defense of superior orders and not duress in any way.
Yes, Your
Thank
Honor.
you. Thank
Counsel seeks ignorance for the same, Your Honor.
But you concede that you don't have a defense of superior orders because you were actively involved in the commission of the offenses. Isn't that right? Yes.
No, Your Honor.
Because I thought you said you agree to that, isn't it? You're not relying on superior orders, implying that you agree that the responsibility is attributable to you.
If you're honest, may just wait for 1 second. I just have to I mentioned that.
In the meantime, I have a question to the second defense lawyer, if I may.
Yeah, indeed, Your Honors.
I'm just a bit curious. You relied on the defense of duress.
Indeed, Your Honors.
Why not in the alternative did you invoke the defense of superior order if the defense of duress was not acceptable to this court? Is it not always good to fall back on some alternative instead of relying only on one defense?
Your Honors, basically, we are not. We have actually in our written submission to the written submission as the memorial, we have invoked Article 33 as well. So basically, we will be substantiating under Article 33. There are three major things which needs to be substantiated. Is that there should be a legal order from the government side or from the side of the superior, and second one is that there should be manifestly illegal. The order should be manifestly illegal. So basically, what the council contends is that in the present case scenario, both of these elements are actually substantiated and justifiably substantiated. The first thing is being that the order that was a legal obligation on Mr. Umberto Eco, he was legally obliged to give punishment according to the order of Mr. Steiner. There was the law passed by Mr. Steiner, which mentions, and actually Mr. Steiner had given guidelines to Mr. Umberto Eco that he has to dispose the cases as soon as he can. Now, when we come to the second element, which is manifestly illegality of the manifestly illegal, there we can see that the order which was given by Mr. Steiner, that was manifestly illegal. And now when we talk about why exactly Mr. Steiner was adhering to the same, we have told that he was trying to avoid the greater harm that could have caused. He was trying to act.
I'm so sorry to
question, Your Lordship. Your Honors.
But under 33 paragraph 2, if there is an order to commit a crimes against humanity, then it is deemed to be manifestly unlawful. So you are expected not to comply with such a law if it is a crimes against humanity.
Honors, therefore, this is the alternative. As Your Honors asked about the alternative remedy, therefore, we have firstly adhered to the defense of duress. And if
coming back to the question I asked to your colleague, you concede to the fact you don't have a defense under 33, you only have a defense under duress.
Your Honors, we accept.
There's no harm in being honest to the court at times,
Indeed, Your Honors.
Thank you. Okay, so I think that closes the hearing, and now we are in the hands of the organizers. Do the judges go in some closed room to have a discussion, because we may want to discuss markup?
Your Excellencies, may I please request some feedback for the participants in this round?
Right away?
It depends on your convenience, Your Excellencies.
I thought we all may want to have a word with each other and see where we stand, and then tell you. Is that the right way? How does
yes, sir.
Dr. Subramaniam?
I think we need to consult. The panel of judges needs to sit together and discuss a few things, and then we can give the feedback, or at least one of us will give feedback on behalf of everyone.
All right. Thank you, Your Excellency.
Thank you, sir. With this, we conclude the final rounds of the 6th Symbiosis Law School Pune International Criminal Trial Advocacy Competition 2021. We would like to thank Dr. Umesh Kadam, sir, Mr. Aniruddha Rajput, sir, and Professor Dr. T.R. Subramania, sir, for presiding over as the finals judges. We would request the judges to join a breakout room for discussing the scores. Rebecca, has a breakout room been made?
I'll just ask.
Sorry. Can we request for the live to end, because we are going to discuss, the judges are going to discuss, it should be confidential. So can the live end, and then we can start again for the valedictory?
The live
how do we join the breakaway room?
So
just
allotting a breakout room, you will get a pop-up. Once you click on join, you will shift to another room where the judges can discuss regarding the scoring.
Okay.
Thank you, judges, Professor Kadam and everyone I can see. So thank you for supporting our students.
Well, I'm not sure if we have been supportive, but it was a pleasure. In
No,
whichever way it was.
the very arrival of you as a judge is very important for us, each one of you, based on your expertise. So it took a little longer than the plan.
Process of learning, even at this stage. Lots of things are coming up and lots of developments are taking place.
Right,
and listeners, remember, they have lots of sources they find. At
Right.
times they're unable to make use of it properly and the contexts are different.
Right, right. Sir.
In a way, it is really a good experience.
So all the students who are onlookers now, I think more than 300, including the competitors. So when you all are busy with this, how would we engage them? Shishira and Rebecca, how do we engage them?
Ma'am, we will not be taking more than 10 minutes for the tabulation once we receive this.
Okay,
So we
it
can
should be done within 10 minutes. Okay.
Yes, ma'am.
Great.
Can the participants turn off their videos now?
Yeah.
Yes, please. Thank you.
We request you to stay on this link because we will be beginning with the valedictory ceremony very shortly. Thank you.
Thank you.
So judges would go to room number 1, right? Which you are asking to join.
Yes, ma'am. We will be making the breakout room.
Yeah.
In a minute.
Good. Thank you.
Ma'am, judges will be going to a different breakout room. In breakout room number 1, the chief is already there. So we request you to please join that breakout room.
I shut it. So can they give it again?
Yes.
Ma'am, do you see it again? We will assign you to the...
No, I don't. It was there. I thought it is meant for judges, so I didn't.
Okay, ma'am. We'll just see.
Yeah.
I haven't got a link.
How am I supposed to join the breakaway room? I don't understand still.
Just a minute. We will send you, sir. You will get a pop-up on to join the room. So just you need to click.
It will appear on the same screen, is it?
Yes, sir.
Yes.
Yes.
Okay.
Yes.
Okay.
Did you send the link?
Ma'am, do you see an option breakout rooms at the bottom?
No, no. I just saw once and then I didn't click it. I thought it is for the judges, but after that it hasn't come.
Excuse me, ma'am.
Yeah.
Ma'am, do you see an option saying only breakout rooms, not join, but breakout rooms?
At the bottom of your screen, ma'am, towards the right side.
No, I don't see.
I don't think it is coming for anyone.
Where are our ICT people? Are they not with you?
They are here, ma'am.
Yes, ma'am. We are here only. Just we are guiding to the other people. Just a minute. We're making one room for the.
Talking here and you are not even responding here. Okay, now the breakout rooms are here. In that.
Just a minute, ma'am.
Room number 1.
No, it doesn't say which room, but it says only the numbers are there. Breakout in progress, it says.
Oh, ma'am, then you will really. Ma'am, if you scroll down, you might see room number 1.
Yeah.
So you can press the join option there and you will join room number 1 where Justice Sandeep Mehta sir is there.
Nothing has come. Hello?
Yes,
Hello?
sir.
Yes, sir.
Nothing has come so far.
Yes, sir. We're just sending you some.
Yeah, okay. Caption is join.
So you would have received a pop-up now.
I have not seen any pop-up so far.
I'll just get back to you.
Sisira, check
Yes.
the group. Check the group.
CC, please don't. Yeah, please check the group once. Ish, if you're here, if you can send it on the chat box. Ish, Vishal, if either of you is here.
Yes, I've posted the link on the chat box. So only the judges are requested to join the same.
Here.
So the pop-up is not appearing for any of us now. So we'll be going.
No, take it on Google Meet. Huh?
Yes, sir. Google Meet only, sir. We are going on Google Meet, sir, because the pop-up is not available for us.
To join to the Google Meet. So we are waiting for other judges to join us. Yeah.
From the chat bar, it's not connecting to Google Meet.
So, so that is only for the finals judges, sir, for discussion.
Okay.
Yes. Sir.
We have to stay here only.
Yes, so we will be beginning the valedictory shortly.
Okay, fine.
Thank you, sir.
Yes, sir. Yes, I'll just check. Sir.
It echoes otherwise.
Lot of disturbance also.
Yeah, there are a few candidates, a participant, Maitreyi, Raghav, just announced, please be on mute.
Everyone, we request all of you to please be on mute. We are to begin the valedictory ceremony in another 30 seconds. So we request all of you to please be on mute.
Okay, we are ready. 3, 2, 1, start. We are live.
A very warm evening to one and all present here. My name is Nandita Mantha, and I, along with my colleague Patricia Pereira, are your compares for the day. It is our esteemed pleasure to welcome all of you to the valedictory ceremony of the 6th Symbiosis Law School Pune International Criminal Trial Advocacy Competition, SICTA 2021. After 2 days of riveting competition, passionate and enthusiastic advocacy, the competition has ended on a triumphant note. SICTA 2021 was an endeavor of great significance in unprecedented times, conceptualized with the aim of infusing the seeds of dispute adjudication through simulation, along with a holistic experience of International Criminal Court. In the last 2 days, the participating teams and the respective judges have achieved just that. We at Symbiosis Law School Pune are taught that smooth seas seldom make skillful sailors. Conducting the competition online with such efficiency was only possible due to the guidance of our director, Dr. Shashikala Gurpur ma'am, the support of our faculty and the IT team, and the incredible amount of effort put in by the members of the Student Bar Association. And we're humbled to have our distinguished guests contributing to the successful completion of SICTA 2021. Before I invite Director Dr. Shashikala Gurpur ma'am to deliver the welcome address, I would like to take this opportunity to introduce ma'am. Professor Dr. Shashikala Gurpur ma'am is the Director of Symbiosis Law School, Pune, and the Dean Faculty of Law of Symbiosis International Deemed University. Ma'am is a distinguished academician and orator, having presented over 220 invited lectures, workshops, and seminars in a global capacity. Dr. Gurpur has 65 articles and research papers, 2 co-authored books, and 12 book chapters to her credit. She has an outstanding career with a wide range of experience in teaching, research, and industry. She has been a member of the Law Commission of India, and currently, ma'am is a member of the Curriculum Development Committee, Bar Council of India, and Academic Council. Ma'am is also the advisory and PhD referee for several national law schools and universities across the country. The community legal service rendered by Symbiosis Law School, Pune, under Gurpur ma'am's guidance among prison inmates and rural women in Pune, has recently won the Howbert Smith Freehills Grant also. Recently, ma'am has also been listed in the book 100 Legal Luminaries of India by LexisNexis, along with Indira Jaising, Arun Jaitley, Advocate Ram Jethmalani, and others. Ma'am has recently been presented with the annual Kittur Rani Chinnamma Award 2018 by the government of Karnataka for her work towards the empowerment of women. I now request Dr. Shashikala Gurpur ma'am to address the gathering.
Good evening, Your Honorable Lordship, Justice Sandeep Mehta, sir. Good evening, my respected colleagues, dear students, and most of all, our respected alumni convener, Advocate Sampath Bulusu, and the supporter of our competition along with Mr. Bulusu, Mr. Manan Sangai, and this final's esteemed judges, Professor Umesh Kadam, Mr. Anirudh Rajput, and Dean Subramanya sir. A very warm welcome to each and every one of you. First of all, I deeply apologize that our schedule went forward by 2 hours, and I sincerely appreciate His Lordship's kindness in accommodating this delay and understanding how the students function and their constraints. Thank you very much, sir, for your compassion and understanding. As I welcome you, I would like to bring to your kind attention that Symbiosis Law School, Pune, which has consistently been among the top 5 law schools in the country in last more than 20 years, has been known for its beyond classroom learning, emphasis on skills, and preparing students for diversified legal careers. While there is a lot of clamor for corporate careers across all lead law schools, we are very particular about training students in standing up as a lawyer, because we personally believe that every law graduate represents the identity as a justice worker. So the first and the foremost competence they should have is the urge to defend justice and the capacity to stand up when things don't go according to rule of law and justice. So in our endeavor to do that, the general environment of Symbiosis being a home to 8 faculties, ranging from management to information technology, and lately with an all-women medical college to the our health and medical sciences faculty, this university and this family of institutions, now we have 38 institutions, more than 20,000 students pursuing studies here, right from diploma to graduation to post-graduation to PhD here, is known for the tagline Vasudhaiva Kutumbakam, where the whole world is seen as one family. Therefore, we believe in preparing students for the global workplaces as much as India, because India is home to 1/5 of the global population. So at the same time being socially relevant, socially sensitive, globally competent, our graduates have persevered to occupy very important roles, to play very important roles, to get into Ivy League universities across the world. Besides being judges, Justice Revati Mohite Dere, who is the sitting judge of Mumbai High Court, along with Justice Sadhna Zadav Madam and a couple of others have been our alumni. There are more than 35 students of ours in last 5 years who have occupied different judicial roles, civil services roles. So there is a very strong emphasis here while preparing the corporate world related legal skills in making one very much reverberate with public service commitment. So SICTA is one such endeavor where we train students beyond the dominant mode of mooting into trial advocacy, because we are looking at number of lawyering skills. They say that business schools do not teach business, but law schools will have to teach the lawyering. So our effort has resulted in the law school in last more than 12 years in creating an ADR center, in training people, in training lawyers to commit to legal aid, alongside hosting about more than 3 crores worth international research projects funded by European Union, and more than 54 collaborations. Just 2 months ago, FICCI awarded us the best institute in internationalization across India, where we were competing with globally translatable language like technology or medicine. So for a law school, and with law bound up with governance and nationalism, it was not an easy feat. It was a big feat to accomplish this award. At the outset, I would also like to put on record that we have been honored this year to have such enthusiastic bunch of students and faculty who stood up to the challenge of running SICTA online. Your Lordship, I would like to share with you the pain that we had last year when we had almost set everything right for a direct SICTA competition. Competitors even flew in from Chennai and other places. And there was one part of National Law School students resisting this move to arrange the SICTA directly, because by then country was opening up to the lockdown. This was 13th of March, we are talking about 2020. So suddenly we had to reorganize our guests to leave. We had an international judge who was with us, the former judge of Sri Lanka, who is now the UN representative of Sri Lanka. So overnight, we had to organize this return trip. We had to manage the air travel. So from there, we have come a long way. We had to do the memorial-based rewarding in the as there was no way of reopening after that lockdown. So having come a long way this year, we didn't want to take any risk. We went online, but we had our own challenges. Last night, I'm told that proceedings went up to 10 o'clock in the night. So I congratulate all the participants for that endurance. At the same time, I would apologize that we should have been mindful of the screen time, which doesn't seem to be a very healthy time to be that long. So we could have, because of enthusiasm, we did not have any other choice. We could have divided the proceedings into 4 days, but we didn't have a choice. So what I'm coming to is, this is a law school which is very, very prepared for the 21st century. We are going to come up with the 21st century Teach Skills Lab. We are one of the very rare law schools which is developing a skill lab. We have a skill center. So our curriculum is very much aligned with skilling, and not skilling in the government sense, but lawyering skilling, which is a very unique initiative which Australian Bar Council developed, and we have developed on that with our own field experience and talking to the lawyers and being graced by judges like Sandeep sir, or in the past we have had the former CJI of Rajasthan, Justice Nandrajog. So these are the people who kindle the spirit of learning beyond classroom, learning in a way that it applies to real life, that it impacts the socioeconomic landscape of this country. And it also helps students to innovate. So, sir, I'm very happy to place on record that SICTA in its the 6th version today is a very mature competition. Initially, it came as a resistance to, or as an alternative to ICC's official moot, for which a national law school was picked up. And our own students developed this in-house innovation of SICTA. And our own alumni and our advisory visiting faculty from New Zealand, Ireland, and other places helped us to develop the first problem. Today, our own alumni and our in-house students and faculty, with the advice of some of our alumni who work with international organizations and mentored by lead lawyers like Sampath Bulusu, have these problems being brought up. And you would have appreciated the way in which it has remained contemporary, which the way in which it has picked up on a number of issues and weaved it into a very relevant and challenging trial advocacy problem. The attraction here is students also take the role of litigants, they take the role of victims, they take the role of witnesses. Our in-house students connect it to their curriculum and they make it as mandatory part of their curriculum. That's very unique. We don't want to be just a platform showcasing talents. We want to be using it as a kind of extended learning through witnessing such trial advocacy. I would not want to extend this welcome address to speak more. I'm sure that all of you would give a lot of tips to the students, but I humbly submit that this effort of ours using the technology in a virtual mode has been encouraged by the lead competitors of the world and India, and by people like you, your lordship, aside from our alumni and student team and the competent faculty team. I welcome one and all. Thank you.
Thank you, Gurpur ma'am, for that insightful address and for constantly encouraging us and guiding us to achieve greater heights. I now invite Rebecca Jaiswal, co-convener Student Bar Association, to walk us through SICTA 2021 and to deliver the list of achievements of the Student Bar Association.
Good evening, everyone. My name is Rebecca Jaiswal. I'm the co-convener of the Student Bar Association for the academic year 2020-2021. There can nothing be said about this particular competition that ma'am has already mentioned. If I add more to it, it'll be only adding to what ma'am has already said, and all of you already know about it. The emotions that go behind SICTA, the emotions that go behind conducting the competition or being part of this competition is immense. And all of us are very proud to host all of you here on this particular Zoom link, while the same is being live telecasted on YouTube. SICTA, the full form of SICTA is Symbiosis Law School Pune International Criminal Trial Advocacy Competition. This was started by, like ma'am said, it's an in-house project. This was started by my own alumni, and we will keep on taking their name time and again, because this is how much we are connected to the alumni base. This is how much we are connected to the people who actually incepted the competition and started it back then. We are in the 6th edition now, but we always go back to the same people that have started SICTA back then. And we always look up to them for doing everything that they've done for the college and for this particular competition. If I talk about how SICTA is or what SICTA is, it will be again be very repetitive, because all of you know, since all of us are here, we know what SICTA is. SICTA is a competition that we conduct. It's based on the trial chambers. It's based on International Criminal Court. We are the only second college in the entire country that bases their competition on ICC trial chamber rounds, other than NNUD, which actually holds the ICC official rounds in India. Now, what SICTA does to everyone is they give you an ample amount of opportunity to not only learn about trial chamber, but also to learn about international law in a very holistic manner. We have so many engagements, not from the outside colleges, but from our own college, in the form of witnesses, in the form of so many internals that we keep for these people. The witnesses that you all witness in the final round, those are all the people that we have trained over the course of past 1 month. We prepared for SICTA. We will start preparing for the next SICTA in this August. So it's a long process that goes into making SICTA what it is. From the problem framing part of it to the valedictory part of it, everything is well thought of, well supported by our own director, ma'am, well supported by our deputy director and the faculties in charge. So if I have to talk about SICTA, if in one word I have to talk about SICTA, it'll be emotions. Because ever since my first year, I've been a part of the committee. I've been part of the Student Bar Association. We have conducted this is the 4th SICTA that I'm conducting right now. And it gives me immense pleasure to co-convene the particular competition in the 6th year, in the first virtual year of this competition. If I have to talk more about SICTA, I really cannot do it without mentioning the immense contribution of our problem drafter for this year, Mr. Parth Dixit. He has been always the backbone of the competition. Ever since his 2nd year, he's drafted the problem. Even after he graduated from our college, he is still the one who's drafting the problem. And he does it with immense pleasure, with immense dedication, and a lot of thoughts go about in drafting the particular problem. If you see, the entire problem is drafted by Parth Bhaiya. I call him Bhaiya because he's an alumnus and we've known him ever since our first year. The particular problem is is drafted by Parth Bhaiya with the help of our SBA faculties. But the major amount of work that goes inside into building a problem, the 40-page problem that we hold, along with the witness briefing sessions, along with the witness testimony, every single word is well thought of and written by Parth Bhaiya. So if I talk about SICTA anywhere, I have to mention how Parth Bhaiya has contributed immensely in making SICTA what it is. Without his constant support, his mind, his intelligence, his intellect, we could not have been able to come to the 6th edition of SICTA and make it what it is today in the entire, not just in the entire country, but worldwide. I also have to mention the thought that went inside into make the starting SICTA by then the convener of the Student Bar Association, Mr. Vadi Joshi. Vadi Bhaiya has been the kind of support that we do not think we ever deserve. Not just about SICTA, anything about the Student Bar Association, it concerns us as the members, current members, it also concerns him. At every single point during this SICTA or the last SICTA that we conducted, he was there supporting us, guiding us throughout. He was there to tell us how to go about things. He's still here, right here, telling us about how to do a particular thing or how to not do a particular thing. He's the one who's taught what conducting a competition means. He's the one we look up to for anything possible ever. So it's not just about SICTA, it's not just about the SB, it's about him as a person. It's about us and how we look up to Vadi Bhaiya for everything that we ever do when it comes to the SPA. If we talk about Vadi Bhaiya, we also have to talk about Sneha Didi, who's been immense support, who's given us immense support and encouragement in not just conducting SICTA, but all the other events that the SBA holds. If you talk about all of these people, we also have to mention the constant effort and support that goes in conducting SICTA and the constant support that we get from our faculties as well. Be it Nitin sir at that particular time when he was in the SBA and in the college, or be it Viren sir, Varun sir right now, Richa ma'am right now, all of them have been immensely supportive to all of us. Even when we thought about conducting SICTA virtually, they were the first ones who came up to us and said, yes, we can do it. And that is why we only decided to go ahead with the competition in an online manner. Then we also have to talk about the kind of support that we get from Sampath sir, our alumni convener. And he's again one of the biggest supporters of all our endeavors that we do with respect to the Student Bar Association and with respect to the college. Sampath sir has been that one person whom everyone goes running to for anything whatsoever. And he just has a solution, or he just has something that to provide you with. Not just that, if we also talk about all these people, we have to immensely talk about the IT support that we get, especially this time when everything is online. The IT support, the IT team that has given us by conducting the SICTA. If I talk about conducting SICTA, I have put my heart and soul. My team has put their heart and soul. The faculties, director, ma'am, deputy directors, everyone have put their heart and soul. But it's the IT team that has been there throughout these 3 days, even before and after, for the multiple guidance that we had with the participants, with the judges, and the multiple guidance that we had even after for our own convenience. It's the IT team who always supported us and never said no for us, even if it was at 2 in the night. So the kind of support that we get in conducting an event at Symbiosis Law School Pune is immense. And I'm truly glad to be a part of not just the Student Bar Association, but of a college that gives us so many things to learn and deal with at the same time. While being in college, we learn to deal with so many things. We learn to multi-manage things. We learn to go through a lot of things in general, and we learn to grow. We grow exponentially in the due course of conducting an event or even thinking about an event. Same way, like ma'am rightly mentioned, it's not just about us conducting an event, it's also us going and participating in so many other events that our teams from Symbiosis Law School, representing Symbiosis Law School Pune, have gone on to represent the college. And not just represent, they have also learned something out of every single competition that we've ever participated in the past 1 year. Our teams went on to over 150 competitions in the last 1 year, and in one way or the other, we have won some laurels in the form of the best team, the runners-up, the best memorials, the best speaker, the best researcher, so on and so forth, in over 70 teams, which also includes 9+ international teams in the span of last 1 year, where we went on to do extremely beautifully, and over 46 teams nationally around India, and over 26 teams in the state level. That is not it. We are not only here to win laurels to the college. We are also here to learn and grow in the process that even if we are going for a competition. So some notable competition that we've gone on to do really well will certainly include the Stetson, wherein we went on to the world rounds and we became the runners-up. It would also include the Oxford Prize Media Competition, wherein we were educated the winners for this particular year in the national rounds, and in the world rounds we were educated the semi-finalists. We will also include the Louis M. Brown mediation competition, wherein we were the runners-up again. The CPR mediation competition cannot be left out because we again went on to become the runners-up in the national round. Talking about so many international rounds, I cannot also leave the national rounds behind. So in the GNMU Mood Securities Law, we were again adjudicated winners. In the RGNUL Law National Mood Court Competition, we were adjudicated the winners and the best speaker. In the 12th NLU Antitrust, we again were adjudicated the winners. So there are so many competitions I can talk to you or tell you about that we've gone on to do so well, and we won something for the college, we won something for ourselves, we graced our college in a way that is supposed to, because the college gives us so much that we have to give something back to it as well. Now, it's not just about, like I mentioned, it's not just about being a part of a competition or participating in a competition. It's also about learning out of a competition. So the particular competition, which is the ICC competition organized by NLU Delhi, what happened this year was the rounds got cancelled. The oral rounds for that particular competition got cancelled, and we had a team that was representing the college in that particular competition. And the team, without being disheartened, they were just really very surprised and happy to be a part of the competition. And even when the results came out and they did not qualify to the 5 top teams, they were still very happy because they went on to learn so many new things in that particular competition. With this, I would like to thank all of you for being very patient with all of us over the course of 3 days and during the entire event. I would also like to thank Director Ma'am for her amazing speech. I'd also welcome all our guests and our chief guests for being a part of the 6th edition of SICTA. Thank you.
Thank you so much for the lovely address, Rebecca. I would like to introduce Advocate Mr. Sampath Pulusu, General Manager and Head Legal, Shell Hazira. Sir is an alumnus of Symbiosis Society's Law College, now Symbiosis Law School, Pune, and to become a lawyer was Sir's childhood ambition. During the days as a law student, Sir joined the chambers of a noted criminal lawyer, Mr. Indrajit Singh Gill at Pune. Sir joined the bar in the year 2001 and practiced at the High Court of Andhra Pradesh, City Criminal Courts Hyderabad, administrative tribunals, and appeared in a number of session courts throughout the state of Andhra Pradesh, Gujarat, and Maharashtra. Sir has also appeared before the Supreme Court of India, sensational criminal cases such as the multi-crore scholarship scams case, livestock insurance scam, fake stamp paper scam, and many more such notable cases. Sir also appeared in a number of civil cases pertaining to land tenure litigation dealing with Zamindari abolition legislation via Andhra Pradesh Estate Abolition Act. Sir's interests include criminal law, litigation, arbitration, petroleum laws, construction law, labor and services law, civil laws, banking laws, government relations, regulatory affairs relating to energy sector, constitutional law, land laws, electricity laws, and forensic science. It is an enormous honor for us to have you, sir, among us. I request you to now address the gathering.
Thank you very much. Respected Lordships, our Chief Guest, Honorable Justice Sandeep Mehta, sir. Honorable Judges, Dr. Subramanya, sir, Dr. Anirudh Rajput, and Dr. Umesh Kadam. Our own respected Director and Dean of Law Faculty, Dr. Shashikala Gurpur, ma'am. Alumni who have been judging this competition, participants, students, and learned faculty members. It is indeed a great honor for me to be associated with this particular event and this competition called SICTA. And it shows that, you know, time flies so fast. We thought about SICTA, 7 years back, the idea that was sown by our own students. And when I say our own students, I'm still part of this institution as a student myself, though we qualified to be alumni, because every lawyer is still a learner. And this is what is the beauty of our profession. So these students were at that time in their 3rd year, and they came out with this idea of SICTA. and which is based on the ICC Rome Statute model. And then, of course, this was a learning for me at that time. And we just joined hands with the students. I still remember in the other Viman Nagar campus in Pune, after the Justice Y.V. Chandrachud Memorial Law Lecture, the students had come and they expressed about SICTA and that they were finding it a bit difficult to get sponsorships. Definitely, the alumni base did come forward. We could do something and we made a beginning. And yes, through SICTA, as I always been saying, this is something close to my heart. Criminal law as a subject has been a subject of my interest right from my student days. Though I have been working on the corporate side today, I still continue to have the academic interest into this subject. And I do still read it, though I may not require criminal law day in, day out when it comes to my own work. But yes, it's a subject which is quite important. The procedural laws, when it comes to either CRPC, even when it comes to evidence, yes, this is something which students even today may feel that this is something too old a fashion a subject. But then yes, these things are going to remain. Our basics are taught from these so-called old subjects, then the rather new branches that have emerged. Every branch of law is important. SICTA could not have been completed without the support that we had drawn from our own alumni. There have been, great words spoken by Gurpur ma'am or by Rebecca just now. And this is not something individual of me. I am thankful to my own friends from the campus. We all joined this campus somewhere like 2.5 decades back. By God's grace, we are all still in touch. And I could not have done anything for the institution but for the support when it comes to judging or any other support that is required for the institution. The moment we receive a call from the institution, yes, we speak to each other either on WhatsApp or phone calls, and yes, we have a small number that comes. So without them, I cannot do anything for the institution. So this is what ultimately the ideals of Symbiosis, Vasudhaiva Kutumbakam, happens to be brought in full use. And we try to live by that particular example of Vasudhaiva Kutumbakam here. Apart from that, by way of SICTA, I have been, not only criminal law that has been my interest, SICTA has also given me an opportunity to pay homage to my maternal grandfather, who was a leading prosecutor of Andhra Pradesh. And he had an uninterrupted tenure, being a tenure-based special public prosecutor for 33.5 years. He was called the most zealous and jealous public prosecutor, but none other than Justice O. Chinnappa Reddy in one of the judgments, one of the trials that he had conducted in 1966, when it had gone before the AP High Court. Justice Chinnappa Reddy, while hearing the appeal, in the judgment itself had observed that the special public prosecutor who conducted the trial was not only zealous for his position, but also equally jealous of this position and had left no stone unturned. So, and he was again a product of Pune University. Like most of us, like Siddharth Yavalkar, Vijay Kumar Dakne, who is special public prosecutor in Pune today, we all were students of Pune University because Symbiosis was an affiliated institute of Pune University then, before it became a deemed university. So ultimately, it was the place where my grandfather studied, and I studied there, for which I feel, and my inspiration. So this is how SICTA has brought many things together. And of course, when it comes to time management, I would always say, and today I still remember Siddharth Yavalkar sending me a message in between, we have already completed, don't kill the students further, please conclude your rounds at the earliest. We could complete it 15 minutes late than the original schedule. But then some of the judges of the preliminary rounds, I'm sure you are here, don't take me otherwise. Let us try to concentrate on time and see that we are able to, do well and not keep people, people of high stature like his lordships waiting. And with these words, I would conclude. And in the end, one message which I would give it to the students and also to the participants, when I mean students, it also includes the participants here, the words of our own late Professor Emeritus, Senior Advocate Sri Ramjit Malani. The one thing which he always used to say was, Ram sir used to say, a lawyer who knows law is nothing but a mason. As a lawyer, it is not just law that you need to know about, it is various other subjects which you can integrate and learn. So don't be masons, be true lawyers. Thank you very much.
Thank you so much, Sampath sir, for that heartfelt address. We express our sincere gratitude and thanks for your constant support in all our endeavors and for your words of wisdom. Now, I would like to welcome our guest of honor, the esteemed Dr. Aniruddha Rajput sir. Sir is a member of the United Nations International Law Commission. He was the chairperson of the drafting committee for the 69th session of the ILC in 2017. Sir's area of expertise is general international law, dispute resolution, boundary disputes, law of the sea, international investment law, and international trade law. Dr. Aniruddha has assumed advisory roles for the governments in proceedings before the International Court of Justice, private clients on proceedings under the Alien Tort Claims Act before the US courts, and the human rights and other public international law litigation in the Supreme Court of India. He has taught courses in international law at several universities and presently serves as a member of the Board of Studies of the South Asian University, created by the SAARC countries. He was a member of the study group constituted by the Law Commission of India in 2015, the Draft Indian Model BIT, and a member of the 5th Haryana State Finance Commission. Sir has helped draft the arbitration and conciliation rules of London Court of International Arbitration and Delhi High Court Arbitration Center. He was involved in the consultations for proposals of amendment to the Indian Arbitration Act and contributed to the drafting of the National Sports Development Bill 2012. Sir's recent book, Protection of Foreign Investment in India and Investment Treaty Arbitration, was published by Kluwer International. It is an honor to have you with us today, sir, and I now request you to address the August gathering.
Thank you very much. Thank you to the introduction to be here. It's indeed an honor to be in this distinguished set of individuals, right from the sitting judges to leading academics and practitioners of international law. So I express my deep gratitude to you all for inviting me. Although I don't have any direct link to Symbiosis Law School except for the fact that I come from Pune, but the other indirect link rather, which I have is both my parents are alumnus of Symbiosis Law College as it used to be then. I don't know for what reason they decided to send me to a law college which was just across the road, but be that as it may, we are where we are. I must say it's a great honor and pleasure to be here. It's good to see how young Indian international lawyers are shaping up, working hard, trying to make their mark. I don't want to speak a lot because those who were there at the final rounds realize that I've already spoken way too much. So I should probably not speak much anymore. But just a few thoughts which I think I should make at this stage in order for those students who wish to seriously pursue a career in international law. And I would encourage people to seriously consider that option, which is of course full of obstacles, but nevertheless highly fulfilling. And also a few observations of what we had as judges or what we felt about the rounds. Of course, there was a sterling performance, immense hard work, which was done on the part of students. But it's also now a time to reflect upon what you did because it's a part of a longer process of learning and improving. So whatever general comments I would be making, I would be making those with the hope that it could somehow contribute towards your progress professionally. The first thing which I always feel as a lawyer, it's very important to come to the point. A lawyer who is to the point is a successful lawyer because there is no such thing as a perfect lawyer because there can't be a perfect lawyer. We can only have relative tests of being a good lawyer. And what distinguishes a good lawyer from other lawyers is the ability to improve, is the ability to have more and more qualities of a good lawyer. So a lawyer, in my view, is always a work in progress. And we should always be open to learn, understand, absorb, not just the law, but also the other factors. I do understand that for several decades in India, there is a fashion to say, you need not know the law, you just need to know how the law works. And that's the reason why we stand where we stand today. Despite being such a big country, we are still considered to be one of the still developing countries when it comes to judicial systems. Our backlog and all the other problems, we all know about it. We are still not like United Kingdom. We are not still like Singapore, who started the journey much after us, but they went much ahead of us. And the reason why they went ahead of us, because they stopped and removed the non-legal facets of legal practice. They emphasized on the need of having good lawyers. If we want a good future for the country, if we want a good judiciary, functional judiciary, of which law is an integral part, we need good lawyers. And a good lawyer is the one who knows the law well. If you don't know the law, then there is very little that you can contribute towards the country and to the society. So that's the point for all the participants, or at least those participants who I managed to see in the final rounds. You need to know the law, and you need to know the law well. And if you're going to open your mouth before a set of experts, you better know that there is going to be a challenge. So if you start giving a general discourse on wisdom and how the world functions, I know I have seen that, unfortunately, when I used to practice in the Supreme Court, lawyers coming and making such arguments just to seek an adjournment. It doesn't look good on the lawyer and doesn't look good on the institution. So as we are aspiring, which we do as a country, to go from the third world to the first world, if we are moving in that direction, we better make sure that we know what we are talking about. And that comes with a great degree of research. And it's a general point. I wished even the finalists would have done a little more research than what you had done. The second related point is, what is, after all, a lawyer? What is, after all, law? And now I might sound more contradicting myself, but I'm not contradicting myself. A law is basically logic, but it's not simple logic, it's legal logic. And what I mean by legal logic is, when A leads to B and B leads to C, then what is the connection between A, B, and C? It is the ability to draw the connect between those three ideas. The better and stronger you draw those ideas, the better lawyer you are. And that ability to draw that connect comes from the ability to absorb the facts which are relevant, not just any fact which is not relevant, to absorb the fact which is relevant, and then connect that relevant fact to what the relevant law is, and then to apply the law to it. And now when I say this, I think it's very different from being an academic. And I have always felt being a good academic and being a good lawyer are two different things. As a good academic, you have to be passionate about your position. But as a good lawyer, you have to only make those points which are going to help you win the case. So there's no point having this all style of verbosity, nice flowery words, if you can't win the case, if you can't come to the point. And that takes me to the third point. We have to decide what kind of lawyers we want to be. In the American system, in the classical criminal trial, they like to have these glossy statements, large philosophically loaded words and sentences, which don't take you anywhere. But what I found very interesting, and it is worth considering since I'm myself qualified in the United Kingdom as a barrister, it's worth looking at how the rules are framed for the barristers. And the barristers are not supposed to make any glossy arguments. A barrister is supposed to come to the point, straight to the point, discuss the point, make the point, and rest his case. If we try to stick to that, I think we would have a lot to contribute. I was allotted 5 minutes. I think I've already exhausted them. I try my best to always stick to the time. And if the rounds have gone overboard, I think we also started a little late. And I'm sure Honorable Justice Mehta would sympathize with us that since the organizers made us wait for at least more than an hour, they made you wait a little bit more as well. So just to ensure there is parity, there is equality, which is a fundamental aspect of the criminal adjudication. And most importantly, of international criminal adjudication. So I would stop there. It was an absolute pleasure to sit with my fellow colleagues. They were simply outstanding. Dr. Subramaniam and Dr. Kadam. I have learned a lot. It was a fantastic experience, and thank you for having me.
Thank you so much, Mr. Aniruddha, sir, for those wise words and for giving us ideas to aspire for. We now welcome our guest of honor, Professor Dr. T.R. Subramaniam. Sir is the Dean of CMR University School of Legal Studies in Bengaluru. Prior to his appointment in CMR University School of Legal Studies, Sir served as a coordinator and research fellow at the Center for Regulatory Studies, Governance and Public Policy in the West Bengal National University of Juridical Science, Kolkata. From 2013 to 2015, Sir served as the Vice Chancellor of Karnataka State Law University, Hubli. Sir has been the Professor of International Law at West Bengal National University of Juridical Sciences. Sir has served as the Vice Chancellor in charge of Bangalore University, Dean and Chairman of the Faculty of Law of Bangalore University, Registrar Evaluation and in charge administration of Bangalore University. At the international level, Sir has served as a legal advisor to the Kingdom of Bahrain for over 7 years. Sir has years of teaching experience at the postgraduate and graduate level and has served as a visiting professor to several prestigious law schools. In 2009, Sir was awarded the Dr. Raj Kumar State Award and for the services rendered in the field of education by Dr. Raj Kumar International Foundation, and was also honored by the Karnataka State Young Advocates Welfare Association. Sir's publications have appeared in leading law journals, including the Indian Journal of International Law, Kare Law Journal, Legal Opus, Mysore University Law Journal, Journal of Indian Legal Thought, and the Indian Social Legal Journal. It is an honor to have you with us today, sir. I now request you to address the gathering.
Is sir having any difficulty? Patricia, we could move to the next.
Sorry, is unmuted only.
Sir, are you able to connect or?
Ma'am, sir's mic is unmuted and he's, I think, trying to switch on his video. Yes, sir's here.
Yeah, good. Thank you.
I'm so sorry, sir, but you're not audible. All right. Should we go ahead then, sir?
We'll make the next speaker.
Thank you so much, sir. I would like to now welcome the chief guest for today's event, Honorable Justice Shri Sandeep Mehta, sir, and we extend our sincere gratitude and thanks to him for taking out time from his extremely busy schedule to be a part of this event and grace us with his presence. Honorable Justice Shri Sandeep Mehta, sir, is currently serving as a judge at the Rajasthan High Court. Justice Mehta's expertise is in criminal and constitutional matters, and sir is practiced at trial courts, high courts, as well as the Supreme Court of India. Justice Mehta has remained counsel for commission in 3 judicial inquiry commissions headed by retired as well as sitting honorable judges of the High Court. From 2004 to 2005, Justice Mehta was appointed as the vice chairman of the Bar Council of Rajasthan, and in 2010, sir was appointed as the chairman of the Bar Council of Rajasthan. Sir is also the chairman of the Rajasthan State Judicial Academy in Jodhpur. It is an honor and privilege to have you with us today, sir, and I now request you to address the august gathering. Sir, you are not unmuted, sir.
Sorry, I'm sorry. Thank you, Nandita. Good evening, everyone. Dr. Sashikala Gurpur, Director, Symbiosis Law School, Pune, and Dean Faculty of Law, Dr. Subramaniam, Dr. Umesh Kadam, Mr. Aniruddha Purohit, respected faculty members, dear students, and the participating teams. It is indeed a great pleasure to be a part of this wonderful event, SICTA, which is being organized by the Symbiosis Law School, Pune, for the last about 6 years. I got a call day before yesterday, rather yesterday only, for addressing the students in the valedictory session. And since I had nothing better to do, I readily agreed. And indeed, I must tell you that the delay facilitated me in being a part of your discussions for about an hour, and it was indeed very interesting. So the time which has been spent was well utilized, I must say. No need to apologize for the delay. It was to my advantage. As Nandita has read out my biodata resume, which is there on the High Court website, I had practiced on the criminal law for almost 25.5 years before my elevation as a judge in the Rajasthan High Court. The topic of the moot is, of course, an international criminal trial, and my brushes with the international sphere has been minimum. Therefore, I would rather say that it was an advantage to me to learn a few nuances about the international criminal law. All the same, I must tell all the students that fundamentally the principles which apply to any criminal trial, wherever it be, in whichever country it be, are based on the general principles of jurisprudence, of which the Indian Evidence Act is a reflection. In my experience, I would say that in the Indian scenario, Indian Evidence Act is the mother of all statutes. And if you, as the students, concentrate a little bit more on understanding the concepts of Indian Evidence Act, it would really be of great advantage when you step out in this competitive field of legal practice. The testament of this statute, being an ultimate law, is the fact that it was codified in the year 1872, and we have not been able to do much with the statute. Whatever changes have been brought around, they are basically cosmetic. Leave aside a few salutary provisions like 113B, etc., or the provisions which have been necessitated with the introduction of the electronic evidence. Therefore, sharing my experience as a criminal lawyer for about 25.5 years, my first friendly advice to all the dear students would be to focus more on the Indian Evidence Act. Now, the achievements of the institution, which Professor Gurpur read out, I am also aware of a few of them. We have a few lawyers who have passed out from the Symbiosis Law School, and I'll be happily sharing the news, the fact that in our 2020 RJS batch, there is an officer by the name of Abhilasha Jeff, who passed out in the year 2020 only. Then we have an officer named Seema Meena, who was probably a faculty member in the institution. So I took that institution, this information from my director just after Dr. Shashikula completed her interview, her speech, and then I took this information, and I'm very happy to share it, that we have a few of your bright students in our judicial fraternity. Now, coming to the topic which the students were deliberating upon, the criminal trial. Before I come to that, and the concepts which are circulating in the legal fields regarding the future course of action of a young student who passes out from the college, what to do, where to go. Mr. Rajput, of course, having a bias towards international law practice, was of the view that that field is more lucrative, more productive. But dear students, I would like to tell you, the true place of a lawyer in this country, in the context of the arrears, in the context of the litigants who are not able to get access to good lawyers and who suffer like anything because of this difficulty, this drawback, is in the trial courts of this country, in the mufassal courts of this country, where the litigants are suffering because competent lawyers are not available. So my sincere suggestion to you is that if you have set your targets on becoming a corporate lawyer or a high court lawyer straight away, please give it a thought that before stepping into that field, spend a few of your first years as a trial court lawyer. And that will keep you abreast of all your colleagues in future. That I can say with certainty. The reason is that you may read all laws thoroughly, sincerely, with good faculty members, but unless you put it in practice, you will not be able to understand the nuances. Why a particular application has to be filed at a particular stage. Say for section 167(2), that is default bail. Many a times the lawyers are arguing bail applications in the High Court before me. And since I have been a trial lawyer, I was using the provision frequently. Now a lawyer says, sir, grant bail to my client. He is in custody for 67 days and charge sheet has not been filed. So I'll tell him, is your counterpart in the trial court incompetent? Why don't you tell him to file an application under section 167(2)? And the High Court lawyer is totally nonplussed. He doesn't know the provision. He has not used it because no such reference is made in the trial court's order. He has no reason to look out for that aspect of the case. So if you work in the trial side, you get to use the entire procedural law, which is the foundation of every case which is instituted in the courts of this country. And without learning the process, the procedural law, a lawyer is incomplete. Now I'll share a few of my experiences as a lawyer, how a lawyer should go about building a client-lawyer relationship, how he should go about preparing a brief once he receives it, and then briefly, what should be the endeavor of a trial lawyer. Now, as you know, that once you step out in the field of practicing law, the client is the one who gives you the bread and butter. So the first and foremost advice to the young budding lawyers would be to respect a client. Never avoid responding to a client's query. And I tell you that if you inculcate this habit in yourself, not only will your client be satisfied, even in future, he will bring you many more briefs. It is a big problem that the lawyers, once they think themselves to be successful, start becoming rude. They try to extort money from the clients. Never do that. You have settled the fees once, you stick to that. Even if the case goes on for 5 years, you can't say that now I have to amend my fee structure because the trial has gone on for very long. No, you will lose your credibility. Respect the client, respond to his queries, and you will be creating not only a client, a friend. I can tell you that a few of my clients in my advocacy days, if they heard that I was in any kind of difficulty, even though their matters were over, they would immediately, on hearing any such news, call me up and tell me in their own rustic language, वकील साहब ये मैंने क्या सुना, आपके क्या तकलीफ हुई है, हम तैयार हैं आपके लिए रात को 12 बजे भी, आप बताइए हमें. इस तरह का relationship, this kind of relationship is developed if you are friendly to the client and if you listen to his voice properly. Now, once a brief has come to you, first of all, you must master the facts. Supposing it is a criminal case, it would be a complaint or an FIR. So read all the facts which are there in the FIR or the complaint. And then the next stage would be to have an interview with the client. After reading the FIR and telling him what the contents are, mostly your clients might be illiterate persons. They must not be very conversant with the legal jargon or the legal language which is mentioned in the FIR or the complaint. So you have to explain it to your client that these are the allegations against you. So that is the second part of the interview, where you tell the client that these are the allegations against you. The client might say, this is entirely false. The FIR says that I beat up X at place Y, whereas I was not even present in the town. So that is the next step, the preparation of the defense. So immediately on receiving the brief and after getting instructions from your client, have an extensive interview and then think out the possible modes of defense. And as far as possible, it should be close to the truth. Because this concept that the lawyers try to create fibs, the lies, while preparing their brief is totally a myth. As a matter of fact, the lawyers try to modulate the truth to suit their client's interest. Nothing beyond that. A lie would not last very long. It has to fail. हिंदी में कहावत है कि काट की हांडी वापस नहीं चढ़ती कभी भी. So a defense which is based on a total falsehood would not survive in the longer run. Another important aspect which I learned from my seniors is that the lawyer should have the courage and the power to refuse a brief. If you are yourself not morally convinced regarding the credentials of your client, then you will not be able to satisfy the judge so as to get him exonerated. Therefore, you have to have the power to refuse a brief. And now what is the advantage? Why I am saying that you should have the power to refuse a brief? The reason is that many a times frivolous litigations are instituted because the lawyer just wants to take the client for a ride. A client comes to him, sir, I want to file X complaint. Now, on the face of it, you know that the complaint has no merit. But still, because the client has come to you, you will go ahead, accept the brief and file the complaint, knowing very well that you are bound to fail. Now, again, the thing is that it may give you an immediate advantage of a brief or the fee, but in long run, you will lose out because of that. In my experience, the clients who came to me and to whom I gave an honest opinion that there is no merit in your case, they were the ones who brought me the maximum of repeat briefs. The reason is that a client who comes down to engage a lawyer in the High Court or even a district court, if the lawyer fairly tells him that he doesn't have any chance to succeed, normally he is prepared to go to another lawyer, and the other lawyer would definitely accept the brief. The client, because you have studied the brief in detail and you know very well the fate thereof, the client would lose, and then he would realize that the lawyer who had given him the honest opinion was the proper person. And then you have created a reputation of being fair in expressing your opinion, irrespective of the fact that you would lose the brief. And if you are able to create such a reputation, then you will be in demand, in high demand, I would say. So you must have that courage of refusing a brief. The next important part which a trial court lawyer must have is the ability to think on feet. So generally what happens is that even when the two students were today questioning the witnesses, I could see that they were looking at their screens and they had prepared certain questionnaire. It's good to be prepared in that way. But many a times what happens is that the client does not give the expected answer. And then your prepared questionnaire fails. What to do then? Now again, you go back to the initial words which I told you, that you must be thoroughly prepared with the facts of the case. Every single detail must be imprinted in your mind. So when the witness says something which is not expected, you should have the ability to react and to put the next question accordingly. Not only that, many a times it happens that you are prepared with, say, 3 pages of questionnaire, which you think that must be put to a witness so that you can elicit the requisite answers or substantiate the defense. But even in your first or second questions, you may achieve something which might be undone with further cross-examination. So you must be conscious of the fact that you have to stop once the achieved result has been received. Thereafter, further questions on that aspect would damage your case. I'll give you an example. I was doing a trial of section 304B, that is dowry death. The prosecution case was primarily based on a dying declaration of the lady, which had been recorded by the magistrate. And I'm sure that you must have read while section 32 of the Evidence Act was being dealt with, that a dying declaration gives one of the strongest pieces of evidence to the prosecution for bringing home the charge. Now, when I did the client interview, my clients told me, sir, there was nothing of the sort. There were no differences between the husband and wife. As a matter of fact, the case has been foisted because the girl's father became annoyed that his daughter had been burned in the matrimonial home, and the statement which has been given by way of the dying declaration is a tutored one. The client interview also revealed that the status of the accused was much better than the status of the victim's family. And the accused had rather transferred sums of money to the victim's father as a loan or those kind of transactions. So the only possible defense in this case was to get the dying declaration declared to be a tutored one. That was the only possible answer. So my associates, as usual, they prepared a 3-page questionnaire for the witness, who was none other than the girl's father, the first informant. But I had that client interview in my mind, and I had faith in my client's version. So I put the first question to the father. Look here, sir, till the incident when your daughter got burned, she was very happy in the matrimonial home. That is correct. But despite that, then I put the questions regarding the monetary transactions, that this such and such amount of money was transferred by the accused to you by way of loan. He had to admit because they were banking transactions. Then I put a question to him. Sir, once you received the news that your daughter had been burned in the matrimonial home, you became very perturbed. That is true. And for a couple of days while your daughter was in the hospital, the accused were also tending to her. That is true. On the third day, they stopped coming to the hospital. So you became annoyed. Sir, that is true. And then you and your daughter, who was still in an injured condition, decided that the accused party had to be taught a lesson. Yes, sir, that is true. And then you decided what the statement should be. That is true. I closed the cross-examination at that point. There were just 7 to 8 questions. My associates were clamoring with me, sir, kya kar rahe ho? Baki ka hamara questionnaire ka kya hoga? I told them, keep quiet. My purpose is served. My only defense was to somehow create a doubt that the dying declaration was a tutored one. And with these questions and the answers which have been elicited, I have virtually attained that purpose. And if I put any more questions, I would be rather giving the witness an opportunity to defeat my defense. So that is how the trial court lawyer has to think on the feet when the cross-examination should be closed, when a particular question should not be put. More important is the question which has to be withheld rather than the question which has to be put. I have seen trial lawyers destroying their clients with excessive cross-examination. So my dear friends, you must learn how to conduct the cross-examination in addition to learning the procedural law. And how do you learn how to cross-examine a witness? The only way is to associate with a good senior and to observe the manner in which he cross-examines the clients. Now, how do you get the opportunity? From my very second year in the law course, of course, when I was doing my law in the year 1983, it was a 3-year law degree course. Only one college was offering the 5-year law degree. So my maternal grandfather, as Mr. Sampath was referring to his maternal grandfather, I would also take the opportunity to do the same. He was one of the leading lawyers on the criminal side in the state of Rajasthan. And so right from my second year as a law student, I would go to the court and sit on the last benches, observe him doing cross-examination, conducting cross-examination from witnesses. And that is how you learn. In Pune, you have a great trial lawyer. I have had the opportunity of hearing him argue matters in Rajasthan. He is none other than Mr. Shrikant Shivde. So you must take the opportunity of going to the courts once the pandemic is past and the courts are functioning regularly. I must request Dr. Shashikala to send all the students to sit in the court where Mr. Shivde is conducting the cross-examination. That is the way how you learn the art of cross-examination. It of course takes time because no one is perfect at that is for sure. But with experience, with observing the actions of the seniors, you would learn. So I've taken sufficient time. It has been a wonderful opportunity. I thank the faculty members, the students of the Symbiosis Law School for having given me this opportunity to interact with them and to relive some of my student days when I too was participating in a few of the moot courts, which though of course at that time were very rare. They were a rarity in my times, but I did participate in a couple. So I thank you again for having given me this opportunity. It was indeed a learning experience for me to have heard the various aspects of the criminal trial. The subject, the topic which you chose is really close to my heart. The human rights violations. It was the things which are going on in that country. They are really terrible. We can't associate with them. We can't approve them. Come what may, even if the accused persons are suspected to be drug peddlers, but they can't be killed in cold blood. I would like to share one more experience of a similar nature. Honorable Justice T.S. Thakur, he was here in Jodhpur for delivering a lecture, and he shared a similar experience which takes place in China. It stated that when they were visiting the Chinese courts, they found that a member of the Communist Party would be a part of the quorum, and the decisions which were taken were ultimately influenced by them. To us in a country, democratic setup like India, where the courts are open, this is absolutely unacceptable. So I would request all the students to be champions of human rights and to ensure that human right of no individual in this country is violated because the lawyer was incompetent. Thank you. Have a good day.
Thank you so much, Justice Mehta, for your insightful address and for elucidating the value of understanding core legal concepts in our journey to becoming good lawyers. As we have come to the conclusion of this enthralling competition, we arrive at its most anticipated segment, the declaration of results. I would now like to invite Vibhor and Sisira to announce the winners.
Am I clearly audible and visible?
Yes, Vibhor, you are.
All right. Thank you so much. Greetings, everyone. In such grim times, amidst this second wave of the lethal COVID-19 pandemic, we decided to organize the 6th edition of SICTA 2021. And that also happens to be the first virtual edition of the same. In such sorrowful times, it became all the more difficult for all of us to organize SICTA 2021. However, we made this a reality, or if I may call it so, a virtual reality. However, there has throughout been an incredible support from our college authorities, our mentors, our IT department especially over the last few days, and even our extremely benevolent sponsors, Advocate Sampath sir and Advocate Manan Sanghai sir. So on behalf of the organizing committee, I'd like to thank each and every one of you who has helped us in making SICTA 2021 a reality. Having said that, I would like to take the opportunity to move ahead with the much awaited announcement of awards. The first award that is the second best witness award goes to Miss Sabreen Hussain. Moving on to the best witness award goes to Mr. Shrey Mahajan. The next award that also happens to be one of our sponsored awards, sponsored by our very own Advocate Sampath Bulisu sir, that is the Shri P.V. Ramanaya Memorial Best Prosecutor Award. It goes to Mr. Vikram Chandra Shekhar, Christ University, Bangalore. Moving ahead with the second best memorial award, it goes to NLU Jodhpur. Moving ahead with the Best Memorial Award, it goes to Rajiv Gandhi National University of Law, Punjab. Moving ahead with our other two sponsored awards, sponsored by our very own Advocate Manan Sanghai sir, the late Ishwari Prasad Bagaria Best Defense Advocate Award, both India and international. India round goes to Ms. Mansi Reddy, Jindal Global University. The next award the late Ishwari Prasad Bajaria Best Defense Advocate International Award goes to Mr. Yagadi Acharya, Kathmandu University School of Law, Nepal. I'd now like to call upon Sisra Reddy to announce the remaining awards.
Hi, Sisra could not join. She has some technical issues, so I'll be announcing the next 6 awards. The Best Student Advocate of Final Award goes to Mr. Vamik Wasim Nargal, representing his college, Rajiv Gandhi National University of Law, Punjab. The next award is the second Best Student Advocate Award. The second Best Student Advocate Award also goes to Mr. Vamik Wasim Nargal, representing his college, Rajiv Gandhi National University of Law, Punjab. The Best Student Award, which is our next award in the student category, goes to Miss Himisha Diwar, representing General Gobel Law School, Haryana. Now coming to the top 3 awards, the second runners-up team, after rigorous 4 hours of competition in the final rounds, the team members and the team is National University of Study and Research in Law, Ranchi. Going to the first runners-up. The first runners-up are Tamil Nadu National Law University and the winners of 6th edition of Symbiosis Law School Pune International Criminal Trial Advocacy are Rajiv Gandhi National University of Law. We congratulate all the participants. We congratulate every participating team. Thank you, both.
Thank you, Rebecca and Vibhor, and congratulations to all of the winners. With that, we come to the conclusion of SICTA 2021, and I request our Deputy Director, Professor Kshitij Naikade sir, to kindly deliver the vote of thanks.
Yes, thank you very much. Good evening, everyone. Congratulations to all the winners. Ideally, in normal circumstances, this would have followed by pictures with the huge trophies that we actually give for the winners of SICTA, and that's actually a moment to kind of watch. But unfortunately, because of the trying times, we have to do it online. Good evening, one and all. As we come to the end of the 6th edition of our flagship Symbiosis Law School Pune International Criminal Trial Advocacy Competition, it is indeed a matter of great honor and pride for me to present and propose this special vote of thanks. This edition is obviously special for more reasons than one, not just for me, but for our entire team, led ably by Professor Virendra Thakur. Since it is the first edition of the competition which has been virtually organized amidst this pandemic and the challenges in front of us were Herculean to say the least. There is a long list of people who I would like to thank first off. Please be patient with me. However, this event cannot end without showing our gratitude towards a host of people who have made this event a success. I feel like that presenter who comes after the presentation ceremony of a cricket match and discusses the game, who nobody is interested in listening to because the match is already over. But it is very important to note that we cannot actually conclude any event without thanking the people who have made this particular event a huge success. I must first of all congratulate the participants again who participated in this event in spite of the technological challenges and gave their best amidst this gloom in the country. I want to thank Honorable Chancellor Sir S.B. Muzumdar Sir, Rajni Gupte Ma'am, and Pro VC with the Erodekar Ma'am for always supporting SLS Pune in our academic endeavors over the years. I want to thank our director, Dr. Shashikala Gurpur Ma'am, who has stood like a rock behind us, especially in taking important crucial decisions over the years, and even in the last 3-4 days when we have disturbed her at odd hours for permissions and approvals. And she has backed us to perform to the best of her abilities. Wherever there has been a cloud of uncertainty hovering over us, she has cleared them off with her assured and steadfast decision making. I want to thank our generous alumni sponsors, without whom this event would not have been possible. The ever dependable Mr. Sampath Bulusu sir. I would like to actually call him the Rahul Dravid of our Symbiosis fraternity because he's like the wall. He is ever Mr. Dependable. Manan Sanghe sir, we value your support in our endeavors, especially amidst this pandemic. I would like to thank the organizations which have supported us, Knowledge Partners, SSC Online, EBC Reader, and Just our associate sponsor. I want to thank Justice Chalmeshwar sir, retired Judge, Supreme Court of India, who took out time from his busy schedule to speak with such candid during our inaugural ceremony. I want to thank the judges from the preliminary as well as the semi-final rounds, mostly our alumni, Advocate Samad Khanna, my dear friend Advocate Nitin Kumar, and Advocate Karan Kamath, who have had the pleasure of teaching till very recently. I'd like to further thank our Chief Guest, Honorable Lordship Justice Sandeep Mehta Sir, Judge High Court of Rajasthan, for being patient in accommodating our delayed event and delivering such a brilliant address, which had multiple pearls of wisdom for one and all. I was very impressed by the fact that instead of recounting his achievements as a judge, he kind of went to the grassroots and spoke as a lawyer, thus showing the kind of humility for one and all. I want to also thank our other guests of honor, Mr. Anirudh Rajput sir, Dr. Umesh Kadam sir, who unfortunately couldn't join, but who has been present for SICTA since morning today, and Professor Dr. T. S. Subramanya, sir. We would have loved to have them on campus like every year, and I hope that next year they would be in campus and I would be picking their brains like how I do every year. Finally, I would like to thank the faculty team of the Student Bar Association led by Professor Virendra Singh Thakur, Professor Varun, Professor Richa, and the student heads led by convener Ms. Susira Reddy, our co-convener Ms. Rebecca Jaiswal, and the entire team who have literally burnt the proverbial midnight oil to make this event successful. As ma'am mentioned in her inaugural, as ma'am mentioned in her speech, some of the events actually went beyond midnight, and even the planning and preparation for SICTA went well beyond midnight on most days. And the students, and it is something that I want to kind of address over here, used to be present for the lectures the next morning, ensuring kind of participation in these activities as well as not giving up on their academic rigor. As mentioned by ma'ams, it is actually an event which is one of our flagship events, but this kind of stands strong on the shoulders of our student heads. Finally, I would like to thank the IT team, specifically led by Amit sir, Balesh sir, Zia sir, for being an integral part of the success of this virtual SICTA, which has been conducted without any glitches, anticipating the problems and helping us kind of understand this entire virtual platform thing and understanding this virtual event in a much more simplified manner. Thank you one and all. It's pretty late at night. I hope to see all of you, the participants, next year physically in campus, where we will go back to our the kind of energy that we actually see in that particular room in college, which drives this flagship event of Symbiosis Law School Pune. Thank you very much. Good night.
Thank you so
Thank
much.
you.